You are now entering a dangerous liberty zone where God-given natural rights are held sacred and exercised. This is your warning. Tyranny, fascism, and censorship will not be tolerated. Ideas will be exchanged freely. Rigorous debate and open discourse is encouraged. If you are weak and your beliefs are fragile, you should leave now. Prepare yourself. We are now live on the Dangerous Liberty Podcast. All right, folks. Happy Tuesday morning, everyone. And man, we are one day closer. We are one day closer for justice for Charlie. And that's what this is all about. Yesterday was a long day, but it was worth it. And I appreciate everybody that was tuned in yesterday that kept us company. And hopefully we can do the same thing for you, because I do think it's important that every single person out there watches this, knows the facts. That's why these idiotic conspiracies thrive, is just because of ignorance. And the more information that is coming out, and the more people that watch this and don't get this second and third hand from people that are trying to manipulate you, the better off that we are. And that's what this is all about. So number one, I want to tell you guys, I couldn't have made it through yesterday without you. And hopefully we helped you get through most of yesterday as well, and brought a little levity, brought a little insights. We're going to have several guests on today. I was just talking to Josh Carr. We'll probably bring him on just for a few minutes. We'll see how much time he can give us. He was there yesterday. He was outside of the courtroom. So anyways, we'll see how all that goes. And I did throw a guest link down in the chat. Number one, Rage Bronson. You're always welcome to come on, buddy. We always like to hear your insight. I was just seeing your comment, Lynn. You're welcome to come on. Just doing audio only. Works just like a Zoom call. Click the link, jump on, just click your audio source, and you'll be good to go. So I would like to hear from you guys, and I want to extend that opportunity to, kind of get your insight, your thoughts. If anything changed for you, I don't think nothing yesterday was super, super groundbreaking. I think a lot of it was procedural. Hopefully today will be a little bit more, a little bit faster paced, to be sure. I also will be reaching out to our good friend. He was in the comments yesterday, Judge Bernie. We'll see if we can get him on. Like I said, I know Judge Bernie. He's a good friend of mine. He's a great client of mine. I always get a little, I don't want to, mix in the social media stuff, and especially when you're talking about judges and things like that. I don't want clients to feel like they're obligated to come on my show. I want them to stay good clients, quite frankly. What else is going on out there, folks? I want to say hi to everybody over in the chat. We got Yuck Foo Tube, I like that thing. Devil's Advocate, Velvet Lace, Natalie Herman, SK Double Dub. SK, we always love you on. We love having you on, SK. So quit saying that nonsense. Deed Rat, Natalie Herman. We've got her obscure moderator. All the moderators. Thank you guys. You guys always show up, even when I throw streams together. And you're not expecting I still see you guys in the chat working diligently, and we appreciate you so much. Obscure moderator. I still got your birthday present coming. I promise you. Who else is over there? Mr. B5. And many, many more. If you haven't said hello yet, make sure you say CJ Carenti in the house. Thank you so much. CJ is such a big supporter of this channel and everything that we do in many, many different ways. So again, I'll do it again. Throwing another guest link over in the chat. Tonight at 8 p.m. Eastern time, we're going to have Andrew Wilson on. We'll be talking about the facts of the case. We'll be talking about what's been going on in the trial. Of course, we'll have 2 days behind us at that point. I want to get his perspective of what's happening, maybe get and interview him a little bit. Not just, we always see the Andrew that debates. I want to know what makes Andrew tick, even when it comes to this, and what is going on with this, why he wanted to get involved with TPUSA. I had a conversation with him on the phone. We talked about that a little bit. So there is that. So anyways, we got a guest link over in the chat. If you guys want to jump on and just talk for a minute, I want to hear your thoughts on what's been going on the last couple of days. Look, yesterday, all day, Candace Owens was just crashing out. Look, this is the antidote to her. And she knows it. She knows it. Her grift is coming to an end. I don't doubt that she can squeeze several more months out of this. That's not what I'm saying. It's not going to happen overnight. But the more truth that gets out there, and the more of her BS and different theories from the exploding mic, French Foreign Legion, and everything else in between, It's not looking good for her. It really isn't. And that's a good thing because she is a destructive force on this planet. At some point, I may have to restart my computer. One of the things I love after being a Windows guy for so long and being resistant to moving over to the Apple products is I love the fact that I can share stuff in between my Mac Studio over there and my phone. For whatever reason, links aren't carrying over today, so I may have to switch that over. But anyways, Obscure says he's running on 45 minutes of sleep. It's Bronson's fault. Absolutely. VFT is a fake ballistics expert. You're 100% right. He doesn't even know if you can change out a wooden stock on a gun. I mean, come on, dude. He's gotten so many things wrong. And not only that, he's just, unfortunately, I have to say this, he's a liar. He has lied about multiple things when it comes to this case. And he is unfortunately no better than the Ian Carrolls, Candace Owens, and everybody else. That's his crowd. That's who he wants to hang out with. Jesse on Fire and all these other people that are nothing more than grifters, pushing freaking pod slop and making everybody else look bad and pushing these crazy conspiracy theories. He is, as far as I can tell, his politics are far left. He's extremely anti-Trump, and he's willing to lie for political gain at a minimum. And then on top of that, what he really cares about is his viewers, his channels, and everything else. So I don't even think truth is in the calculus of all that. And that's a real issue. I do want to remind everybody, let me see if I actually have this. If I have this video saved here. I'm pretty sure I do. And it is worth posting again. Yes, this one right here. Oh, I did photo. There was a time not too long ago where Candace actually told the truth. She actually told the truth. She was 100% sure about this. She had multiple sources that confirmed this, and I want to share this with you.
Did stop the bullet without question. Okay. And this is going to dispel a lot of theories that are out there. And I'm telling you this 100%. Charlie Kirk was shot from the front, and the bullet did not exit. And at least a fragment of the bullet was recovered from his neck. And I'm going to tell you exactly where it was recovered from. I have fact-checked this information from multiple sources now. I've actually been sitting on this for a little bit over a week. Right around here. So think about almost in line with your shoulder blade right in the center. Now, why is that helpful? Because it gives us a bullet trajectory, okay? We went in here where you saw that, and it was stopped, and a fragment was pulled.
So there we go. She was 100%. She wanted to dispel the myths out there. 100% sure that a bullet is what hit Charlie Kirk. She had multiple sources confirming that. And now we've changed. And that was, I believe that was the day that she returned from the Erica Kirk meeting. And she came out and she said a lot of truth. And unfortunately, her viewers turned on her. And then by the next day, she did a 180-degree turn. And I think at that point, she was trying to get off the conspiracy whack job bandwagon. But her viewers weren't having it. They weren't having it. So that's where we're at with that. Ashley, thanks for doing these lives and countering the BS. Well, thank you. Thank you for supporting us. We appreciate that. Folks, this is one of the things I keep saying. The reason that all of these people exist that are out there lying to everybody is because they have a lot of support. I do think a lot of that support is inorganic, but there's a lot of organic support. These people are getting, number one, they're getting the views. Their fans and their viewers and their subscribers and followers are rabid supporters and radical supporters. And we need to get people that support channels like ours and many others out there that are telling the truth. We need to get the same level of support. It is crazy to watch Candace Owens, Baron Coleman, and just the utter drivel that they sell people, and they are just sending them super chats or super chats or super chat. Like, this is not about getting rich. I don't care if no one ever sent me $1 or whatever else, but I will say, like, we need support too, and it's just a fact. So one of the best things you can do right now to support us is make sure you like, subscribe, comment. We always appreciate that. But the other thing you can do is share. And then down in the description below, if you'd like to become a member and support this channel, a few dollars a month. Like, I think the lowest tier I have is $7.99. So for $8 a month for 2 cups of coffee that you're going to buy at Starbucks, you can support this channel. You'll never notice it, and it does go a long way. But what I want you to do right now, if you haven't done so already, make sure that you share this content, whether you're watching on X, whatever it is. Share this content so we can get the truth out there. I did want to do a quick review of all of the current evidence that we have against Tyler Robinson. And I'm going to throw this up here on Grok real quick. Evidence that, and I want to remind everybody, and then we can go through later on, if we have time, we'll go through additional charging documents and things like that. I mean, the evidence for Tyler Robinson being the killer, I mean, just on the confessions alone, is so overwhelming that it's not funny. I'm going to share this screen real quick. We'll go right there, and we'll get rid of this comment. Thank you again, Ashley. We appreciate you and everybody else. I haven't looked at the other super chats. I will get to those in just a moment, I promise. But we will remove that, add this to the screen, and let's go over the list that we have. And this is just what's been revealed so far, folks. Once we get to, we'll probably get additional evidence in the preliminary hearings over the next couple of days that we haven't seen yet. But you better believe once we get to the actual trial, the amount of video evidence that we're going to see, the amount of additional evidence that we see that hasn't even, it might have been referenced, but again, like for instance, they reference terabytes of video data. What we haven't seen are the high quality images that make it very clear that Tyler Robinson was the shooter. You better believe they have the picture of him running out to the point to where he took the shot, and they have him down on the prone at the moment that the shot was taken. But anyways, let's go through this evidence real quick, and then we got a couple more minutes before we jump on. And again, I threw a guest link down in the chat. If you guys would like to come on, even if it's audio only, you're welcome to. I would like to hear from you and what you think is going on and kind of your take overall. But Tyler James Robinson, age 22, faces charges including aggravated murder, capital felony, death penalty, all of those things. DNA on the murder weapon, a bolt-action 30-06 Model 98 rifle with scope was recovered in the wooded area near the scene. We showed that yesterday. If you all haven't seen the exact area, I showed a video yesterday where I was there, and I showed exactly where that rifle was hidden. I'll happily show that video again today. I want to make sure that you guys know exactly what we're discussing and you have a good lay of the land. Engraved shell casing, sniper position and surveillance, marks in the gravel of the rooftop, the direct line of sight of Kirk were consistent with the shooter line and weight. Surveillance video captured a suspect matching Robinson's description and gait. Unusual walk consistent with hiding a rifle in his pants, fleeing the roof area. Well, that's not when he was. Anyways, additional forensic, a screwdriver possibly used on the roof, and other items also linked via DNA in some reports. No shell casings on the roof, consistent with a bolt-action rifle. Text messages and note to roommate. Other alleged admissions. Well, this is really important here because I read through at the end yesterday, I read through the search warrant to Apple. We looked at some of the additional text messages that they shared with one another. Drop what you're doing and look under my keyboard. I had the opportunity to take out Charlie Kirk, and I'm going to take it. In the follow-on text, he said, I'm sorry. When asked if he did it, I had and explained the motive. I had enough of his hatred. Some hate can't be negotiated out. All of that is in multiple charging documents and the search warrants. Said he planned it for a bit over a week. Reference hiding, recovering his grandfather's rifle, wrapped in a towel. Other alleged admissions report mentioned conversations with family friends, including Discord and implied statements leading to his surrender. His mother noted his shift toward left-leaning politics and pro-LGBTQ views. Manhunt and surrender. It wasn't actually 33 hours, but whatever. Robinson surrendered at the Washington County Sheriff's Office. Cover-up attempts allegedly he hid, disposed of the rifle and clothing worn during the shooting. Obstruction charges. Premeditation indicators. Planning, timeline, choice of high-profile target. Motive, context, alleged hatred of Kirk's views. Rifle identified as one Robinson possessed. The evidence has been described by prosecutors and analysts as strong and multifaceted. What's not discussed in here is, again, all of the cell phone data that we have, including location data. We have engraved shell casings. Not only were the shell casings that were found with the rifle engraved, he actually had a shell casing at his house that was engraved and a tool to which he engraved it with. So all this data that's linked. He had targets that he had already shot. He had been planning this. He made sure that his rifle was zeroed. He'd been out training essentially for all this stuff. So that's kind of where we're at with all this. And I'll do what I can to take as many questions as possible before we get started. But, the evidence really is overwhelming. Gary, is it true that TR's lover is getting spousal privilege? That's fake, correct? Yes, he's not getting spousal privileges whatsoever. I haven't heard anything like that. He does apparently have some level of immunity that has been given to him to basically be a witness against Tyler, right? Provide testimony against Tyler Robinson. That's not unusual either. I don't know what other information they found as far as how much he was complicit in it. At a minimum, what we know is that he did destroy evidence. So they would at least be able to charge him with obstruction, probably a lot more crimes, aiding and abetting, all of these things. So, but he has been cooperative with investigators since the very beginning. That's what I will say. So that's where we're at with that. And it doesn't appear that he's going to testify in person. I have heard that there will be video testimony from him that will be played to the court. I am really interested to hear what he has to say with that and what will come out of that. They're already saying on the other side, well, he was given immunity, so they want to discount whatever testimony that he's going to provide altogether. There's no reason for that. There's no evidence that he is being manipulated to say something other than, hey, you know what? If you cooperate with us, and since Tyler Robinson is the actual murderer, we want to make sure that we get charges against him. If you testify, we will give you immunity and we will not charge you with these crimes of which we could charge you with. So that's pretty standard when it comes to any sort of, especially a big case like this. Yeah, look, she is tweeting a bunch of she's tweeting a bunch of alleged messages between her and Charlie. Those messages and some of the messages that I've seen in the past, they don't look real. That's just my opinion. Doesn't mean they're not. Just they don't look real. So you can assess that on your own. What I can tell you, the first time that I ever talked to Andrew Colvett was probably back in December or whatever else. He's put out this information. So I think it's okay to share it at this point. I had a long talk with him about Candace, and he was like, Gary, let me tell you something. She has been a thorn in our side ever since she left. Charlie was concerned that she was going to go on a rampage against TPUSA and cause a lot of problems. So he would not take her phone calls, and she was handled by Andrew Colvett and other people at TPUSA. That's a fact. Well, I'll say that's what he stated. You can believe that. You can believe whatever you want. I can't confirm or deny that. But what I can tell you is that I have had several other people that have worked with her reach out to me. Graham Allen said the same thing. He's like, Gary, I have known Candace for a really long time. She sits there and talks about me now like she doesn't know me, like we didn't have this personal relationship. But let me tell you something. She has always been an agent of chaos. She is someone that kind of will destroy everything around her if she doesn't get her way. And that's what we see. And I think you can just watch her operate. And if you listen to her with any objective discernment whatsoever, You can clearly see that's the type of person that she is. So you can take those messages for whatever they are. Andrew Colvett has done a great job combating this. I'm glad to see that TPUSA is kind of tired of her crap. I wish they would have started this a lot sooner. I'm glad to see that someone like Andrew Wilson is now picking up this fight. He's very aggressive. He knows how to do these things very well. He's the right person for the job. I know there's a lot of people out there that are concerned about his influence in TPUSA. I will talk about that tonight with him and address those things directly. Based on the conversation that I had with him, I'll say this. I don't get the impression that like he's wanting to infiltrate TPUSA. And by the way, I had a talk with Rachel Wilson as well the other night on the space. I don't get the impression that they want to like infiltrate TPUSA. The biggest thing with Andrew, and I'll set that aside to some of the comments that Rachel has made. Andrew just straight up sees this as a fight worth fighting. And I think it's just a matter of like, he's like, hey, this is evil. I don't necessarily agree everything with TPUSA. He's criticized Erica. He's criticized TPUSA. He's criticized Charlie in the past. He just thinks this is a bridge too far. And he knows that what they're putting out are just lies. And he's kind of like me. It's like, you know what? I just can't stand by and let this continue without some sort of pushback. That's the impression that I get from him. And I think he sees it as a fun challenge, as weird as that might be for some people, but that's just his personality, because he knows he can easily defeat them just because they're lying. And he's very good at that. That's what he does. Much better at that than me. So, you know, we're here to get out the truth and do what we can. And, you know, this is a whole new battlefield, and learning your operational environment, it takes time. And I've come to understand these people more. I've come to understand how to fight these people more effectively. We're getting better at it, but that's something that Andrew Wilson has been doing a really long time. And to some degree, I definitely came in this with a level of naivete. Well, like I didn't know. I didn't know how these people operate. You know, I was like, hey, look, I can prove these people are lying. What I didn't expect for them to be is quite as petty as they are and quite as malicious as they are. Doesn't change anything. I also didn't expect them to just create false narratives about me or other people. And they put that out and people just believe it, even though it's completely fake, completely false, and it's just a character smear, and there's no truth behind it. So again, we are learning our operational environment. We're going to continue to get better at this stuff, because this is what matters. This is the fight that we're in, and it's super important. It really is important. Let me see. We got a couple other super chats here. Whole Truth. I just sent out a I'm going to send out another guest link. Gil, jump in here whenever you'd like. I'll be available here and there throughout the day if you'll have me, of course. Where I got music coming from? Oh, I see. Suddenly I heard music. I know you probably guys didn't hear it, but anyways, I'll be available here and there throughout the day if you'll have me. I want to point out significant evidence was revealed in the prelim yesterday. Would love to have you on. Would love your legal analysis for sure. Back listening today at work. I'm in for the long haul with it. We appreciate you, American Patriot, and everybody else is doing it as well. Look, again, I know Andrea Burkhart is going to be streaming this as well. She has amazing legal analysis as well. I would definitely be watching her and supporting her. But today it is 2026, folks. You got multiple devices. Stream me, stream her. I support the work that she does. We're going to have Gil on to provide some legal analysis as well. I'm going to have Judge Bernie on, especially if I can get my stupid cross-swapping of sharing and of information between my devices. I don't know. We'll see how that all turns out. Let me see if I can go. Matter of fact, here's what I'll do. Real quick, like even my messages, for whatever reason, aren't coming up. Let me see. Boom, boom, boom. Let's see if that works. All right. Does look like we'll be going live in just a few moments. So there is that. Yeah, look, I got to be honest with you, Angela, and I don't have any evidence of this. And unlike Candace, I'm not going to pretend that my opinion is fact. Those messages look fake as hell. Maybe we'll go through some of those today. Dalton says, we've addressed this a bunch, Dalton. Them doing a remodel on the scene quickly is weird after days of forensic investigations. What more could you find? Kirk was shot there, so there's going to be blood, of course, but what else? Look, it is standard procedure for insurance companies, especially if they're trying to not get sued. I've talked about this. It is standard procedure for insurance companies to mitigate a scene once that's taken place. Look, they were trying to get the FBI, SBI, all the forensics teams, hundreds of people is what I was told. I don't know if that's hyperbole, but I was told hundreds of people from multiple agencies where they're processing the forensics of that scene over 3 days, 24/7, the whole time. And then here they come like Saturday, Sunday, and they did tear up the grass. They had to remove a lot of sod. And I've actually talked to the guy that was on that job, by the way. We're trying to get him to come in to talk a little bit more about that. So anyways, they had to remove the sod, and then they wanted to make the area less traumatic. And I'm sure there's some extent of mitigating people coming and pretending they're, investigators with metal detectors and all those things. I say that. I don't even know if that was part of their calculus, but this is very common. Like, for instance, if there was a murder in your home, and there's blood all over the place, aren't you going to fix that? Aren't you going to remediate that and make sure that is less traumatic, that you don't have to look at it every single day? And they have students. It's an open public campus. It just makes sense to me. It's not some crazy thing where, they're trying to hide evidence. You can paint it that way, but the more reasonable and the more likely scenario is something very different. There was no evidence around there. Look, Charlie Kirk was shot. They're trying to tie that in to say, there was explosives. They would be able to detect the explosives all over the place. And it's just not true. It's just dumb. It really is. And it makes perfect sense. A college campus where a lot of the students were on campus that day, and you want them to have to relive that trauma by looking at, the grass torn up, whatever is going on. I think it is very reasonable. If you want to turn it into a conspiracy, that is on you and everybody else. The lie, though, that's been put out was they did it the next day. That's one of the things that's been said since day one. The very next day they came in and they did all. No, they didn't. No, they didn't. It was not. They were they destroyed a crime scene. It wasn't a crime scene. You know when it stops being a crime scene? Is when the investigators say, hey, it's no longer a crime scene. Here you go, UVU. Here's your property back. Do what you want with it. And then UVU's left with a mess where they've had to tear up all kinds of soil to get rid of the biologicals and all the blood. And they're like, you know what? Let's just do a remodel. Let's try to make this look nice so that it's less traumatic for the students and they don't have to relive this. I mean, that's just how these things work. You want to turn it into something else, you're welcome to. All right. I think they're going to be going live very soon. So I'm going to go ahead and pull this up. We are rocking it with KSL again. They seem to have the best audio and video for the most part. And we'll just keep that on the tab right there. I am curious to see what they're saying over in the chat. I guess the chat's not even going. What's going on here? Let me just refresh this, make sure we're not missing anything. Interesting. Yesterday, the chat was pretty crazy. Like, I think a lot of people did have their eyes open. I think they're realizing that they've been lied to. We'll turn down the volume on that. You guys help me out. Let me know. I know we had some volume issues yesterday, and part of it is just the court. the audio in these courtrooms are always jacked up. You know, we have one person talking too loud, their mic's too high, the judge, you can barely hear them. So if we have any audio issues, you guys let me know down in the chat as well. I had to buy another super chat to say, I love when the trolls call you Ginger Boy. I'm creating a video game called Ginger Boy. You'll be a badass. Yeah, Ginger Boy. I love that all these keyboard warriors talk so much trash that they would never say to my face in person. That's what I love. You guys are so tough, so brave behind your keyboard with your anonymous accounts. I think that's a good rule. Like, don't say anything online that you wouldn't say to somebody's face. I live by that. Hilarious and sad, too. They buy their lives without question, although they're likely the same type of person that distrusts legacy media. That is the crazy thing. It's like, you shouldn't trust legacy media. We shouldn't trust the government. You should always be skeptical of all these people and all these things. But you sure as hell shouldn't trust podcasters that are incentivized left and right to push this BS. Like, without a doubt, just objectively speaking, we've gotten more lies, confirmed lies that have been pushed by all of these podcasters than we ever did from the government during this particular instance. And if you're a logical, sane, reasonable person, that's what you do. Yeah, the government lies. Sometimes they tell the truth. Guess what? Podcasters lie. Sometimes they tell the truth, or there's other people out there that do tell the truth. And there's a big difference between the Trump administration and the Biden administration. It's just a fact. It wasn't the Trump administration that weaponized the DOJ. It wasn't the Trump administration that threw people in jail for January 6th with like zero probable cause, just trumped up charges. It wasn't the Trump administration that charged Biden with 34 felonies that didn't even make sense. So, you know, that's kind of where we're at with this. And it looks like we are live. So let's go ahead and tune in and see what's going on with this.
For the record, the court also recognizes the presence of victim representative, Ms. Erica Kirk. Good morning. First, with respect to courtroom protocol to maintain security and decorum, any individual who exits the courtroom during proceedings will not be permitted to re-enter until recess. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic.
All right, so they're going through procedures and protocols. Did you notice that Candy and her cult spent the day trying to convince everyone she and Charlie were friends, distracting from the damning evidence? Yeah, they are distracting left and right. Zionist is a compliment, not an insult. It's biblical.
Just let me know when
it's biblical, right?
to be working.
I am going to share. Nah, I won't. Yeah, you know what? I am. I'm going to, because I think it's funny. We need to start the day with a little bit of humor, I think.
If you have any,
I will share this with you. I made this yesterday. I thought it was hilarious, and I think you will too. Let me pause this.
Don't hesitate.
Share this tab. All right. Candy cult crash out. As the Tyler Robinson preliminary hearing unfolds and the evidence they claimed didn't exist is revealed, Candace Owens and her cult will become more desperate and unhinged, flailing like petulant, deluded children mid-tantrum. And I thought this was funny.
No, Tyler wasn't even on campus. Erica did it. She wore sparkly pants. That proves everything. No, Tyler wasn't even on campus.
That's Candace Owens right there, in a nutshell. In a nutshell. All right, back to the hearing. Absolutely agreed, Omar. It's important that we question everything. It's important to be skeptical of the government. But, you know, we have a bunch of people stuck in this default thinking. They will not accept anything the government says, no matter how much evidence is behind it, and they will automatically accept this pod slop. It doesn't matter how fantastical, ridiculous, and crazy it is. You know that Gary fries his best tries his best to stick to the truth. When he reads things, then he strongly disagrees with out loud on his channel. Jesus is only a dead false prophet. Deuteronomy 4:2. Yeah, he's not dead or a false prophet. Rose again on the third day, bud. This is why Zionism is not allowed in our government. First Amendment, the Establishment Clause, prohibits the government from establishing official national religion or unfairly favoring one religion over another. Sure. There's elements of that I disagree with, but generally speaking.
Can you send them a link to the where this is being streamed so they have something to look at? I see. All right. All right, let's go ahead and continue. And let me repeat it just because the audio may have cut out. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices and care to avoid the inadvertent capture of privileged or private discussions by recording equipment or by those present in the courtroom. Second, the court will address the camera operator and still photographer, and I will invite you to come forward. All right, the purpose of this is to ensure clarity regarding the expectations governing today's proceedings. Could you both state your name for the record?
Yes, Trent Nelson with the Salt Lake Tribune as the pool still photographer.
John Wilson from KSL Television, video photographer.
Good morning to you both. Have you reviewed the court's standing decorum order?
Yes, Your Honor.
Yes.
Do you understand the requirements set forth in that order as they apply to your activities today?
Yes.
Yes.
Do you require additional time to review the order or to adjust equipment to ensure compliance?
No.
Do you anticipate any difficulty complying with the order or with the court's instructions?
No.
All right. Well, thank you. I appreciate your
Thank you.
cooperation today. As we begin this morning, the court wishes to acknowledge the importance of the safety, dignity, and well-being of all those who are present or who may be present during these proceedings, including the parties, counsel, witnesses, court staff, and members of the public. The court is also mindful of its solemn obligation to protect and uphold the constitutional rights of both Mr. Robinson and Ms. Kirk.
Was he, Alicia? Was he set up?
In furtherance of those important interests, all persons attending these proceedings are reminded that portable electronic devices are not permitted in the courtroom or on the fourth floor. The court also expects every person in attendance will be treated with the dignity and respect to which they are entitled. Consistent with the court's standing decorum order, all spectators shall remain quiet, civil, and orderly during all times. Spectators shall not engage in conduct that is distracting, disruptive, provocative, disrespectful, uncivil.
These are all the same directives he gave out yesterday.
Spectators
Got
shall
Yasmin
not
in the
make idle
house.
comments
Good to have you
of any
back.
kind, shall
Matt
not shake or
Duncan.
nod their heads,
My
shall
boy
not make
Matt,
gestures
somebody
or
I know
other visible
personally.
reactions during today's hearing.
Good friend.
Spectators shall also not
Good
wear or
customer.
display
I'll leave it
pins,
at that.
buttons, signs, clothing, photographs, or other items expressing support.
Mackenzie, I've been sub for months and
or
renewed my
opposing to any
membership, and I
person
couldn't comment
connected
for a
with
while.
this
Folks, all
case,
kinds of weird
or
things happen
expressing
to
any
us
position
on
concerning the
YouTube.
status of this case as a capital offense. The court appreciates the cooperation of all present.
We were
in maintaining a
leftists
courtroom environment that is safe,
Or pushed
respectful,
narratives that were
orderly, and
destructive
faithful to the
to
rights and
the
dignity
conservative
of
right,
every
we would
person
be
involved.
in the
Turning now
millions and
to
millions of
counsel.
views all the time.
Before we begin,
just
I
a
wish
fact.
to acknowledge the professionalism, civility,
Andrew
and
Wilson's good
competence
debater.
demonstrated by counsel for
Let me
both
turn
the
this down
defense
just a little bit
and
more.
prosecution.
We're not
during
even, we don't even have
yesterday's
anybody in the
proceedings.
stand or anything else. Andrew Wilson's a good debater, but he should get out of the debating dating stuff. The one woman got him bad, turning his own standards and arguments against him, the sniz liquor. Yeah. Look, there is a debating is a skill. You can have facts, evidence, and everything else on your side. And if you don't know how to debate properly, you're going to lose. And the other thing you got to be careful about is, again, you can go on there and people can just say whatever they want for sound bites. I had somebody do this on a space to me the other day. I was 100% correct. They took some things out of context. They played on people's ignorance. And again, they start pushing narratives that are just lies, and they cut that, push it out. It's going to happen. And that's why people are afraid to step out in the space. You just got to realize that people are going to attempt to make a fool out of you, and accept it, and be willing to do that, and be willing to expose yourself to that. And that's going to happen. I don't even know exactly what you're talking about, Bumps Johnson. Maybe it's true, maybe it's not. And here's the thing, no matter what you're doing, you're going to have off days. You're just not, and sometimes you're just going to get bested in that moment, no matter if you're the world champ or not. Doesn't matter. So, that is the risk of stepping out into the public discourse. It just is. But you got to be willing to do it. And just understand that you're going to take some L's and you're going to take some W's. And hopefully the W's outweigh the L's. And hopefully you're continuing to get better, whatever it is that you're doing. All right, let's go back to this. Make sure we're not missing anything important. I doubt it.
Unnecessary delay. This is needless delay, and we'd ask the court to acknowledge and the record to reflect the
this just a little bit.
standing objection. Yes, defense, that ruling.
The table are turned off to prevent, and turning to Mr. McBride.
Thank you, Your Honor. Before this hearing, the defense moved to find Article 1, Section 12 of the Utah Constitution, Rule 7B, and Rule 1102 unconstitutional as it relates to the admissibility of hearsay and reliable hearsay at this hearing. The issue was extensively briefed and argued. The court denied the defense motion to exclude the use of reliable hearsay at the preliminary hearing. That ruling is at docket number 631. In addition, defense counsel filed a standing objection on July 3rd. That's docket 678. The standing objection reasserted the arguments made in defendant's previous motion. Defendant continues to make these same objections throughout the testimony of each witness. I believe both the state and the court and everyone present knows that the defense objects to the use of hearsay or reliable hearsay at this hearing. On the point of preserving the objection, that has been done. Defense counsel has filed their motion, they filed their standing objection. Throughout the proceeding, they have continued to make objections. At this point, further objection is unnecessary to preserve the record and causes undue and unnecessary delay. This is needless delay, and we'd ask the court to acknowledge and the record to reflect the standing objection. And we also ask the court to give an instruction that continuing objections on this ground are unnecessary. Of course, if it relates to some other ground or is some item that's particular to a particular statement, that objection may be appropriate. But at this point, we feel that the repeated objections that have been made and already been ruled upon are unnecessary and cause undue delay.
Thank you, Mr. McBride. To defense.
Good morning, Your Honor. Michael Burt for Mr. Robinson. We have no objection to that procedure as long as the court makes a ruling that the objections are preserved. We do think it would expedite matters if we didn't have to repeat the standing objection. There may be particular objections that are not covered by the standing objection we've made, and so we ask permission to be allowed to make those objections as needed.
Thank you, Mr. Burt.
Agreed.
Thank you to both sides. I appreciate the presentation and your argument about this. The court takes no position in regards to whether the objection is made again and again or not. I leave that to the parties. I recognize the need to expedite this, and if both sides stipulate, I will adopt the request that the standing objection as it relates to 1102, Article 1, Section 12 of the Utah Constitution, and all relevant authorities that have been cited have been noted, and the standing objection by defense is in place. However, if defense feels the need to do that in order to protect the constitutional rights of Mr. Robinson, the court will not prevent that, nor stand in its way.
Sterile postings, I'm just seeing yours. Where did you send those to me? I haven't had a chance to go through messages and everything else since last night.
As necessary. But as noted,
I'm sure I probably did. Just let me know where you sent those.
Note that the standing objection has been noted for all of the yesterday's proceedings and will be in place throughout the rest of the preliminary hearing. Anything further or any need for the record, given the court's statement?
Not from the state.
No, Your Honor.
All right, thank you. All right, the court acknowledges that the exclusionary rule is in effect. At this time, any witness who is subject to exclusion should be excused from the courtroom. And again, I will leave it to the parties to monitor the courtroom to ensure that if a witness has come in and they shouldn't be, that they are redirected. I invite Agent Hull to return to the stand to resume direct examination. And Agent Hull, you are still under oath. Mr. Sturgill?
Thank you, Judge.
And before we begin, is there a way to dim these lights just a tad like we did yesterday? Perfect. Thank you. All right. As of yesterday, there is also a water bottle to your left. And if you wouldn't mind just making sure that microphone is directly in front of you, we want to make sure that the record picks up your testimony today. Mr. Sturgill, your witness.
Thank you, Judge. Agent Hull, we're going to return to what has been marked State's Exhibit 12.1. There was reference to it yesterday. And I'd like to ask you again, have you reviewed that exhibit?
Yes.
And if you wouldn't mind, just briefly remind us what that exhibit consists of.
The exhibit is a compilation or running of a summary of videos from UVU campus security footage.
Okay.
Your Honor, excuse me, we can't hear the witness.
And that's what I hear. So let's go ahead and
Yeah.
stop. I'm not hearing it. So I'm going to have you repeat. Let's test it. Go ahead.
Check.
All right. I believe that.
Thank you.
Mr. Sturgill, if you wouldn't mind restarting.
I
so
can do that, Judge.
Thank you.
Maybe bring a mic from the base a little bit closer to you. I don't know if that'll help. All right, let's go ahead and go back to what's been marked as State's Exhibit 12.1. I'd asked you a moment ago if you'd reviewed that exhibit.
Yes, I have.
Okay. And would you just remind us what that exhibit consists of?
It's a compilation of videos that were part of the overall footage that was obtained from the Utah Valley University as part of the investigation.
And does that compilation video, from your point of view, capture Mr. Robinson arriving to and visiting the UVU campus
It does, yes.
on September 10th through the 11th, 2025?
Correct.
Okay. And again, I asked you this question yesterday, but did you prepare that video compilation?
I did not.
Okay. Do you know who did?
The Utah County Attorney's Office.
Does that video, and I'm referring to 12.1 exhibit, State's Exhibit 12.1, does it include all of the footage collected by the SBI from UVU?
It does not, no.
Does that video, again, 12.1, include all of the footage you collected from UVU that captures who you believe is Mr. Robinson walking around campus?
Not all of the footage, no.
You reviewed this compilation with Mr. Olson, correct?
Correct.
And in its entirety.
Yes.
And he actually, and then you collected an 1102 statement from him.
I did, yes.
And I believe that has actually been admitted into evidence as State's Exhibit 12.3. Did Mr. Olson refer to that exhibit, 12.1, in his statement?
He did, yes.
Okay. 12.3. I'm going to put on your monitor State's Exhibit 12.3. And I asked that it be scroll down towards the very bottom. And I would ask that you read from the statement specifically what Mr. Olson said about State's Exhibit 12.1. And I want to narrow your focus. So I'm going to draw your attention about 3/4 down the page. There's a sentence that begins on the left margin, "I have reviewed." Do you see that?
I do, yes.
Okay. Would you please read that sentence?
I have reviewed State's Exhibit 12.1, and the recordings are true and accurate, including timestamps, dates, and camera labels. The only changes are some zooms and red highlights, which were not part of the original recording.
Okay.
Would
Have
like me to-
you, I'm sorry.
Sorry, I didn't know if you wanted me to continue. Or...
No, that's good enough. Have you had a chance? Well, you reviewed the raw footage yourself. Is that correct?
Correct.
And does that comport with your viewpoint of that exhibit?
It does, yes.
Have you had a chance to review what's been marked as State's Exhibit 12.4?
Yes,
Okay, and when did you review that exhibit?
this morning
And who did you review that exhibit with?
with Kimberly Durfler.
Okay, was there any conversation about that exhibit?
No, I was just shown the video.
Okay. Nobody asked you questions or suggested anything to you?
They did not know.
Did you prepare that exhibit?
I did not.
Do you know who did?
The Utah County Attorney's Office.
All right. And I'm referring specifically to what's been marked State's Exhibit 12.4. What is depicted in that video?
That video is, again, a compilation of videos from the overall footage that was obtained from Utah Valley University for September 11th and September 12th.
And how does it compare to what's been marked as State's Exhibit 12.1?
It appears to be the same footage. However, on this particular version, there were no circles or blurs that had been made to the video.
How about zooming in and zooming out?
No, there was no zooming or zooming out.
Does it appear to be identical to the raw footage that you've seen that portrays this particular part of the UVU surveillance video?
It does, yes.
Judge, the state would move to admit what's been marked State's Exhibit 12.4.
And
Your Honor, we just object to the publication of this for all the reasons we argued yesterday. We think this video is going to play a big role in the trial, and to allow the public to see it now would seriously impact our ability to get a fair trial, and we're asking the court not to publish it.
thank you. And Mr. Surgeon, and to all counsel, as it will apply to all counsel, when you are moving a piece of evidence, it's the three parts, whether admissibility into the record,
Right.
to be published in the courtroom, and captured by the media. So Mr. Sturgill, as it's your request, what are you requesting?
Judge, first of all, clearly I'd move to admit the exhibit. I'd ask, and Judge, the presumption is that this is a public record and should be published. And so the state's position is that it should be published here in the courtroom, and it should be published in such a way that the media can capture it on video.
All right.
Your Honor, can I be heard on that very briefly?
You may, if you would approach the lectern, please, and state your name.
I'm David Ryman. I represent the news media. I didn't make an appearance because the news media technically aren't parties, but as you know, they do have the right to be heard on issues like this, and I've tried to keep that to a minimum. But since this is the first one coming up today, I thought it might be helpful to just address it again. There is a presumption not just that it be published in the courtroom, as we talked about yesterday, because the participants or the spectators in the courtroom have a right to know what the court is viewing so that they can understand how you're making your decision. This seems like a very important piece of evidence. It doesn't seem like there is a basis in the courtroom today from understanding why it's being introduced. It is not like the videos yesterday, and my understanding at least is, and you can correct me if I'm wrong, but we didn't object to the videos that weren't published yesterday that were graphic. We didn't object to the non-publication of the autopsy report. The argument here that Ms. Nestor just made is this seems really relevant, and that is precisely why it needs to be public. With the last thing I'll address is just EMC. There is a presumption, it's a rule presumption, not a constitutional one, that EMC is allowed. And I think that for all of the reasons that we've briefed this for your honor several different ways, there needs to be a really good reason why. If it's being published in a public proceeding in the courtroom, it should not also be allowed to be published to the media. So, thank you.
Natalie's in the chat. Natalie
Mr.
Beisner, thanks for showing
Sturgill,
up.
Do you wish to respond or perhaps
Natalie,
give a little
you're always
more
welcome on the
detail
channel.
on what
Love to have you.
this video purports to show?
There's the link.
Well,
Want to come in? Love Natalie.
do you want me to proffer that, Judge, or have the witness?
I'll defer to you.
Okay. Well, first of all, if I could take one step back, let me ask you, I may have misheard, but let's just be clear about this video, the compilation video. It includes video surveillance from UVU campus from what dates?
September.
All right. Da Vinci, listen to me. It's the last time I'm asking you. I've asked you respectfully, kindly. I would love for you to be here. I would love for you to be a participant. We want to hear your thoughts on the subject matter at hand. Everybody else, stop talking about Zionism. Stop talking about theology. Now is not the time or the place to have those discussions. Da Vinci, I would love to hear your analysis and your opinions on the case matter at hand. That's it. If you're going to continue to what appears to me to be just trolling and being a distraction over in the chat, I will ban you. I will ban you quicker than shit. So I don't think I've ever even seen you in the chat before. So all of a sudden you show up, you start just talking about the Bible's crap, whatever, right? You're an atheist. I got it. Respect. That's your choice. But if you're going to be a distraction in this, then I'm going to ban you. Would love for you to stay. Would love to hear I'm sure you're a very intelligent person. Would love to hear your thoughts on this matter alone. And if you're going to continue to be a distraction, I will ban you. Hopefully that's clear and we can end that. We can all be friends, right?
November 10th, 2025 into the morning of the 11th, 2025.
And if you wouldn't mind just describe in a bit more detail what this compilation includes.
The compilation shows the movements of the individual believed to be Mr. Robinson on Utah Valley University campus, arriving and leaving in a vehicle, arriving and leaving on foot, and then returning and leaving, and then attempting to gain access again in a vehicle. And his movements throughout the day are included in the videos also.
Is there any footage of the alleged shooting?
There is not, Judge.
Okay, I just want to clarify that. Ms. Nestor, given that additional information and anything further from defense.
Mr. Burt's he's the one who's been litigating all of the First Amendment issues. If he could address Mr. Ryman's argument.
Yes, Mr. Burt, if you wouldn't mind coming forward.
Judge, I wanted to clarify one argument that was made by counsel for the media yesterday, and that was the rules, the rule 4-202.02 does not apply to the situation we're in right now, and that is wrong. The rule says that this rule applies to the judicial branch, and 4-202.02J says the judge may regulate or deny access to exhibits to ensure a fair trial. So I think that rule does apply to our situation, and the Supreme Court in the Algier, ALLGIER case, 258 Pacific 3rd, 589, applied the rule in the context of an evidentiary exhibit. And I know the court has not mentioned, since counsel made that argument, this particular rule, but I think it does apply here. And also applicable is the Supreme Court's decision in the Kearns case, which we talked about when we argued the motion for denying access to the cameras. And that case, Kearns versus Tribune Corporation, 685 Pacific 2nd, 515, says that the standard the court ought to apply in determining whether an exhibit at a preliminary hearing should be sealed is one of a, quote, realistic likelihood of prejudice. And we rely on the evidentiary showing we've made in connection with our motion to exclude cameras, that there is a realistic likelihood of prejudice in this way. The court knows and has access to the media coverage up to the time when we litigated the motion concerning closing this hearing to the cameras. And the court knows that one feature of the media coverage has been a very pro-prosecution bias of every story that has been published on this account. The court also knows from that coverage that information is being widely disseminated, and you have found
this clown, the defense, is saying that the media has been pro-prosecution as far as their coverage goes. Let me tell you something. Legacy media means nothing. There is 50 times the coverage, 50 times the view that is pro-conspiracy, pro-Tyler Robinson didn't do it on social media. And to sit there and just say, like, I guess legacy media, mainstream media, and by the way, there's a lot of that going on as well. Like a lot of these people are pushing some of these things at least, but that doesn't even matter. You're talking about 10% of the actual coverage. The other 90% of the coverage just about on social media is pro, Tyler didn't do it and all the crazy conspiracies. So just stop there with it. That's his job though, right?
In connection with the shackling issue, that the publicity in this case, and we've also
Any final,
Robinson's right to a fair trial. So under that standard and under the rule, the court ought to deny publication.
thank you, Mr. Burt.
Thank you.
Any final argument from the parties before the court issues its ruling?
Your Honor, can I be heard on that briefly?
Yes, you may.
Thank you, Your Honor. David Ryman. I just wanted to clarify. I don't know that Mr. Burt and I necessarily disagree about what he said about the rule. What we were talking about yesterday was something different. That is the portion of the rule that classifies records that are in the court file. It's not the same as what happens in a public hearing. And Mr. Burt referenced the portion of the rule that essentially just tracks the constitutional standard, which of course, controls here as to whether in this public proceeding, it can be closed in any way, and non-publication of exhibits.
Look, they've made a determination that is due to public interest, that everything in this trial be public. It should be an extremely high bar for them to be able to not show any of the evidence. And I get it if it's extremely graphic. And I'm sure there's some other instances, but it should be an extremely high bar as to why we're not going to show certain evidence, given that it has already been determined that because of public interest, because of trust, and everything else is being said, everything surrounding this, that this needs to be a public hearing. And I agree. And I think most of you do too.
The
So
last thing I'll say is just
we can't.
constitutional standard that I think we're all agreeing.
We should protect Tyler Robinson's right to a fair trial, but at the same time, and I understand it's a balance.
And it is never satisfied,
But,
as we
like,
explained.
Everything we possibly can. And I will say again, the other thing that we need to remember: this is a preliminary hearing.
And I certainly don't think
I could understand them,
that apparently just
the
defendant walking around.
not showing certain information for the preliminary hearing, but when it comes to the trial, once the jury's selected and they're kind of isolated, hopefully they just show everything.
No, but I think I'd like to be crystal clear. You asked if there's any portion of this video that captures, and I believe you asked of the actual shooting. There's no video of that. There is video, however, and you've heard testimony related to this, where the shooter goes to the top of the low-C building, goes out to the edge of the building, low crawls, and then leaves after what we assume is the shot being fired. That's as close as it gets. I don't know if that makes a difference, Judge.
Folks, listen to this. Listen to what he just said. This is a false narrative destruction bomb that's taking place right here. Listen to what he says.
Building goes out to the shooter goes. We've heard testimony related to this, where the shooter goes to the top of the low-C building, goes out to the edge of the building, low. There's no video of that. There is video, however, and you've heard testimony related to
There is video
where
Listen.
the shooter goes to the top of the low-C building, goes out to the edge of the building, low crawls, and then leaves after what we assume is the shot being fired. That's as close as it gets. I don't know if that makes a difference, Judge. I just wanted to make the record clear, and I want to be crystal clear with.
There is a video of him going out to the low-C building, taking the shot, and then leaving. There is video. You know that video that everyone said didn't exist? All the evidence they say that doesn't exist, it does exist. Somebody clip that right away. Jen, if you're listening. And by the way, keep Jen in your prayers. She's still not feeling well. I think she is going to be on here shortly from what I've been told. I've been trying not to bug her. I just want her to rest. And anyways, Jen, if you're listening, I know you can't help but work. So clip that, please, and let's get that out ASAP.
Your Honor.
Thank you. I appreciate that.
Or somebody wants-
Clarification as it is guiding for this court and
Liars.
making its ruling. I turn to Utah. Well, let me pull this up. So Rule 4-202.02. I go down to, well, first it says statement of the rule. 1, presumption of public court records. Court records are public unless otherwise classified by this rule. 2, public court records. Public court records include but are not limited to. And I'm going to go down to 2J, exhibits. But the judge may regulate or deny access to ensure the integrity of the exhibit, a fair trial, or interests favoring closure. And the court recognizes the importance of the constitutional rights of Mr. Robinson being upheld and protected. At the same time, the court also recognizes the importance of transparency and a proper balance to ensure that the constitutional rights of all parties are upheld. As it relates to this exhibit, I believe it's 12.4.
12.4, yes.
I agree.
Based off the representation of what is in that, the court differentiates this exhibit from the exhibits from yesterday, namely Exhibit 7, Exhibit 8, and Exhibit 9, as those are different in nature. And those go to issues relating to Utah Constitution, Article 1, Section 28, as it relates to the Declaration of the Rights of Crime Victims, 1102, that exhibit. Having taken in consideration all factors, the court rules that Exhibit 12.4 is admitted into evidence and shall be played in the courtroom and may be broadcast by the media. We can proceed.
Overruled.
Agent Hall, before we actually watch State's Exhibit 12.4, I have just a few questions. Yesterday, you testified at the very beginning of your investigation that you focused on the video that captured the shooter on the top of the Low C building. Is that correct?
Yes.
I believe you also testified that you began by working your way.
No, it shows him taking the shot. Now, whether or not you can see him take the shot, depending on what camera angle they're showing, I don't know. And what I mean by that is, are you going to be able to see recoil or muzzle flash? I doubt it. But you're going to see him get into the exact position, and you're going to see him be in that position the moment the shot is fired. And these are things that people have said that don't exist, and it does.
And this is what I remember you saying, so correct me if I'm wrong. But you, in essence, testified that you began with that video and you started working your way backward and forward with the UVU surveillance video in an effort to trace the shooter's steps on campus. Is that right?
Correct.
Okay. Would you mind explaining just in a little bit more detail what you meant by that, tracking forward and backward on that video?
Yeah, we had a known when the shooting occurred, and as the officer testified, there was a video of an individual on the roof at the time of the shooting. And so the philosophy that we applied was to take what we knew and then work that forward through the timeline and backwards through the timeline to try and establish where the individual had gone from the rooftop or how the individual had come to be on the rooftop.
And did that, for lack of a better term, did that bear fruit?
It did,
you
yes.
actually see from, at least in part, where he came from and where that shooter went?
Yes, more so where he came from. It was very limited after the fact.
Okay. You testified yesterday that in reference, I believe, to what's marked State's Exhibit 21, that you believe Mr. Robinson visited campus at least 4 times on the 10th and the 11th.
Correct.
And I think you reaffirmed that today. Did you do the same attempt that is to track Mr. Robinson through UVU surveillance video during each of those 4 visits?
Yes.
Or those other 3 visits, I guess.
Yes, on each occasion, we attempted to follow the movements of the individual throughout campus.
And did you in fact see Mr. Robinson on campus in surveillance video that is not included in State's Exhibit 12.4?
Yes, there is additional footage of him on campus, yes.
Okay. I'm going to have displayed on your monitor a paused or a still image. And I'm going to ask if you recognize what you see that now, Agent Hall?
I do, yes.
Okay. Do you recognize what's displayed on your monitor?
Yes, it's footage from the university that was provided to us, particularly of the parking structure.
Okay. Does it appear to be State's Exhibit 12.4?
It does, yes.
So I'm going to go ahead and I'm going to have this video run. And if you don't mind, as it's running, I'm probably going to be asking you some questions. And so this video has no audio, is that right?
No, there's no audio on the cameras.
Okay. Let's go ahead and start the video.
Your Honor, it's just not up on the screen yet.
Let's go ahead and put it on all screens. No, I appreciate it. Is so it is admitted and may be published to the screens. And just want to make sure it's on your screen, Agent. All right. All right. Mr. Sturgill, you may proceed.
Appreciate that, Judge. Thank you. Go ahead. Okay, what are we seeing here, Agent Hall?
That's the vehicle that is believed to belong to Mr. Robinson arriving in the parking garage on campus.
At what time in the morning? What time of the day?
It's approximately 8:30 in the morning on September 10th, 2025.
And what leads you to believe that this particular vehicle belongs to Mr. Robinson?
Information that was provided regards to driver's license and Department of Motor Vehicle records. The vehicle fits the description of a vehicle owned by Mr. Robinson.
Is there anything unique about that vehicle that stands out to you?
The shape of the vehicle is very distinct, but predominantly the wheels were very distinctive on this version of the vehicle.
Now what do we see?
The driver of the vehicle exits the vehicle and then walks on foot to exit the parking garage. It's the individual in the red T-shirt and the shorts and the shoes.
And do you believe you recognize who that person is?
Yes,
Who is that?
I believe that's Tyler Robinson.
All right. Where does he go from there?
He heads out of the parking.
It's Tyler Robinson. It is not Lance Twiggs. For all the people saying, oh, it's actually Lance Twiggs.
Garage on foot into the campus and actually goes to the quad area of the campus. At that time, he makes contact with some representatives from TPUSA.
By quad area?
Sorry, the amphitheater is what I previously referred it to.
All right. So he goes up on campus, visits the amphitheater area, the courtyard or quad.
Correct.
And then what do we see here now?
He returns on foot back to the same vehicle.
And what time is he returning back to the vehicle?
It's about 9:25 a.m.
And where is this parking structure located on campus?
It's just off of Campus Drive. It's a short walk from the amphitheater.
What do we see now?
That's the vehicle exiting with Mr. Robinson driving the vehicle.
Now what do we see?
This is Mr. Robinson returning to the campus on foot from the neighborhood to the northeast. You can see he's wearing the same clothing as in the previous video.
Is that 10:09?
And he's carrying a blue backpack.
Describe the clothing.
It's a maroon colored T-shirt with gray or olive colored shorts and then Converse shoes.
And what time did he return to campus?
Just after 10 a.m.
And does he leave the parking structure eventually?
He does, yes.
Okay. And during this visit, do you know where he goes after he leaves the parking structure?
Yes, we were able to track his movements on campus. He went to Chick-fil-A in the Sorensen building
Mhm.
and purchased some food, sat and ate the food. Then,
And
I'm sorry,
Where did he purchase the food from?
Chick-fil-A in the Sorensen Center.
And where is that in relation to the amphitheater or the courtyard?
It's kind of on the northeast side of the amphitheater. It would be on the upper back edge of the amphitheater, furthest away from where the tent was that Mr. Kirk was in.
And from there, where does he go?
From there, he moves across campus, out across Campus Drive into a wooded area on what would be kind of the northeast side of Campus Drive. Then returns back onto campus. We noticed at this point that he's no longer carrying the backpack that he was originally wearing. He moves through the Gunther building and the computer science building. And
goes where?
then, I'm sorry?
And then goes where?
Then goes across to the railing that gives access to the roof of the Losi building.
From there?
From there, he comes back down the stairs and walks off campus from that point.
And about what time was that he left campus that second time? Do you know?
I believe it was approximately 11 a.m. or just after, if I recall. I could verify from my notes if you need an exact time.
Yeah, if you don't mind. That'll help you remember, refer to it. Don't read it out loud. Just let me know when you've had a chance to look at that, would you?
Folks, this should put an end to all this right here. All of what we're seeing right here should put an end to everything that's been going on with Candace Owens and all these other
Were you able
freaking
to
grifters
refresh your memory as far as the
lying
time?
to you.
I was, yes.
And what time was it?
It was just prior to 11 a.m. when he walked off campus.
And before we go any further, the parking structure that he left initially, where is that parking structure in relation to the LDS Institute building?
I'm sorry, in relation to?
The LDS Institute building on campus?
I agree, buddy.
I think it would be just to the north of the LDS Institute building, if I recall.
Do you recall whether it was adjacent to the LDS Institute?
Yes, it is.
Okay. All right. What do we see displayed here now? Go ahead.
This is a video of Mr. Robinson returning back to campus the same way that he did previously on foot.
And this takes just a moment. And why, well, let me ask you this. You believe this is Mr. Robinson returning to campus?
I do, yes.
Okay. And why do you believe it's Mr. Robinson?
The shoes are the same, and the images that we have from my viewing and seeing Mr. Robinson on the video, it's the same person.
Could it be any more obvious?
He's noticeably wearing different clothing.
He is wearing different clothing, and he also is walking with a gait or a limp in this video.
With a gait or what?
A limp.
Okay. Now what do we see?
So it's Mr. Robinson coming up the stairs of the parking structure. Again, he seems to be having issues walking.
And again, we're able to track Mr. Robinson when he leaves this parking structure.
Yes, we were able to.
Okay. So when he leaves the parking structure, where does he go?
He comes up around Campus Drive. As you can see on the video here, there is a cut through there north of the Losi building, and that's Mr. Robinson coming up the sidewalk. He has the noticeable gait or limp in his walk. And then he moves south across the...
For those that have watched Gray Hughes' animation recreation of this looks exactly like what he created. And just
Gary,
Yep.
just for my reference, can you remind me what time the shot happened?
I believe it was 12:23.
12:23.
12:23, like 40 seconds into that.
Front of the Losi building.
On the sidewalk?
Yes, correct.
Okay.
He would be the rear of the two individuals in this
And now we're at
particular video.
12:03.
So right now, if you were to break this picture into quadrants, where would he be?
I would be in the top left quadrant, walking to the left of the image.
Now what do we see?
This is an
Bless you.
image looking across the parking lot to the Losi building, and Mr. Robinson is appearing on the exterior staircase, which gives access to the Losi building roof and the area where the railing was.
And again, let's break that image into quadrants. Where would he be located if you broke it into quadrants?
It's in the top right, and the individual can be seen moving under the notations that are on the video.
And what time is this?
It's just afternoon, about 12:15.
On what day?
And real quick, folks. So yesterday they tried to show a compilation of all these things where they were actually zoomed in and they had some things circled, and the defense, objected to that. So now they're showing the original film of each one of these, and I think later on we're going to see the altered version of this. And what they're doing is just proving that there was nothing changed that is material to this. Hopefully, we'll be able to see that, and we'll get better views of all of this as they have digitally cropped in.
On September 10th, 2025.
What just happened, or what did we just see happen?
The individual actually kind of rolls over the railing onto the roof of the Losi building.
All right. Go ahead, sir.
And again, in the top left corner, the individual is now seen running across the rooftop of the Losi building to what would be the southwest corner of the building, crouching down and then crawling to the corner of the building.
And this is at what time?
12.
Around 12:23. I think the timestamp on the video is 12:22.
On the 10th.
On September 10th, yes,
So we're
2025.
clear. This is the roof of the Losi building.
Correct.
Can you still see that individual?
Yes, you can, laying prone.
You believe this to be Mr. Robinson?
I'm sorry?
You believe this to be Mr. Robinson?
I do, yes.
And how long is he out there on the edge of the building?
Just until the reported shot was fired at 12:23 and 28. Individual then stands up and then moves across the building to the north.
Is that what we're seeing happening right now?
It is, yes. They move behind the atrium area on the rooftop to the northeast corner where the white triangle is.
Do you see Mr. Robinson now?
I do, yes. He's just arriving at the corner of the building, almost the top center of the image.
What are we seeing now?
And Mr. Robinson lowering and jumping off of the roof of the Losi building onto the grass area, and then moving away towards Campus Drive. And he appears to be carrying some kind of an object in his hand at this time.
So he's approaching,
Campus Drive.
and again, broken into quadrants. Where is he currently?
Be in the top right quadrant.
And the time?
It's 12:24 and 42 on the timestamp.
What do we see now?
He then crosses Campus Drive and drops down into the wooded area on the far side of Campus Drive.
And that is located in what part of the video? What quadrant?
It would have been just off center on the top left side.
And that, folks, is a video perspective that I don't believe we've ever seen before. So that's from another location, seeing him cross the road, go into the wooded area that I showed you yesterday. For those of you that weren't here yesterday, I will show that video again. I will show you exactly when I was there and I walked over to that area so that you can see the terrain and see what it looks like and see exactly where I believe that he hid the rifle.
Gary,
What do we see now?
Yep. Go ahead.
I'm as a criminal defense attorney, I'm watching this. If Tyler Robinson's my client, I'm devastated. This is you don't often get surveillance video of everything like this, so it's pretty devastating for the defense.
Yeah, no, it's and wait till they show it zoomed in where we see a more clear
Exactly.
picture of what's going on.
This is the unenhanced version, right?
Yep.
This is the intersection of Campus Drive and 800 South. There's a vehicle attempting to turn right onto Campus Drive. That's the vehicle that's driven by Mr. Robinson.
6:36
And
p.m.
on the screen, where is that vehicle that you're referring to located? If you broke it into quadrants.
It's on the left side, on the upper side, the upper quadrant.
Now, what do we see?
That vehicle's now pulling away and heading east on 800 South.
And why do you believe that vehicle is Mr. Robinson's vehicle?
When that vehicle was stopped, it actually made contact with an officer who was doing security detail.
And do you know who that officer is? or
Officer
was?
Goforth,
Okay. And do you know which department he works for?
Spanish Fork Police.
And did you have a conversation with Mr. Goforth regarding this interaction at that intersection?
I did, yes.
Okay. And what time was that interaction? I'm sorry. Did I ask you that?
It was approximately 12:30 a.m.
On the 11th?
on September 11th, 2025.
So you talked to Officer Goforth about that contact on the corner on that, during the early morning hours of the 11th.
Correct.
And what did Officer Goforth tell you about that interaction?
It was an interaction that I guess cop intuition, but there was something about the interaction that made him make a note of the license plate of the vehicle. And then subsequently, when information was available that vehicle or a vehicle matching the description of that was involved in the incident, he ran the information that he had obtained from the stop and was able to identify that it was registered to Mr. Robinson, and he had in fact had contact with Mr. Robinson on the morning of September 11th, 2025.
The information that he ran, do you know what information when you say that, he ran information?
Yes, he ran a partial plate.
Okay. A license plate?
Correct.
And based on that partial license plate, he was able to identify the owner of that vehicle?
Yes.
And did he tell you who the owner of that vehicle was?
He did, yes.
Okay, and who did he tell you that it belonged to?
Said there were two registered owners of the vehicle, Tyler Robinson and an Amber Robinson.
Did he say anything about the person that he actually interacted with?
Yes, it was a male that he believed to be Tyler Robinson.
Let's return again to what's been marked State's Exhibit 12.1. Again, you've reviewed that video.
Yes.
And the difference between 12.1, or what's been marked as State's Exhibit 12.1 and 12.4 are, if I understand you correctly, are these enhancements that we've been talking about.
Yes.
And specifically, what be specific about the enhancements, and let's go one at a time.
Okay.
I think there's a reference to either red circles or red highlights. I think
Correct.
That's how Mr. Olson described it, red highlight, referencing by the red highlights. Or what do you?
Placed over the image to identify specific individuals of note.
And these red circles, different.
I don't think we need to hear about red circles.
And that is a bad question. What I mean by that is do they appear and disappear quickly, or do they linger or last for a period of time?
They're there for a notable period, but I believe they come off the video.
All right. And other than, well, and you said that the circles, what do the circles do?
They identify an area or a person of interest within the video.
And other than do that, do the circles or the highlights do they do anything with regards to the video itself as far as its
Not-
accuracy?
Not to my knowledge, no.
I think the next enhancement that has been mentioned that we've talked about is there's some blurring.
Yes.
Do you know what that, tell us what that is. What blurring do you see in what's been marked as State's Exhibit 12.1 that you now don't see in 12.4?
If I recall, there were some individuals in the parking garage footage and their faces were blurred. Excuse me.
Is anything other than faces being blurred?
Not that I recall, no.
And how often do you see the blurring throughout the video?
I believe it's just in the original sequence in the parking garage.
The other than the blurring, does the blurring, other than obviously blur out part of the image, does it change or impact the accuracy in your mind of that part of the compilation video?
Not to my knowledge, no.
And then the last thing is, I believe, is there's some zooming in and zooming out that's in 12.1 that has been removed
Yes.
from 12.4. What can you tell us about the zooming in and the zooming out?
Predominantly, it's in the area that was referred to as viewing the Losi building rooftop. I believe it focuses on the area where Mr. Robinson comes up the stairs and onto the rooftop. Those portions of that particular footage were zoomed in for clarity.
Other than zooming in and zooming out, change, are the enhancements in State's Exhibit, well, it's been marked as State's Exhibit 12.1. Are they helpful in any way, or what do they add or take away from that video?
I think for people who are not familiar with the area and what's trying to be shown, they allow an opportunity for people to look at an individual who we believe to be Tyler Robinson, and also specific movements with more clarity than the original.
It sounds like it's specific to the Losi rooftop, if I understand you correct. And although you can see the facilitate, at least that part of the video, seeing Mr. Robinson and tracking, I guess, his steps.
I believe so, yes.
Okay. Judge, at this point, I think in combination with yesterday, which has been admitted into evidence, we believe there's enough foundation to admit what's been marked State's Exhibit 12.1. We think it would be.
Objection, and we also, thank you, Your Honor, we renew our authenticity objection, and we also object to for admission purposes. And then we also object to the publication for the same reasons, the fair trial issues that we raised with the unaltered version that was just submitted.
And Judge, sorry, I neglected to mention the other two. Again, Judge, we believe that the presumption is that this is a public record, that it should be not only admitted, but it should be published here in the courtroom, and it should be published in such a way that the media can have access to it.
All right. I do have a question in just directing your attention to the Utah Rule of Evidence 403, to the last phrase, the last 4 words in that. Do you wish to address that?
Judge, I'm going to have to look at 403 specifically for those last 4 words,
I can
unless you
read,
want to share that
I
with
can
me.
read that. Let me just read the whole rule.
Oh, God.
Probative
Let's read
value
the
is
rule some more.
confusing. Recognize there is no jury. I am the magistrate. I am the fact finder, but just addressing that last point of Rule 403.
Right. Judge, well, I don't believe that the evidence is cumulative. I think that each of the 2 videos, although they portray basically the same footage, there's characteristics of the one that has been enhanced that I think makes it easier for Your Honor to truly see what's going on, and for the public to see what's going on. I mean, we've displayed 12.4 on the video, and unless you have very, very, very good vision, or you've zoomed in on that monitor, you really can't see what Agent Hull has. It enhances, but and it just makes it, and specifically.
Anything further from the parties as it relates to 12.1? All right, well, I will admit 12.1 into evidence, but as it relates to playing it in the courtroom or on television, well, for the media, I find that it is, well, as the fact finder, I will look at the evidence and weigh it as a magistrate is required to do, but I do not find it is I don't find it's necessary to replay this video, given the representation that's the exact same video, the difference being enhancements made. If it was different in any way, or if it added to or subtracted from, that would be one factor. But because it's simply the same video, simply zooming in with circles or notations,
Of course it does.
the court does not find that the interests of justice requires it being played again. But it is received into evidence and will be reviewed by myself in determining a probable cause determination.
And I appreciate that, Judge. And just so we're clear, State's Exhibit 12.1 has been admitted.
It is received into evidence, yes.
And your intent is to review it in its entirety, but not here in the courtroom request. I believe the most important part of the most helpful part of this video is the zooming in and the zooming out. And that is a portion that if you want, we could isolate that and only play that portion of the video if you'd be willing to publish that portion of the video. And that's really the thrust of why we are trying to introduce that exhibit, because we believe that it's helpful to see it up close. And unfortunately, because of the way it's formatted and the way it's been recorded, there's no way any of us can zoom in and zoom out on this video to get a better look at what's going on. And that's the reason why we did what we did, but we had to memorialize it and save it. And then present it in that way rather than just present it in its raw form and then have the ability to zoom in and out, if that helps Your Honor understand why we're doing what we're doing.
All right, Ms. Nestor, to the second request of not playing the whole video in its entirety, but simply the portion with the zooming in. How long is that, Mr. Sturgill?
I think it's a couple of minutes.
All right, Ms. Nestor.
We object to the prejudice of that, Your Honor, and ask the court to stand by your previous ruling on that.
All right. Thank you. I appreciate both parties. What I will do is review this video in court, and it will be displayed to the monitor's counsel table and to the court's monitor on any portion that you wish to play for me to look at. So all parties can see clearly that the court is reviewing it in court, but I do not find that it is necessary for its publication because this is the exact same video. I recognize it's zooming, but in balancing constitutional rights, there is nothing on this video from what's been represented that
Coco Choco or whatever your name is. I had the same thing happen. I had two videos that were copyright banned.
the public
From Tucker Carlson, that met every standard of fair use.
hasn't already seen. It's simply zooming in, and I don't find that that is necessary or and so in balancing the constitutional rights of all parties, I'll view it on the monitor. Counsel's free to view it with me as I'm looking at it, but it will not be broadcast in the courtroom or by the video camera.
I appreciate that, Judge. I respect that. I think there's a natural break. You will have this entire exhibit in evidence, though.
Thank you.
Is that right?
Yes, I will. All right, whenever you're ready. Counsel, as it relates to your monitor, I know our camera operator is being diligent in ensuring that complying by the rules, but in abundance of caution, this is just your moment to take care of your screens.
So if I could just have one moment. Hold on, Billy. Not sure where the power button is on this.
All right, counsel for defense, are we prepared? And for the state?
Yes, Judge.
All right, thank you. Having heard from both counsel, I'll go ahead and review it on my screens. It is not being displayed in the monitor in the courtroom and to view.
All right, let's hit some super chats. They're not doing anything right now.
I'm trying to figure out the judge's reasoning for not publishing the enhanced version.
And just for the benefit of the record,
Sorry.
you want to put on
Yeah, go ahead, go.
And I'm not really figuring it out, because if it's an issue about like a fair trial for Tyler in the future, then I don't see how an enhanced version of the video would be any different than showing the current version. It's whoever's watching this is not going to be impartial juror anyway. And if it's for authenticity's purpose, if it's like, there's no foundation laid for the authenticity, maybe there's more tampering or whatever that the defense is alleging, then I don't know why they would accept it into evidence. So it's kind of inconsistent why, doing one but not the other here.
Agreed. Let me hit play. I'll address this. John Watkins said, I'm putting my name on it, Gary. I was Da Vinci. Now I was just responding to someone in the chat. I didn't threaten or insult anyone very weak. I was 375, so I had no problem saying this to your face. Yeah, John, and I told you, stop multiple times. So, and you're being a distraction. And now everybody in the chat is talking about you and not talking about the case. So this is my house, my rules. I asked you kindly to stop it. Just drop it. Let's talk about this case. And you had to continue to go on. Like, that's the thing. Like, atheists are like the most zealot. Like, they got to prove the point. I don't go up to people and say, hey, you know what? You need to accept Jesus Christ. No. You need to accept Jesus Christ as your Savior. No. You got to accept Jesus Christ as your Savior. Like, we'll have those discussions at the appropriate times. But, like, atheists, I don't know. They're like CrossFitters. Like all they want to talk about. They also want to talk about. Like, just shut up. Let's talk about the trial that's going on. How about that?
I love that. I love that analogy, Gary. I'm going to use it.
Tyler made this public. Absolutely, he did.
It's a good point.
Let's go. Another day of real evidence to smash the goons. Agreed. YouTube is definitely messed up. I had to renew my memberships, although it wasn't supposed to be automatic. Thanks, Gary. Yeah, we have those problems all the time. Here we go. John Watkins again. I am putting my name on it. It moved on me. Super sticker. Thank you. Appreciate you. You all mad about me? I was just responding to someone in the chat, but you kept going on and on, John. That's the problem. And you're still going on and on. I appreciate the super chats. And I appreciate your service, buddy. And I'm sure you and I would get along just fine. But again, quit being a distraction. LO, I can't chat for 20 minutes. You are the ones insulting me and getting upset. The rifle in modular chassis, the bag is small. The rifle wasn't in the bag. The rifle wasn't in the bag. The rifle and the stock were removed from one another. That's what I believe. We don't know. This is just speculation. He clearly has something down his pants. It's not that hard to quit pretending that this is like an impossible test. There's no way he did this. Like, there's plenty of different options. There's plenty of ways to hide a rifle. We see him clear. Like, what you think he's just happy to see everybody? Like,
I have another question for you, Gary.
Yeah.
Do you happen to know, was Tyler a student or a former student at UVU?
No, it was
no.
No.
So there's
he just knew that Charlie Kirk was going to be there. But there is evidence. There has been references that he actually went there in the past, and somebody saw someone that matched Tyler's description. Not only there days prior to, but actually that went out on the roof to where the shot was taken. By the way,
really.
Yeah.
Do you happen to know how close in proximity his home or where he lived was in UVU?
He's like 3.5 hours away.
3.5 hours. Okay.
Yeah.
So.
No cover for time or place. I just said Christianity was a myth and Zionism is not allowed to influence our government. You're acting like the way I expect Christians to act. I hope you know it's not surprising to non-Christians, very weak. And you're acting just like a militant atheist acts. I see this all the time. I would not block any of you like cowards do. Thanks for the $2, John. I was just calling out your hypocrisy, and we told you to stop, and you continued to not stop. How backwards is our country now? Normally the mobs would be attacking the suspects, parents, family, not the victims. You're exactly right. All right, let's get back to this.
on the record the timestamp of what you're playing, at what point you're starting and stopping, as we go, or when we finish is fine. I just want the record to be complete.
The difficulty in doing that is.
Well, you can just give me the
count
the
on the-
count record of what exactly I'm looking at. Limitations of technology. Oh, I see. No, it's.
Whenever we pause on the court system,
Oh, I see. No, it's limitations of technology sometimes. Thank you for letting me know.
So count on the video is just before 6-minute mark, Judge.
All right.
And, just so the record's clear, this is State's Exhibit 12.1.
Thank you. I have it on my screen. It's so it looks like it's been paused at 6 minutes and 9 seconds.
Agent Hall, can you see it?
Yes.
Okay, well, let's just, I'm good with playing it. And we'll play it. Go ahead, Kimberly.
It's playing.
All right, I see some discussions about 30-06 and the ballistics and all this stuff. We can have a longer discussion about that a little bit later. I will address all of the. So hopefully, for those of you that are critical of the idea that a 30-06 would not exit, make sure you guys stay around. And when we get to a pause point, we can have that further discussion. And I'll present to you what I believe, and I'll present some evidence for that. And then if you feel differently, that's okay. All right.
Gary, can I make a prediction here?
Sure.
I think the candy tards, after seeing all this devastating evidence, they would have been better served if they started from the beginning by saying Tyler Robinson was blackmailed or bribed to do this by Israel or something, because now they're stuck in this, conspiracy that Tyler Robinson, wasn't there, or some, all this nonsense, and they're going to eat it.
Yeah, no, and they went as far as saying, this is still playing, right? Yes, it's playing. I thought I had it paused. Yeah, so Candace is multiple times, and even on just latest on Sean Ryan, just recently a Sean Ryan interview saying that Tyler Robinson wasn't even on campus. So,
Yeah, it's ridiculous. But they'll switch their line of reasoning on a dime.
no, but they will, and nobody will hold them account for it. Like, okay, Candace gonna, who knows? But I wouldn't surprise me if Candace switches
All right,
from.
it's been
He
paused. It looks
wasn't
like
on
it's
campus.
6
Okay, he
minutes
wasn't
and
on
23
campus, but
seconds.
I'm sorry. Judge,
there's been no explanation as to why he was 3.5 hours away from his home, why his gun was there, why there's DNA on his gun, why it was cached in the woods. Like, there's no plausible explanation. You have to shoehorn with you have to do so much. You have to do mental gymnastics to try to say that Israel was involved, a different shooter was involved. If there was a different shooter involved, we have no evidence of that whatsoever. There's all these people out there. We have surveillance footage. We have people with cameras, and they caught no other shooter on camera. We see no other muzzle flash or anything else anywhere. It didn't happen, folks.
Right.
But anyways.
Yeah. Mark my words, they're going to switch to it was Tyler Robinson, but he was blackmailed or bribed to do it by Israel.
We'll see. I don't think they can afford. I think they're going to stick to what they've been saying, and that's a Tyler Robinson lookalike. I think that's the only thing that reconciles what they've said before and what they're saying, what we're seeing now in the evidence. But we'll see.
at 8:23, we stopped the video.
Oh, 8:23. Okay.
8:23. That's the count on the video itself. Agent Hull, you were able to watch that zoomed in version. Is that
Yes,
right? Okay. And was there anything that stood out watching that zoomed version?
For me, on the zoomed version, it's apparent that Mr. Robinson, the individual jumping off the roof, is carrying an item.
Okay. And you can see clear the clothing that he's wearing. Strike that.
Mr. Sturgill, do you want to respond to the objection?
Judge, it is leading.
I'll go ahead and sustain the objection, and that you may move forward.
Is it easier to see? Oh, strike that, Judge. I'll let the video speak for itself. Judge, I have nothing further with Agent Hall.
All right. Ms. Nestor.
One moment, Your Honor, if
Of
I may have
course.
the court's indulgence.
That's right. Best answer. Look, Occam's razor, guys. It was a invisible laser beam from a Jew base on the moon. That's Occam's razor. Simplest answer.
Thank you. Do you want to take your?
And I was just going to suggest that. It seems like right now is a good time to take our morning break. It is 10:15. Let's come back at. All
right. All right. So while we got this going on, turn down the volume. I'll keep an eye on this, or try to. While we got that happening, though, I want to show. Let me remove this. We'll throw this up there. Now, I know all of the conspiracy people. I'm going to try to be as respectful as possible today. All right. I'm going to try to lay off some ad hominems, because it's time for you people to come back into the fold, right? Come back and join the land of the sane and quit participating in this mental illness. Here we have a collage of pictures that are in chronological order here. Here's him prepping to jump down to the roof. We have this black object. All right. I would allege that this is a rifle in a black towel that is somehow magically rigid, just defying gravity up in the air. And then we have another one over here on the second picture. Once again, a black rigid object that is once again defying gravity. We know it's a towel because we see the towel kind of moving around sometimes. And then we see it again, defying gravity. And then down here, once again. And then suddenly, so many people that believe in these conspiracies are like, I don't see anything. I can't see that doesn't look like anything to me. Like, what do you think it is? Suddenly you're struck with blindness. Like Paul on the road to Tarsus. You can't see anything. And you're out there, you can see all these pixels. Like, look, there's a gun over here. Like, it looks like a pixel. And like you can spot all of these different anomalies that are absolutely nothing, right? Everybody remember the iPhone gun? The kid that's off to Charlie's right stage. If you're looking at the stage, it's off to the left. This kid just happens to be making this like hand motion. And they're like, it's an iPhone gun. It's like from 40 feet away. Anybody seen these like foldable little guns that look like a cell phone? They're about this big. They have 0 sights. There's no way anybody's shooting it. And by the way, you also want us to pretend that it makes sense that in a crowd of people, somebody fires a gun and like, I didn't hear it. Didn't see it. Didn't see someone like holding something like a gun. And then, the percussion, the gun blast goes off. Like nobody notices that. It's wild. It's wild. Let me see real quick. Let's talk a little bit about ballistics. So first of all, I saw a couple of comments over there regarding ballistics. And yes, somebody mentioned a very good point. Matter of fact, let me see if I can pull this up. I think it's one of the best videos. Let me see if I can. And it really does illustrate. Let me see what's going on with ballistics and the unpredictability of ballistics. Let me see if we can find this particular video. I know I talked about it in this one. This is definitely worth showing everybody. While we're doing that,
Can I make a quick point? Yeah.
please make all the points. Come on, do some
Yeah.
juggling or something. Keep the people entertained while I'm looking for something.
Got it. So everyone keep in mind that unlike a jury trial, the prelim, they're not going to like present it in a very palatable way, for lay people. Normally at a jury trial, you would kind of lay out all this chronology. You would have maybe PowerPoints that say the exact times of the videos. So it kind of explains everything. Maybe you would show a map of the school and stuff like that. It's not like that here. They're just trying to show that there's probable cause. So kind of bringing out the evidence in this more how would I say it, kind of random fashion is sufficient, because again, they're not trying to like present the whole narrative very clearly. At a jury trial, you're going to see the opening statement where they're going to lay it out what the evidence is going to show, and then they tie it all together in the closing argument. So, I know that just seeing footage, not knowing exactly the time or the place, it doesn't make everything clear. But again, it's not really the point of the prelim. They don't have to tie everything in a nice little bow.
Yeah.
And another point I was thinking is like, as a defense, I'm always thinking with my defense lawyer hat on. It's a problem to explain why he was there, because you're not going to want to put him on the stand to testify. I mean, very, very rarely do you put the defendant on the stand. And in this case, judging by Tyler's demeanor, I don't think it would be a good idea. So, but that's going to leave a lot of people with questions like, why was he even there? You're going to have to somehow explain that in the jurors' minds. I'm trying to think of like what sort of explanation. I was thinking, if he was down the street, if you lived down the street, then maybe you could say something along those lines. But 3.5 hours away, the guy's obviously never was a Charlie Kirk fan, so he wasn't going there for the show. So that's a big problem for the defense also. Yeah, they're probably thinking plea deal. But I mean, the main goal probably right now is still see how much evidence you can get excluded on technical grounds to maximize the benefit of a plea deal.
I'm still looking for. I played this video multiple times, and now I'm freaking looking for it. That's how this works. Every time you're looking for something, it's impossible to find.
But yeah, those videos were devastating. Were they public before? I haven't seen all those. I've seen stills, I think, but
I haven't. So there was a couple of those videos that gave us a new perspective that I haven't seen before.
Yeah,
it was more footage they said that doesn't exist.
right. And right now, if the prosecution wanted to, they could arrest and he would be held to answer. But they want to make sure.
So I mean, just based on kind of preliminary hearing standards, you talked about this a little bit yesterday. You feel like there's already enough evidence that's been presented to move forward with the trial.
Yes. Yeah.
All right. Let me see. Mm-hmm. All right. Let me try another. I may have had to cut that out. That's what it was. I got hit with a copyright claim on that particular segment of video, and that's what it was. I don't know. Let me think about how to do that's why I can't find it in the video, because I just remember I got hit with copyright. Look, so anyways, I'll just describe it. Take my word for it. You can search it online. You can find it. Oh, you know what? I know where I can find it because it didn't get cut out, and that was on Rumble. And it will be cut out of this video. I'll end up having to cut out of this video. And let me turn off my ringer. Still, but I think it's worth showing you guys, because it just shows you how unpredictable bullets actually are. Let me find this particular one. And folks, I will get to some questions in just a minute as well.
So yeah, I mean, again, thinking with my defense lawyer cap on, what am I planning? I'm planning first on, exhausting all the motions to exclude as much of this as possible, based on any number of possible reasons. But that's mostly, outside of the courtroom. Then I am, at trial, just throwing as much sand into the system to kind of blind people, so that with the hopes that maybe one person can't reach a decision and get a mistrial. That would be, sloppy investigation. You can argue that's, point to little inconsistencies, try to make them into like big deals, stuff like that.
Agreed. All right. So, anyways, I'm still having trouble finding this stuff. So, look, folks, the Mythbusters did this experiment 20 years ago. They shot a 9mm round through multiple blocks of ballistic gel and a 30-06 through multiple blocks of ballistic gel. Which one penetrated further, and by how much? So the 9mm went 5 feet into multiple blocks of ballistic gel. The 30-06 went about 10, 11 inches. It blew apart immediately. They also show them shooting rounds in water, which is very consistent or similar to shooting a human being. And all of the high-powered rifle rounds immediately broke up, just shattered once they hit that water. So, and whereas the lower velocity rounds, as somebody was pointing out, actually penetrated much further. And most of the lower velocity rounds didn't shatter, didn't break up. So that's what we're dealing with. And there's a lot of things. And then we can just go back to the fact that Martin Luther King was shot with a 30-06 at 65 yards. And it hit him in the jaw. It actually hit him in the spine, deflected downward. No exit wound from 65 yards. Charlie Kirk was shot from twice the distance, 138 to 142 yards away. And so just that alone, if you had the exact same rounds, we would expect significantly less energy, because it's a further distance. It bleeds off that velocity very quickly. All right. And then it hits him, and then we have no exit wound. Now, I can give you two other examples. Chuck Ritter. So I know 4 people by name that have been hit with 30-06 and it didn't exit. All 4 of these people. And what they all have in common is they're all hitting the spine, which I think has a lot to do with this. We also see that Charlie Kirk, there was some video that we played the other day with Midgray. You can see separation in the back of Charlie's neck. Like, literally looks like his spine is it looks like it's broken, right? So like it is detached, and actually you see a segment of it. But regardless, we have 4 people. We have Martin Luther King, Charlie Kirk, Chuck Ritter, and a guy named, what is his name? I'll think of it in just a second. What was his name? They had it in notes. Something Hill. I'll find it in a minute. But the point here is that all of these people, Charlie Kirk was shot from the furthest away. Chuck Ritter was hit with 7.62 by 54, which is the Russian equivalent. Ballistically is the exact same. He was shot from 25 yards away. It actually went in between his ribs, hit his spine, deflected downward, and not only did we not have an exit wound, Chuck's still alive today, and it was caught on video. The whole thing was caught on video. He was in a firefight in Afghanistan, and he continued to fight, by the way. The other guy.
I'm reminded, Gary, of that scene from Jurassic Park, where Jeff Goldblum's character drops a drop of water on someone's hand and it goes one way, and he asks, if I drop it in the exact same place, what do you expect to happen? Person says to go the same way. And of course, the point is that there's so many variables that can affect something like that. And I assume the same is true. I'm no ballistics expert, but I assume the same is true.
Absolutely. So again, all of these people, but let's just go back to Martin Luther King. I think it's the wound pattern and the circumstances of what happened, the terminal ballistics are extremely similar. The only difference is that it didn't hit his jaw for Charlie Kirk. Now people would say, and originally I kind of said this too. I was like, well, the jaw is thicker. Is it though? And here's the other thing too. If we have the exact same guns, and the other part of this is like, if it hadn't hit Martin Luther King, do we know that it would have exited? We don't know that. But even if we had the exact same guns using the exact same ammo, if it is twice the distance, can we still expect not to see an exit wound with Charlie Kirk? But let's go with reality. We have two different guns, right? We have two different types of ammo. What was the muzzle velocity of Martin Luther King? Was it greater than when Tyler Robinson actually shot Charlie Kirk? Was it a better engineered projectile that broke up quicker, that was designed to break up quicker? For the record, I'm going to put this on the record. I believe that it was 150 grain core lock. That's what I think that actually hit Charlie Kirk. That's the ammunition that I think Tyler Robinson most likely used. Could it have been a lower velocity? Even with the lower velocity, I have low recoil ammunition right over here. So we have low recoil and custom Hornady custom light, both 30-06 ammunition. Both are designed to have lower recoil. So it's going to have slightly lower velocity. Now, is it still moving well over 2,000 feet per second? You better believe it. So it would still have the terminal ballistic effects. We're still talking about a high velocity round. It would still break up. Is that a possibility? So we don't know the muzzle velocity. We don't know the energy. We don't know the bullet grain that actually hit Martin Luther King. We absolutely, it's just common sense to come to the conclusion, hey, 142 yards away, we could see the exact same result. So to pretend that this is impossible, and by the way, the first time that we started hearing this is like, it's impossible because if a 30-06 hit a human being, 100% of the time it's going to go through. We're going to have 100% exit wound every single time. Folks, that's just not true. I just gave you 4 examples of people that were hit with 30-06. As a matter of fact, I don't know anyone that has actually been shot in the neck and it did have an exit wound. I know Charlie Kirk, Martin Luther King, and Chuck Ritter, and another guy, Shane Hill. Shane Hill. Look up. He was actually hit in the back. It hit his spine, and there was no exit wound. But originally, the argument was, oh, his head would explode. There's no way you wouldn't have an exit wound. And now it's like, oh, well, it hit Martin Luther King in the jaw. So that, like, we got to throw that example out, even though every component of this is almost exactly like Charlie Kirk. As a matter of fact, the parallels are uncanny, quite frankly. Yeah, Gil,
Gary, let me ask you one other variable. I mean, wouldn't the angle of incidence also make a big difference? Wasn't Tyler Robinson elevated as compared to
Tyler Robinson was at 9.4 degrees. We had Charlie Kirk leaning over. And that's the other thing that these people try to depict. They want to act like the round came straight at a 90 degree to Charlie Kirk's body and hit him in the neck, and it should have went straight out. That's not what was happening, folks. We have a 9.4 degree angle, but on top of that, even if you're shooting at 140 yards and the straight line distance is 9.4 degrees, we still have a parabolic arc that takes place. And then on top of that, you can see Charlie Kirk, he's leaning over. So when it hits him in the throat, right above his Adam's apple, or right below his Adam's apple, all right, we're now at an angle plus the shot angle. It's going to go deeper in his body. So to pretend that it was just like 4 inches, actually it's about 9 inches from front to back of the neck. It was much longer than that because of the angles involved. And I just want to state, I don't know 100% that it was a 30-06. I can't say that. That's not what I'm saying. What I do know is that it is not only not impossible, it's much more likely than people realize. And when you take all the evidence, all right, and you look at it, you start to have to go through, you start weeding things out. Like, we're only left at this point, if it was a 1 in a million shot, things that are rare, that have a low percentage likelihood of happening, happen all the time. Happen all the time. Even if it was a 1 in a million shot, it's not even close to that. Right now, just based on empirical evidence, I have 4 people. They're the only people I know. And by the way, you can go look through pathology reports and you can go look through military studies. The occurrence of 30-06 not exiting the human body is much more common than people will even pretend and give credit for. So there's that.
I just don't get the implication. If they're saying, oh, it was a 40 caliber or something, it's like, okay, well, so Tyler Robinson was framed with the wrong gun. Is that like the whole point? It's
another stupid. It's like, this is a very sophisticated. It's a very sophisticated conspiracy.
Yeah.
There's all of these people. Like, it is so sophisticated, so well done, so well planned out that everybody got away with it. Nobody, and the implication is that we have the Israeli military, the U.S. military involved, and the one thing that they screwed up was they planted the wrong gun.
It's like
it's lunacy.
Yeah,
it really is. All right, let me get this back up here.
So, when did you leave the SBI?
The State Bureau of Investigation?
Yes.
March of this year.
March of this year?
Yes.
So you were involved in this investigation from September to March, basically.
Yes.
And your new position at Post, what is your new position?
I'm an investigative sergeant.
So you investigate potential wrongdoing of police officers?
Correct.
Okay. So when you were first brought into this case in September, is it my understanding from your testimony that you were not engaged in any way with this event prior to getting a call after the shooting? Is that correct?
Correct.
Does the SBI on occasion assist other agencies with preparing for big events like this or not? Is that not typically something you do?
Not something that I've ever been involved with, no.
Okay. And what time did you arrive on campus that day?
I believe it was shortly after 1:30.
So approximately an hour after Mr. Kirk had already been removed from the...
Approximately, yes.
Okay. And were you involved in putting up any drones into the air? Were you part of that or were you not involved?
It's not, no.
So how quickly after you arrived on scene did you become aware that you were actually going to be in charge of the scene?
I believe it was approximately an hour after, so what would have been approximately 2:30.
So for the first 2 hours, you were not in charge?
For the first 2 hours, I wasn't. I didn't arrive till 1:30, so no.
Okay. And once you came from on high that you were basically going to be in charge of the scene, what was your first priority? What were you focused on?
We were focused on, through our major crimes team and our lieutenant, putting together an investigative team and developing initial assignments and a plan as to what we were going to do moving forward.
And part of that is protecting any potential forensic evidence that may be found on the scene. That's clearly important, right?
Correct.
Preserving the scene, right?
Correct.
But it sounds like that's not really your area. That was more maybe Agent Falmina's area.
Agent Falmina was assigned to process and document the crime scenes. It was my understanding that the known scenes at that time, amid the chaos, had been contained and had been secured by the on-campus officers who were already on scene.
And what's your understanding of what the known scenes were? In other words, the area where there might potentially be evidence that you needed to process.
I know that the amphitheater area was cordoned off and managed as best it could with the number of people that were there. I was also made aware that there was a rooftop area that had been secured and also an area off of the side of that building that had been secured by an officer.
And that building was the low-C building.
Correct.
Wasn't there also a bullet found on another building?
I believe an unfired bullet had been found on another building at some point during my time there on September 10th. Yes.
Which building was that, sir?
I don't recall.
Was that considered a scene that was worth preserving?
It was not. My recollection is that that was accounted for as an ejected cartridge from an officer who had cycled his rifle.
Okay, I thought you said it was an unfired bullet, and now you're
That's-
saying it was a
that's correct.
cartridge?
When a weapon is cleared,
Uh-huh.
an officer would make his rifle ready, which would chamber around.
Oh, I got you.
And my understanding was that that's how that was accounted for.
So an officer claimed that bullet belonged to him or her?
That's my recollection, is that was how it was accounted for.
And when was that accounted for?
I don't know specifically.
Do you remember what type of bullet that was?
I don't.
Was it a 30-06? Do you remember?
I don't.
Do you know where that bullet is now?
I don't.
Okay. So you had the amphitheater area that had to be preserved. And how far out did that stretch? The entire amphitheater or just the area around the tent? Or
I'm well aware, Gerald. This is why I think that it was most likely, and it's very common, the core locked Remington Court. We know it's Remington ammunition that has been documented in the ATF reports and some other places as well. We know it's Remington ammunition. That's the only thing that we know about it. I'm assuming that it's 150 grain core lock. That's what I think it is. And it would be a very easy explanation. We would expect a high probability that that round would not exit had it hit Charlie Kirk where it did and actually hit him in the spine.
what?
My understanding was the entire amphitheater area was cordoned off, and there were attempts to secure the campus itself with a perimeter of officers who were monitoring or preventing people coming and going.
When you arrived on the scene, were you aware that an individual had been taken into custody?
I had heard that, yes.
Did you ever have any interaction with that individual?
I did not.
And were you advised at any point that that person was no longer a person of interest?
Information was passed down that the individual was not considered to be a suspect in the shooting.
And when was that, time-wise?
I don't recall specifically, but I know I was on campus when I had heard.
So whoever arrested him as a potential suspect got that wrong. He wasn't the actual suspect, right?
So he got what wrong?
That he was the shooter.
The person I believe to be the shooter was not the individual who was taken into custody, correct?
And then was there anybody else taken into custody as a person of interest?
There were several people who were detained for questioning and who were interviewed throughout the investigation.
And none of those people were they were all ultimately cleared by you or somebody connected with you.
Correct.
And were there any other guns confiscated on the scene that day?
There were other firearms that were located on the scene, yes.
How many guns were confiscated that day?
I don't know specifically confiscated, but I know that there was a firearm found in a backpack that was accounted for during the day.
What type of firearm was that?
It was a handgun.
Any other guns that were found on the scene?
Not that I recall.
Do you recall an individual named Noah Gonzalez being interviewed?
I don't recall that name specifically.
Let me see if it refreshes your memory that he was an off-duty, I think maybe trooper that was on the scene that day and that was involved in recovering the holster. Does that refresh your memory?
I know that a trooper was interviewed having been on scene. I don't recall if it was Gonzalez. I don't recall the name, but I do know there was a trooper that was interviewed, yes.
Okay. And just a moment, Your Honor. And do you recall the trooper that was interviewed saying that there was actually a gun found in that holster?
I do not.
You do not?
No.
Okay. Can we pull up? Exhibit Hole 13. and just show it only to the witness for right now?
Yeah, and that's her job, right? She's just trying to pick apart the story and raise doubts. This is what they do. They will use any mistakes or inconsistencies. That's their job. And, you know, if I had even if I was guilty of something and I had a defense attorney, I would hope that they do
All
the
right,
same.
can we go to page 2 of that report? Do you recognize this report? Have you reviewed it as part of your investigation duties?
I do recognize the report now, yes.
Okay, and this is a report prepared by actually Mr. Davis, who's going to testify later in this matter. Is that right?
Correct.
Okay, and on page 2, this is the interview of Noah Gonzalez. Is that right?
That's what it stated on page 1, yes.
And he's an off-duty trooper who happened to be there that day.
Correct.
And do you see on the second paragraph, does that refresh your memory about whether Trooper Gonzalez believed there was a gun found in a holster in that area of the amphitheater?
Trooper Gonzalez included in his report that there was a gun, yes.
Okay. Thank you. Okay. When did you first personally go up to the roof of the Losi building? Do you remember the time of that?
I don't recall. I know it was dark when I went up to the roof, so it would have been later that evening.
And at the time you went up there, there was already crime scene tape that had been placed around it?
There was an officer standing security.
Right. And to your knowledge, as the head of the investigation, did they ever find any bullets or casings anywhere on the Losi roof?
Not to my knowledge, no.
Did they ever find any bullets or casings anywhere around the Losi building?
When you say around the Losi building, you mean how close? Like immediately around the Losi building?
Correct.
Not to my knowledge, no.
Okay. And then you've been talking a lot about a timeline here that seemed, you talked about it when you were watching the video, but you also talked about the fact that you developed a timeline. Is that right?
Correct.
And can you pull up hole 1, please? I'm pulling up on your screen your report that you prepared. Do you recognize that?
I do, yes.
And what's the date that you drafted that report?
It looks like September 14th. It says date created.
And that's the place where, if you could go to page 2, please. Do you see down at the bottom where you summarize Sergeant Bricker's report listing the timeline?
Yes.
Okay, and so it was actually Sergeant Bricker that prepared the timeline, is that right?
He prepared a timeline.
And you incorporated that into your report?
No, I created a timeline.
You created your own timeline?
Yes.
Separate from the one that's in this report?
Yes, using information obtained in the investigation.
And when did you create that timeline?
Over the course of the investigation, over a long period of time, after a lot of reviewing video and investigative time.
So as of September 14th, Tyler Robinson had already turned himself in to the authorities. Is that right?
Yes, I believe he turned himself in on September 11th.
So prior to the time that Tyler Robinson turned himself in, had you all prepared a timeline?
A documented written timeline?
Yes.
Not to my knowledge. I don't know when Sergeant Bricker produced his specifically.
And isn't it fair to say that as of the moment that Tyler Robinson voluntarily surrendered to authorities in Washington County, as of that moment, you all did not know who the shooter was. Is that right?
We had identified a person of interest, but we did not specifically know who the shooter was at that time.
Okay. And you became aware that Mr. Robinson was voluntarily surrendering how? How did you become aware of that?
That information came originally, I believe, from the Washington County Sheriff to the administration at the control center at the university on the evening of the investigation, or the second evening of the investigation.
Right, we're going to get back to that in a minute, but I just wanted to get the timeline down. All right, now I want to go back to the videos that we've seen and the question that I just asked before, which is it fair to say that nothing about the video of the individual on the roof revealed to you, you couldn't see facial features, you couldn't see what they were wearing, correct?
Of the individual on the roof?
Correct.
I know that there was a meeting to discuss perhaps a pattern on the front of the shirt that was observed when the individual was jumping off of the roof.
Okay, that's fair. But at that time, as of the 11th, before Mr. Robinson turned himself in, you all had not been able to determine that. Is that right?
Excuse me. Determine who he was, or
No.
determine distinguishing features?
Determine distinguishing features of the video
Yeah.
of the person on the roof.
Yes, we had a person of interest, and those images were released to the press.
You're talking about the ones in the stairwell from the
Correct,
from the parking garage.
correct.
But the video on the roof was not distinguishable. Fair?
That video as a standalone
Yes.
was not, no.
Okay. And in fact, the video on the roof, well, strike that. Is it true that you had some spectators that you interviewed that had gotten a photograph a few seconds before the shooting of someone on the roof?
Sorry, I'm not sure I understand the question.
Did you at some point in your investigation collect from two young men who were present at the event a video that they had taken
Video.
of
Wasn't a
someone on
picture.
the roof about 10 seconds before the shooting?
Yes, a video, yes, not photographs. A video was collected from an individual who had a video
And ultimately, some screenshots were taken out of that video. Is that right?
by,
By you?
not by me, no.
Okay. That's fine. It could have been someone else.
Okay.
But did you see the video that those young men took?
If you're referring to the video that is looking north and shows an individual dressed in dark clothing on the corner of the roof,
Yes.
if that is the video, I have seen that video, yes.
Did you review the interview of those young men?
I did not.
Do you know how they described the person on the roof?
I don't know if I read it or if I heard it, but my understanding was they believed it was Overwatch or some kind of a police Overwatch for the event,
Okay.
if that's my recollection.
And do you remember anything specific about the person's build that they discussed when they described the person on the roof?
I do not know.
Okay. There is a portion of the video after the individual jumped off the roof, which we all saw here, where the individual crosses, I believe it's Campus Drive. Is that right?
Correct?
And there's a moment where the individual waits and there's two cars that pass in front of him, right in front of him.
Correct?
And is this the moment where you are submitting that he was holding a gun in his hand?
As across the road?
Yes.
From my observations, would show that he's carrying an object in his hand that's concealed or in a bag, and it is long and has the appearance, based on my training and experience, it could be a firearm.
But do you see a gun anywhere? The actual gun?
In the video?
Yeah.
No.
All right. And did anybody that was driving by on Campus Drive that day report to you or any other investigative entity, hey, we just drove by a guy with a gun who was leaving campus and he was standing right by my car?
We did not receive any reports to that effect, no.
Okay. Also, when you were revealing the timeline, exactly how long was there between when the person was prone on the roof and when the shot was taken? Do you recall?
If you would like to replay the video, I can time it for you, but I don't recall. It was my guess, I would estimate between 15 and 30 seconds.
So between 15 and 30 seconds to lay flat, take a shot, and get up and run off, right?
Plenty of time.
I think you asked how long he was prone. I
Right.
think it took longer for him to crawl into position
Okay.
and then establish a position
Oh.
and then take the shot. He appeared to be in prone for approximately 15 to 30 seconds, but the video would verify that.
Okay. Thank you. All right. I want to talk to you for just a minute about the video that was taken. And I'm not going to get into I'm not going to show it, just so that in case anybody's concerned about leaving the courtroom, I'm not going to show it. But there was a video that was taken by Mr. Ty Phillips from behind the individual that was speaking to Mr. Kirk.
Correct?
And it showed like a dead-on view of Mr. Kirk and his parts of his security team. Is that right? And then you also have video that you described that shows the back of the tent at the moment the shot happened. Is that right? Behind Mr. Kirk.
Folks, I'm going to always have to stop this every now and then just for the to make sure we have all our T's crossed and I's dotted when it comes to fair use, just so that we're providing commentary in between here. So anyways, how long after this will the trial be? Everybody that I've talked to has said 18 months, a year, 18 months to maybe even 2 years. Gil, do you agree with that?
Yeah, I mean, it's not like it necessarily has to be that long.
Sure.
Both sides have to agree to the scheduling, but usually in my experience, a year to 18 months is the usual amount of time.
And a lot of people are asking, well, why is it taking 10 months to get to this point? Folks, is because the defense was delaying this multiple times. They asked for this amount of time so that they could review all the evidence that they were receiving.
Right. Keep in mind that the defendant always has a right to a speedy trial, so they have to waive that right.
Yeah.
So it's not like they asked for it and it was denied.
This is not the prosecution doing this. This is the defense. Gary and Gil, thank you for your time and for doing this and giving us a forum to discuss the case. You're welcome.
Thank you so much, and please remember to subscribe to my channel.
What is it? Whole Truth? Is that what
Whole
it is?
Truth 1-2, yeah.
Whole Truth 1-2. There you go.
Thank you.
Make sure you mention the 4 men shot to Andrew. The 4 men shot. Oh yeah, I will. I know what you're talking about. How much yaw do you get out of Granddaddy's gun? Well, that just depends. We don't know. That's the problem. It's like it could have been tumbling. It could have been completely unstabilized, if that's what you're asking. I hope I didn't miss much. Glad you're covering this with integrity that some people lack. The attorney is about to attack his credibility by insinuating he doesn't know how to do his job. That's their job. That's what they're going to do. They're going to poke holes. That's what you do. Do you think Brian Harple will be called to testify? I don't think so. There's been no indication of that, and I don't think so. Yeah, so I don't think there's any indication of that. Maybe.
Referring to the UVU video in the breezeway?
Yes.
We have that video, yes.
Okay. And can we pull up the last video, the last clip, 49? I want to show you, just you, this clip. That is a little clip from that video under the breezeway that's behind the tent, right?
Correct.
And just to be clear, this area behind the tent would not have been visible to anybody that was on the Low-C building. Is that fair?
I can't answer that question.
Yeah, sure.
And Ms. Nestor, as you're playing this, are you just being cognizant if the sound is on or not?
I don't want the sound. Please.
Okay, I just wanted
not-
to
Thank you for bringing
clarify.
that. Thank you.
All right.
No sound. I just want only the witness to look at it. So can you just watch this clip for just a minute? This one little clip of behind the breezeway at the time of the shot.
That's fine. And so just as a reminder to all the parties, if it's on your monitor, please be cognizant of that. It will not be displayed on the main monitor. Ms. Nestor, you may proceed.
Thank you. Is it playing? Okay. Do you remember that? Does that refresh your memory of what's in that clip?
Yes.
And having reviewed that at the time the shot was fired, there was no one standing directly behind the tent. Is that correct?
You'd have to show me it again. I wasn't specifically looking for that,
Okay.
but I can answer that question if I can view the video again.
Okay. And just before you do that, I think you testified before that Mr. Kirk would have been dead center behind that banner. Is that right?
Approximately.
Okay. So what I'm asking is if anyone behind that banner, dead center behind Mr. Kirk, if there was any people standing there. Go ahead.
So there's a videographer on the right side of the tent, and then I can only see as far as the video allows me to, so I can't speak to whether there's anybody out of frame who could have been behind the tent.
But what you can see, is there anyone directly behind the middle of the tent?
Yes, there's a videographer stood behind the tent.
To the right?
Yes, behind the tent.
Correct. But directly in the middle of the tent, is there anyone standing?
There's no one stood in the middle behind the tent, no.
Thank you. All right, I want to talk now about the TP. You can take it down off of the screen. Thank you. I want to talk now about the TP USA video that you got. That was the angle that was taken from behind Mr. Kirk while he was talking, looking out at the audience during when the shot was fired. Do you remember that video?
The visual impulse videos?
Yes.
Yes.
All right. Is it true that Visual Impulse provided 4 videos?
Yeah, I believe there were 4 total videos that encompassed everything that they provided to us, yes.
But the one that you showed, that's only one of the 4 that they provided to you?
That one that was shown had a Bates number. It was an item that was provided by Utah County Attorney's Office.
Okay, but were there more that you haven't seen in this courtroom, in this prelim, that you got from?
There's the original footage.
Okay. But were there other angles that are not shown here in this prelim?
Yes.
Okay, that's what I was trying to get to. Thank you. All right. Were you involved when the gun was located in the forest area?
I was not involved in the search for the gun, no.
Did you get notice when it was located?
From the footage that we reviewed, we identified an area that we believed could be potentially of evidentiary value, and then it was secured. And then I was notified that as a result of that search, a gun had been located, yes.
Were you involved in the processing of that gun? In other words,
I was not.
boxing it, shipping it, sending it wherever it was going to go to be
I was
analyzed?
not, no.
Okay, thank you. All right, now I want to shift to the autopsy for just a moment. You were not present at the autopsy, is that right?
I was not.
Okay. So anything you know about the autopsy was not from personal observation?
No, other than from my meeting with the medical examiner and his report. No, I was not present.
Did you meet with the medical examiner after he had conducted the autopsy?
I did, yes.
And when you met with him, did you provide him information about what you all had learned in your investigation so far?
We didn't have any reason to provide any investigative information to him. The purpose of the meeting was to establish what information he could provide to us.
Well, in fact, on the front page of the medical examiner's report, he talks about the investigation and information he learned. Did he learn that from you, or did he learn it from someone else?
It would be my recollection that he did not learn that from us, but I couldn't speak to how he did learn about it.
Okay. So you didn't share with him your conclusions about what happened or how Mr. Kirk was injured or anything like that?
That's my recollection.
Okay. Thank you. And isn't it also true that fingerprints that were taken from Mr. Kirk and autopsy photos were provided to you on a CD?
Yes.
Was there anything else provided to you from the autopsy other than that?
Other than the CD and the report?
Yes.
Not to me, no.
Okay. You did mention not to you. Were you aware of anything else from the autopsy going to anyone else?
I believe standard practice is anything of evidentiary value that the medical examiner collects is transferred through a chain of custody.
And are you aware of anything that was transferred after Mr. Kirk's autopsy?
I'm aware that there were items transferred for evidence, yes.
What items?
I believe some fragments of a bullet casing. I know Mr. Kirk's personal items to be returned to the family. That's all I can recall off the top of my
Do
head.
you know how many fragments from the bullets?
I don't.
Now, I'd like to talk a little bit about the Ring camera that you obtained, and you interviewed a woman named Ms. Noble, is that right? To get that Ring camera that we watched with the car on the outside?
We interviewed her to verify the authenticity of the video, yes.
And were you involved in that interview?
With Miss Noble,
Mhm.
yes.
And do you recall what they told you about what they remember seeing in and around that car that night?
I don't recall. I just know we were there to verify the video. I didn't conduct an interview with Miss Noble at that time.
Okay. Can we please bring up whole? Sorry, just a moment. Let's see. Poll 48. This is Miss Noble's interview. Do you have it? All right. Do you remember that? Looking at that interview, does that refresh your recollection?
I remember reading the report at some point, yes.
And do you remember that the Nobles told you that the driver of the vehicle was bald?
I do remember that being in the report, yes.
And you didn't mention that today when you were talking about that Ring camera, did you?
I did not.
And did they also tell you there were 3 other people in the car?
Yes, I believe they thought that was the case.
Okay. I want to go back, if I can, to the scene itself, the preservation of the actual scene where where Mr. Kirk passed. Did you all have canine dogs at any point that sniffed that area?
I don't know specifically that area, but I do know that canines were present, or a canine was present on the day.
But you don't know what task the canine was given?
My understanding was that it may have been used in an effort to track an individual that had jumped off the roof, but I don't know for certain.
And obviously that didn't produce any results, or we would have heard about that, right?
Yeah, not that I was made aware of.
Okay. Do you know when the tent and the stuff was actually removed from the scene?
I don't. I would imagine it had been at least a couple of days, if not longer than that, before anything was removed from the scene.
You didn't have to give permission to remove the tent?
Me, personally?
Right.
No.
So you're not sure when it was removed?
Nope.
And were you involved in the decision to pave over the dirt that was under the tent?
At UVU?
Uh-huh.
No.
Did you know that happened?
Only because it was in the news.
All right. But you don't know when or who ordered that?
Nope.
And it's true that during the time before Mr. Robinson turned himself in, you all received lots and lots of tips from the public. Is that fair?
Correct.
You received tips of death threats that Mr. Kirk had received before, the day before the shooting. Is that right?
I'm sorry, did we receive threats that Mr. Kirk had received before the event, or?
Let me clarify. That
Thank
was a
you.
confusing question. As you were going through tips that the public was giving you, did you receive tips about online death threats that had been made against Mr. Kirk prior to his death?
There was a huge variety of tips and information and suggestions that were being provided by the public.
Okay. And a lot of those, some of those filtered through you, right?
Some of them filtered their way down to us, but predominantly that was being handled by our State Information and Analysis Center that had been set up.
And you also got multiple tips about potential suspects, people who thought they recognized people in the picture, right?
Yes, there were different calls and information provided by the public.
And you had quite a few of those.
Correct.
And then Mr. Robinson turned himself in, right?
Yes.
And is it your understanding that the individual they used to facilitate Mr. Robinson turning himself in was someone known to Mr. Robinson personally that had been connected to law enforcement.
I know he was known to the family. I don't know his connection specifically with Mr. Robinson, but I am aware that someone was used to facilitate Mr. Robinson turning himself in.
And were you aware that he was one of his Boy Scout leaders? Did you know that?
I think I had heard that at some point. There was a connection. I didn't recall specifically what it was.
And Mr. Robinson, in fact, no police went to go arrest him. He drove himself, or he was driven with his parents to the Washington County Sheriff's Department, correct?
That's my understanding, yes.
And he voluntarily walked in.
That's also my understanding, yes.
And that was the first moment you ever knew his name connected with this case.
Yeah, aside from the image that we had, that was the first time that we had a name of an individual who had taken responsibility, yes.
And did you personally ever meet with Mr. Robinson?
I did not.
And as far as you know, Mr. Robinson did what he said he was going to do. He told the police he was coming peacefully, he was coming with his parents, and that's exactly what happened.
I don't know any of the specifics of how he was arranged to turn himself in terms of what you've described. I just know that it was being facilitated with the sheriff's office.
Okay. Court's indulgence for just a moment, Your Honor.
Yes.
Thank you, Agent Hall. I tender the witness, Your Honor.
Thank you. Redirect by the state.
Just going to go back to a few things that Ms. Nestor asked you about. First of all, the unfired bullet that you referred to. It's your understanding that that bullet was accounted for?
That's my recollection, yes.
Okay, and it possibly belonged to an officer that could have maybe been clearing his weapon.
Coach, whatever your name is, Gary, there seems to be some confusion about the casing part of the bullet. I'm here to learn, and I'm humble. If someone corrects me, there's no harm done to me. LOL. Yeah. Present your question specifically to that, and I'll try to address that. So I'm trying to keep up with the chat, but I can either do one of two things: either pay attention to the chat or pay attention and try to listen to all the particulars and the details that's being discussed in here, which I'm trying to do. So anyways, if you already presented that question, present that question again specific to that, and I'll try to address it as quickly as I can.
Yes, that's what I recall being told about that particular item, yes.
Are you aware of if on the 10th there were police officers present that were actually securing buildings and securing rooms there at UVU?
I know prior to my arrival, it was a dynamic and active scene that I believe was originally being treated that there was an active shooter on campus. Mm-hmm. So there was a large, rapid response of law enforcement who were actively trying to clear, secure, and ensure that the campus was safe. If that answers the question.
The entire campus?
Yes, correct.
Okay. And what types of officers were there clearing the campus?
Originally, there would have been probably local units who would have responded, but subsequently specialty teams would have been deployed to do a more methodical search of the campus and what we would call a clearing of the campus.
And those specialty teams and any other officers, how are they equipped? Like what type of equipment were they carrying?
I believe most officers carry a sidearm, a handgun, mm-hmm. and most officers in this day and age are equipped with a rifle platform as well.
Okay. When you said that it was possible that round was from an officer clearing his weapon, what exactly do you mean by that?
Our standard practice in our department is to carry a rifle cruiser ready, which is we carry our rifles in a situation which is called cruiser ready.
What does that mean?
It means we don't have a round chambered. So if an officer deployed with his rifle, he would chamber a round. once he had done whatever task it was that he was doing, in order to put that weapon back, he would eject the magazine and eject the round. Sometimes in doing so, rounds are dropped or not accounted for.
Have you personally done that yourself?
We do that at training, and I've done that in the field as well, yes.
And you're aware of, is that something that's common among police officers in this situation?
I believe for most agencies, that's how they carry their weapons, but I can't speak specifically to agencies outside my own.
Do you have any idea how many officers were dedicated or sent out to clear the campus?
I can tell you I had to park on University Avenue and walk all the way onto campus between hundreds of police cars. So I would say hundreds, if not 1,000 officers, high hundreds would have responded to the campus that day.
Now I'm going to ask you about, Ms. Nestor asked you about your observation of seeing Mr. Robinson with something in his hand. And I think she was asking you about Mr. Robinson just prior to crossing Campus Drive, following the shooting. Do you remember that question?
Yes, I think I was asked whether he had a gun in, or I had seen a gun in his hand in the video.
And you said that you did see something in his hand?
Correct.
Okay, I want you to go back as far as you can remember. At what point after Mr. Robinson stood up on top of the Losi building and ran across, I believe to the northeast corner, when did you first notice in that video something in his hand?
The first time you can clearly notice he has something in his hand, without a doubt, is when he's on the white triangular portion on the northeast corner of the Losi building preparing to jump. It is very apparent he has an item in his hand.
Okay, and that's based on your observation of the videos?
Correct.
Okay. And is it easier to see in that enhanced video?
The zoomed version of the video makes it a lot clearer to see, yes.
Okay. And then after he drops down off of the roof of the Losi building, is there any time between that point in time and making his way to Campus Drive that you believe you see, again, something in his hand?
As Mr. Robinson lands on the grass, it's almost like he either drops it or goes into a crouched position, and then when he returns up from that, it is again clear that there is some kind of an item in his hand, yes.
Okay. Can you be more specific or describe in more detail?
It appears to be black, and it appears to be longer.
Okay, anything else about that item?
No.
Okay. I believe it was Exhibit 9, State's Exhibit 9 that Ms. Nestor pulled up on the screen, and she had you look at that. And I believe what you looked at was beginning a still image, but then a few moments or a few seconds of that video. And that's the UVU tunnel video. Is that right?
The breezeway underneath the Hall of Flags, yes.
And the view is from behind, where I believe you testified that Mr. Kirk was on the other side of what appears to be a banner.
Sure.
In that tunnel view.
Yes.
And on the other side of that banner is the tent, and then the rest of the courtyard. Is that
correct?
Fair to say? Do you remember seeing the banner?
Yes.
In the video? Okay. And
you're referring to the back of the pop-up tent?
Correct. Yes.
Okay. Yes.
Okay. And do you remember, what do you remember about that banner?
It has some kind of an emblem on it, and it forms the back portion of the pop-up tent.
Is it opaque? Is it transparent?
No, you can't see through it. It's white,
right.
and you cannot see through it, no.
And how much of the tunnel does that banner, I guess if it's opaque, obstruct?
I couldn't say. I'm assuming it's a 20 by 20 gazebo, so it would block out the area of the back of the tent that you can see. You would not be able to see through it. You would not be able to see through it from the audience side of the amphitheater.
And what about the tunnel side of that banner? Can you see through the tunnel side in the opposite direction?
You cannot, no.
Can you see Mr. Kirk on the other side of that banner?
You can't, no.
Okay. Well, we exhibited, or Ms. Nestor had you watch just, I believe, just a brief few seconds of that video. that exhibit is actually much longer than what we just looked at, or what Ms. Nestor had you look at. Is that right?
Correct.
And leading up, and again, I'm referring to that view, that tunnel view of that surveillance camera, leading up to the shot. What's going on behind that banner?
There are representatives, I believe, of TPUSA, but there are representatives of TPUSA. There are law enforcement representatives. I don't know if there's any student body, but essentially people are moving to and fro behind that area. A couple of individuals are retrieving items from a vehicle, but there's consistent movement behind and in that area.
Directly behind the banner?
Correct.
Ms. Nestor asked you about the wooded area that Mr. Robinson entered. Well, Ms. Nestor brought that up, and I believe your testimony has been, between today and yesterday, that you witnessed Mr. Robinson enter a wooded area on at least 2 occasions. Is that fair to say?
Yes, on his second visit to the campus and on the visit where the incident took place.
At least on those 2 occasions, did the wooded area that he entered, were they different parts of the wooded area, or was it the same parts of the?
They appeared to be the same.
You're aware that a rifle was eventually discovered?
Yes.
And was it your understanding that that rifle was discovered in a wooded area?
It was in the wooded area where we believe Mr. Robinson entered the wooded area, yes.
And that rifle was discovered on the 10th?
Yes.
Ms. Nestor asked you about a variety of tips including threats to Mr. Kirk, I think before the event?
Yes.
And did you follow up on those tips?
After tips have been put through a process and been analyzed and screened, anything that appeared to have relevance to either the investigation or a credible threat was managed by the various entities involved, yes.
Okay. So managed by law enforcement, so.
Correct.
Did you personally follow up on any of the tips?
I don't think I personally did, but I worked closely with people who did.
The point is, I guess, is that those tips were followed up on. Is that fair to say?
To the best of our ability, yes.
Okay. And then Ms. Nestor also asked you about tips, I believe, of people reporting to police that they felt like they knew who the shooter was.
Yes.
Okay. So identities of possible shooters.
Correct.
Did law enforcement follow up on those tips as well?
They did.
Ms. Nestor, finally, Ms. Nestor asked you, she asked you whether Mr. Robinson voluntarily went to the sheriff's office down in southern Utah. Is that right?
Washington
Yes.
County.
Okay. That was a Washington County Sheriff's Office.
Yes.
Okay. You understood that he showed up there voluntarily. Is that right?
Correct.
What was your understanding as to why he was showing up there voluntarily?
He had informed, I believe, his immediate family that he had been involved in the shooting and that he wanted to turn himself in.
Okay. Nothing further. In the video that we've already talked about, the video where Mr. Robinson stands up and runs across the top of the LoC building, do you notice whether at that point, after he stood up until you see him last, at least in that part of the video, do you notice whether he's walking or running with a limp?
He is not. From the time he left after going over the railing, when we see him on the video move out to the position.
Correct.
And then leave the position, there is no longer a visible limp or gait.
Thank you.
Ms. Nestor.
No follow-up, Your Honor.
All right. May Agent Hull be excused?
Yes, Your Honor.
All right, Agent Hull, thank you.
We have just a minute to meet.
All right, let's take a 5-minute break and allowing parties to confer. Court is in a brief recess.
All right. So that's where we're at. We found out a lot of information so far. I don't know where they're going to go from here. They're going to. We know they're going to. Any big things that stood out to you so far, Gil?
Well, I mean, the defense is doing what defense is supposed to do. They're trying to find some inconsistencies, point out leads that weren't followed up on. They were trying to imply that maybe the medical examiner's report was tainted by investigators, input. I mean, pretty much everything that you would expect from a defense lawyer. I don't think that it's going to do much. But I'm always curious to know what kind of the average person thinks, because that's who's going to be on the jury. And
Sure.
so what I find persuasive and what I don't find persuasive, is obviously very different than what a juror would likely find persuasive. So I don't know.
That's a great point. Here's what I want to hear from everybody. Everybody that believes that the evidence suggests that Tyler Robinson is the killer, allegedly, put down in the comments what you've heard so far today that you think is the most compelling evidence against Tyler Robinson. For those of you that do not believe that Tyler Robinson was a shooter, write down in the comments whatever you think is the most compelling evidence that supports your position. So I would like to, that is a great point right there. That's a good one. And I probably, I'm going to run a poll on YouTube, and we will kind of ask something very similar to that as well. So I will post that poll in just a moment. What other key points did you hear today?
Well, like I wrote down, for example, the inconsistency where they spoke with the ring owners, and they said in the interview that they saw multiple men, one of them being bald, driving that vehicle. But I don't really see the point or the relevance of that, because the video kind of speaks for itself. So, but again, this is just them, the defense poking holes wherever they can find them. The pavement, I found it interesting that she brought that up, the repavement, because that's probably something that wouldn't normally be followed up on, if not, for the kind of the public conspiracies and stuff. So maybe some of it's kind of getting through. I'm trying to think, this whole prelim is much more thorough than 99% of prelims. So they're going through a lot more than you would normally see. But I mean, the security cameras is just damning in and of itself. If I'm the defense, I'm trying to get that excluded, whichever ways are possible. That's what I'm working on. And then because that with the confessions, there are many instances of like kind of nut jobs falsely confessing to crimes.
Sure.
But it wouldn't be accompanied by footage of them at the scene of the crime, with something in their pants and everything, and jumping off of buildings. So those two things together, it's really hard to overcome. I'm trying to think of anything else that really stood out to me. I thought the finding a bullet was, that's something I would probably jump on as a defense lawyer, because it's not often you find a bullet.
Yeah, and I want to be clear on that. They didn't find a bullet; they found ammunition, right? So this was not a spent. This is not a bullet that has been shot. This is a single piece of ammunition that was found. I would like to know the caliber of that. I would like to know a lot of things, and I want to know obviously where exactly that was found. I think they kind of mentioned it yesterday where that was found. I wasn't kind of oriented exactly where they found that. I think all of those things, that's an important point, and I like that you picked up on that from a defense standpoint.
Can I ask you? I wasn't following the line of questioning about the tent or who was behind the tent. I'm not sure where she was going with that. Maybe that'll be elaborated on. Do you know where?
No, I didn't know where she was going with that at all, to be honest with you. I'm curious to see where that goes.
The failure to follow up on leads, that, or the I wouldn't say failure, but that the defense is going to point to that as much as possible, say, you guys got tunnel visioned, and once somebody turned themselves in, you really shut yourself off to investigating other leads, and you just kind of went with it, and you made everything fit that narrative because simpler.
Yeah,
that's probably the main angle they're going to go with.
Sure. What I wish they had put out was exactly what time, because there's a lot of discussion about this, exactly what time that Tyler Robinson did turn himself in. So I'm curious to see if they're going to clarify that.
It was after the news published those photos of the person of interest, right?
Yeah, it's going to be, look, according to all of the documents and even clarification by the attorney's office, the state's attorney's office, it was after 9 p.m. on the 11th. There are people out there that are presenting, that are attempting to say that he actually turned himself in at like 3 p.m. on the 11th and that he was in custody. So therefore, the Discord chat messages that were sent at 7:57 p.m. local time, Mountain Time, could not have been him. So it's a lie that is being used to perpetuate this idea that those Discord confessions were Fed slop. And I guess what they're saying is because he turned himself into the Washington County Sheriff's Office, that I guess a sheriff's deputy took his phone and was creating these fake confessions on his phone. So
Were all
the point to that.
Oh, sorry.
No, go ahead.
No, were all the messages that you were reading from the Apple search warrant yesterday, was that Discord only or no?
Those were text. Those were text only.
Those were text. So those alone, it seems like there's more than enough.
So let me ask you this, Gil, as a defense attorney, for people saying those were faked.
Yeah.
Those were some FBI agents faking those text messages. What are some of the tools that you have at your disposal? For instance, if you get similar evidence, what are some ways that you can impeach that evidence? You guys, how do you forensically analyze to confirm the credibility of that information?
Well, so first off, I just want everyone to know that when you delete text messages, they're not deleted from your phone. Any law enforcement agency can retrieve those deleted messages. They stay on your phone, unless I think you have to really overwrite everything by maximizing the memory on your phone. Secondly, it's also saved on the servers of the cell phone companies. But can you re-ask your question?
Let's say you're Tyler Robinson's lawyer and you're like, hey, you know what? I think the feds faked these. We'll pause this real quick because they're re-adjourning. I think they faked these. Mm-hmm. How would you be able to confirm or deny whether or not those messages were faked?
Well, it would be one thing to say if it was faked from his phone.
Yeah.
I don't really know if there's any way to prove that it was not, because, if I grab your phone, Gary, and I text somebody from your phone, then it's kind of your word against mine, right? So from that, now if it was somehow fake from a different source, that can be determined by, sourcing there's a print on the text messages through the towers and everything like that.
Got it. And that's what I'm saying. So if you are there's definitely times and places where Tyler is texting from that I have not heard anybody claim that, he didn't have his phone at the time. But what they're saying is that those text messages are faked, that they were, I don't know, produced from a different source somewhere. The feds did it. That's basically what I hear. As a defense attorney, you would be able to confirm or deny that pretty easily, yes or no? I'm not trying to lead you.
Well, you would have to subpoena the cell phone towers,
Sure.
and get that data to kind of corroborate that it came from that device and was sent to that device. But otherwise, it's funny because in a case I actually brought this up as an example where I forget what there's like a spoof app where I can text you from someone else's number.
Sure.
And it looks just like you received it from that number or phone calls. So those are pretty easy to do, but I don't think it would show up on the cell tower records as coming from the same device. So that would be the way to confirm it.
Got it. Okay. So, but you would be able to digitally analyze that, and with a little bit of effort, you'd be able to confirm or deny whether that came from his phone.
Yeah. And definitely law enforcement would have that ability. No problem.
Perfect.
Excused, and we are proceeding. Mr. McBride.
Yes, Your Honor.
Let me turn up the
I
volume.
intend to call Jennifer Falmuina, but before I do that, I'd move the admission of State's Exhibit 5.1, if I can approach the bench.
Yes. Thank you.
Your Honor, there will be an objection, and we want to be heard on the objections. And I didn't know this was coming now. It could be a lengthy call.
Oh, I guess
All
I
right.
just put this up
Let
on
me
the screen,
just,
huh? Sorry, guys.
Do you
I can
wish
see
to
it on my
identify
screen.
what
It's all that
State's
matters.
Exhibit 5.1 is?
You didn't miss anything. You approached the bench. You gave him a piece of paper. Defense objected. That's what happened.
Is?
Yes, Your Honor. Exhibit 5.1 is a self-authenticating 1102 statement issued by David Englehart from Turning Point USA.
All right.
And again, I say it's a self-authenticating document. As you can see there, it's got the admonition on page 1. The body of the 1102 statement is there on pages 1 and 2. I would say number 4 is kind of the foundational statement, paragraph 4, but the self-authentication portion is the notary acknowledgement on page 3.
All right. Turning to Mr. Novak.
Thank you, Your Honor.
Thank you,
Mr.
that
McBride.
pattern recognition coming from Ramza.
So the court, obviously, because the court can decide how much of this we discuss in open court, how much we discuss at the bar, so to speak, sidebar. There's initially a fundamental relevance problem with this 1102. There are also there are other issues, but I think that just to help the court parse the evidentiary issues, we should start with the relevance. There are sub-issues. There's also a problem under 1102 because if the court looks at the last paragraph of this, Mr. Engelhardt, who is the purported author, refers to himself in the third person. So it's not clear to me who actually wrote this report. And as Your Honor knows, 1102 says that prosecutors are not to assist witnesses in writing their own 1102 reports. That's not my primary concern, although I think it is an important issue because that's what the rules require. But the real question is relevance. And I guess the question is, does the court want me to do the speaking objection? Because the court said no speaking objections. Should we approach sidebar? How does the court want to handle it? The people can move their exhibits into evidence whenever they wish. I wasn't aware we were going to do it at this moment. I'm ready to proceed, but the question is how the court wants to handle these objections. I'm prepared to keep going in open court, but it's what the court referred to as a speaking objection.
No, I appreciate that. As it relates to, well, so here's my question for you, Mr. Novak, as you're, and again, I appreciate your discretion and highlighting that point. do you anticipate your argument being of the nature that would defeat the purpose of, if the court does not admit this, that you've already let the cat out of the bag with your argument? Or do you feel that you can make your argument without compromising what is in the 1102, so the purpose of if excluding it is still preserved?
I'll go as far as I think we can go, and then we'll just see. I mean, I do think I am not trying to conceal from anybody in the courtroom or the public our concerns about relevance. So why don't I, taking the court's lead, go forward publicly with my concerns about relevance. And if we reach a moment where it feels like further argument may deprive Mr. Robinson of his fair trial rights, we can approach.
All right, we'll proceed.
Okay, so then what I'm going to do is I'm going to point out that this proposed exhibit, which is the 1102 statement of Mr. Engelhardt, is basically 4 paragraphs. The 4th paragraph identifies Mr. Engelhardt, although I say in the 3rd person, as a pastor and as an attorney who was a friend and a counselor to Mr. Kirk and was involved in leadership of Turning Point USA. So that identifies who the author is. Beyond that, it's not really relevant to any of the issues before this court. Paragraphs 1, 2, and 3. Paragraph 1 talks about Turning Point USA's status with the Internal Revenue Service, the purposes of Turning Point USA within the context of the Internal Revenue Code, and sort of what I'll just refer to generically as the goals and objectives of Turning Point USA. And it also then talks in the 2nd paragraph about Mr. Kirk's relationship with TPUSA. None of this is unknown information, that he was a founder, that he was the chief executive officer, that he was the president of the board until his death. So I'm still not sure what the relevance is. And I guess actually what I should say is I don't believe there is any relevance of any of this information. Paragraphs 2 and 3 are, and actually I'm going to preface this. My discussion of this is within the context of the rules of evidence. And there's nothing that I'm going to say here that is meant to derogate, criticize, question Mr. Engelhardt's beliefs. What he says were Mr. Kirk's beliefs. What Mr. Engelhardt says he believes are tenets of Christianity. That's not what we're talking about. What we're talking about is whether this document is admissible in this proceeding under the rules of evidence. Okay. So paragraphs 2 and 3 include not only Mr. Engelhardt's opinions, and now I'm going from relevance to opinion evidence. It's not clear to me whether it's lay opinion evidence, whether it's expert opinion evidence, but it's Mr. Engelhardt's opinions about a branch of Christianity, his opinions about a portion of the Bible. He quotes the Bible, and he talks about Mr. Kirk's religious beliefs. And I could go into more detail, but the court has the exhibit in front of it itself. So none of this is relevant. If the court looks at the information that is the...
Jen's entered the chat, folks. Jen, I hope you're feeling better. Jump in whenever you'd like to.
Let me just say
Yeah,
real
go.
quickly, I feel like this objection might be sustained because it sounds like what the statement they're talking about is not relevant. I agree with the defense on this one. But-
Real quick, refresh me. I was in the middle of communicating with somebody. What just happened? What is the objection to exactly?
Yeah, there's a statement by someone named Mr. Englehart, and I'm not sure exactly what's in it. I guess maybe there is some other information in there, but from what the defense is describing, it does sound like it has really no relevance to a probable cause hearing.
Fair enough. Cool. All right.
Document which lays out the allegations against Mr. Robinson. When I use the word information, I'm talking about the court document. There are, with respect to certain counts, what Utah Code refers to as a victim targeting enhancement. That is alleged with respect to count 1. It is alleged with respect to count 2. It is alleged with respect to count 7. And may I step away just to get my laptop?
You may.
And as the court knows, but I want the record to be clear, when I refer to the what the information calls the victim targeting enhancement, that's Utah Code Section 76-3-203.14, which the code calls the victim targeting penalty enhancement. The information alleges, and this is, I'm emphasizing this, that Mr. Robinson intentionally selected Mr. Kirk because of Mr. Robinson's belief or perception regarding Mr. Kirk's political expression. And I'm going to focus, if I may, the court's attention on 2 things. One is, whose state of mind are we talking about or whose state of mind is the statute talking about? And what aspect of the victim targeting enhancement is being invoked here? The latter is the state invoking Mr. Kirk's political expression, and now I'm quoting the statute, as the personal attribute that the state alleges is the gateway to this penalty enhancement. And if the court will bear with me, because there's a reason why we have these hearings in public, there are various categories for alleging, I should say, there are various categories of personal attributes, that's the phrase the legislature uses, which authorize the pursuit of a penalty enhancement. And those personal attributes are listed in the statute A through R. I'm not going to read all of them because the court knows the law, but political expression is subsection K. That is separate and distinct from the personal attribute that the legislature calls religion, which is subsection M. So what we have is an allegation that the personal attribute, which is one of the elements of this enhancement, the allegation that Mr. Robinson selected Mr. Kirk was based on his political expression. That's actually the exact same phrase, political expression, as is in the statute subsection K. The 1102 statement is predominantly about what Mr. Englehart describes as traditional Orthodox Christian values. that he believes in, that he believes Mr. Kirk believed in. And I understand in today's world that there is a crossover between religion and politics. I think we can all acknowledge that. But the legislature and the information here are focused on political expression. So I'm concerned that 1102.
I don't know his name, but this is one of the defense attorneys.
Gary, I gotta sign off for a little bit.
Yep,
I'll
no
be
worries.
back on later. Thank you so much.
Sounds good. And we saw him briefly, I believe, yesterday. He's also argued other elements of this in some of the other hearings.
The 1102 statement of Mr. Engelhardt goes far beyond the scope of what would be admissible if the state has it to prove that Mr. Robinson targeted Mr. Kirk because of Mr. Robinson's belief or perception concerning Mr. Kirk's political expression. The second element of this is that the victim targeting enhancement focuses on the allegation of what is in Mr. Robinson's state of mind, not what is in Mr. Kirk's views or deeply held beliefs, sincere religious beliefs. And so the evidence that the state needs to present is not what Mr. Kirk believed or said or what TPUSA stood for. It's what was in Mr. Robinson's head, if anything, about selecting Mr. Kirk because of Mr. Kirk's political expression, because that's the information. So why TPUSA exists, what its founding beliefs are, what its leaders' beliefs are, what Mr. Engelhardt believes Christianity is or is not relevant. And that's why we think it should not be received into evidence. There's a second level here, which is Mr. Engelhardt's statements about what is in the Bible, specifically Matthew chapter 9. And so I would just ask this court the hypothetical question. If the state asked the court to take judicial notice of a portion of the Bible in order to prove this enhancement, because I can't see where else it fits into this case, I think, if I may, the answer would be no, it's not relevant. So instead, what we have is the state trying to use the affidavit of Mr. Engelhardt pursuant to 1102 to get the court to essentially receive into evidence the same information. It doesn't really matter here in this proceeding what the book of Matthew says. It doesn't matter what Mr. Engelhardt thinks. And again, I say this with all due respect to Mr. Engelhardt, who I've never met.
Yeah, exactly. He's just filibustering at this point, repeating himself over and over and over again.
Or how one reconciles the book of Matthew as he sees it.
Basically, there was a statement made that was inferring that whoever made that statement understood the mindset of Tyler Robinson and the motive behind that, the mindset behind his motive. And all he's doing is saying, hey, that shouldn't be entered into the record because you don't know what really motivated him or as to why exactly he allegedly committed this. That's what he's essentially saying. Somebody correct me if I'm wrong.
It doesn't really matter for this proceeding what Mr. Engelhardt's views are, what Mr. Kirk's religious views were, what religious views TPUSA endorses, seeks to encourage others to adopt. None of that really matters. There are multiple opinions in this 1102 from Mr. Engelhardt, and it's not clear whether the state has thought about whether it's expert opinion or lay opinion. I happen to think that it's expert opinion that is not helpful to the trier of fact in this proceeding. that's your honor. There is nothing in this that helps the court resolve with
you've already
respect
said
to
that.
the victim targeting
We
enhancement,
got it.
whether Mr. Robinson intentionally selected.
He's going to talk 10 more minutes and not say anything else than what he just said and repeat it and say it in 5 different ways.
Mr. Kirk's political expression.
Okay.
If the state comes back up here and says, no, it's lay opinion, we still have the question of whether it's helpful to this court.
Cool.
Because the court has to decide whether there is evidence
All right.
of the target enhancement in the way I think I've structured it.
Shut up and let the court decide.
So it's not relevant. It's not admissible lay opinion. It's not admissible expert opinion. There are two aspects of Rule 403, one of which I'm prepared to talk about publicly and one of which I think is appropriately discussed at sidebar because
Correct,
it
Jeff.
does
Yep.
get into
I agree
undue
with you.
prejudice. The 403 here is that receiving this document into evidence is
I'll make sure I clean up all of the we'll get to all the super chats, but I want to hit this one because it's coming from South Africa. Chantel, thank you very much. Watching from South Africa. Thanks for covering. Creators over here aren't really covering this, but are way too quick to share Candace's delusions. Well, I'm just happy to know that there is someone sane in South Africa that's covering this. And I think ZAR 35 ZAR is like $800 US, I think. I'm just joking. I know it's not. Thank you very much, Chantel, and I appreciate you watching us from South Africa.
going to create confusion. It's going to create chaos, not by the trier of fact, but by the future jury pool in this case. For this court to make a ruling that Mr. Englehart's opinions about religion, about TPUSA's views on religious matters, that Mr. Kirk's views on religious matters are in any way what this case is about.
Holy crap, dude. Shut up.
And even if this court doesn't show the 1102 in open court, or the reporters who are here don't get to see it, or if the public doesn't get to see it, receiving it into evidence in light of the victim targeting enhancement that the state drafted and charged is just going to create confusion. There may be, outside of this case, litigation where TPUSA's purposes and its mission and its adherence to its mission are important, and Mr. Englehart's opinions about that may be important in some other context, in litigation, in public discussions. It's not important here. And when I say important, I'm saying it's not relevant. So there's a 403 issue with respect to confusion. There's a constitutional concern that this type of evidence being sanctioned by the court is going to suggest to the jury pool that this is a case about religion. This is not a case about religion. The state doesn't even allege this is a case about religion. The state alleges one enhancement based on Mr. Robinson's perceptions of Mr. Kirk's political expression. So I'm very concerned that this document, even being sanctioned by the court as admissible for any purpose in this proceeding, is going to interfere with Mr. Robinson's constitutional right to a fair trial, which I think is a sort of an umbrella over parts of Rule 403. If at the time, if there is a trial, if Mr. Robinson is bound over, and if there is a trial, and if the state...
The judge is going to be like, I forgot what the objection was. What was this? Could you imagine getting lectured from this guy? It's like a parent or some principal or some, I don't know, some supervisor that is going to sit there and lecture you. All the things and why you did something wrong. Oh my God.
Is more
please shut
prejudicial
up.
than probative. The other part of the 403 issue, we can discuss at sidebar whenever the court's ready.
Thank you, Mr. Novak.
Oh, thank you
Turning
for
to the state.
stopping.
And so just to give an overview, what I'm intending to do is address what Mr. Novak has presented, the state respond. I may have some questions limited to what's been presented now. Of course, that doesn't preclude addressing the second portion of that in whatever means is necessary to protect constitutional rights. But we're just focused on this portion right now.
Understood.
Thank you. Mr. McBride.
Your Honor, the evidence is relevant to 2 points. One is to the defendant's motive, which is not an element of the offense, but nonetheless is powerful evidence, persuasive evidence. And 2, it is relevant to the victim targeting enhancement, which has been described and appears in the information. The statement clarifies what Turning Point USA, what Charlie Kirk's business was. And I think as you read this statement, it's clear that Charlie Kirk presented both religious and political arguments and positions in his presentations. And that is what paragraph 3 says, that he engaged others in debate, discussion of traditional family values, Orthodox Christian views on sexuality, marriage, gender, sex, America's founding principles, political doctrines, and so forth. He often spoke specifically.
Who is typing so
and
loud?
attempted to persuade attendees to follow a mindset rooted in Orthodox Christian and politically conservative values.
Excuse me, Your Honor, can I lodge an objection to Mr. McBride reading the exhibit which we are discussing the admissibility of? And I'd ask the court to strike his statements and admonish him.
All right. So as it relates to reading from the actual 1102, because it's not admitted into evidence, I will, well, before I do that, let me turn to you about the objection to make sure that you are heard as well.
Yes, Rule 104 requires the court to consider evidence before determining its admissibility. How can you determine whether an exhibit is admissible without knowing what is contained in that exhibit? That's what I'm putting in front of Your Honor, is explaining this is why the exhibit is admissible, because it contains this language that is relevant and probative. I don't know how I can make an argument that something's relevant and probative without saying this is what the exhibit says.
Well, Mr. Novak, and I want to make sure I do see you have a microphone. Go ahead.
Your Honor is not a jury. Your Honor can look at the exhibit and determine for itself whether it's relevant, whether it meets other criteria for admissibility. It's not necessary for Mr. McBride to read aloud in open court an exhibit which the court has available to it. I'm not saying that the court shouldn't read it. I'm saying that it's not admissible. I understand that the court has 2 roles, one under 104 and one as the magistrate, but that doesn't require Mr. McBride to read in open court the exhibit which we are discussing the admissibility of, especially where I have just expressed our concern that the exhibit has a tendency to confuse the issues in this case and create fair trial risks for Mr. Robinson.
All right. Thank you, Mr. Novak. Any final thoughts before I rule on this specific issue about reading from the 1102 by Mr. McBride?
Yes, Your Honor. I have to be able to argue here. I have to be able to refer to the exhibits. I can't do my job as an attorney without being able to refer to the exhibits. If the court doesn't want this to be in public, then we've got to close this proceeding. But I have to be able to argue the exhibits. I don't know how I can make an argument without actually pointing to the language of the exhibits, unless I want to say, you know what I mean, or referring to line 13. It's just so cumbersome to do, Your Honor. And I think my job and my duty to my client, which is the state of Utah, and And to their right to fairness requires me to make a good and powerful argument, and that requires me to refer to the exhibit. And I'll submit it with that.
All right. Thank you to both of you. In looking at this, typically in court, when evidence is being taken, until it's admitted, it doesn't come in. For example, if there's a witness on the stand and one is trying to get a piece of evidence in, that witness cannot read from the document and prior to it being admitted into evidence. And so the court applies that same principle here. However, the difference is, in noting Mr. Novak was drawing points from this specifically, he mentioned Matthew, I believe, chapter 19, and talking about certain points in here specifically. There is room for it to be mentioned in argument in order for the court to fully consider what's before it. I'm going to sustain Mr. Novak's objection and simply say, if you want to talk about it conceptually, talk about the points, you certainly may, but simply reading from it exactly saying, and I understand, I don't want to constrain either party from being able to make their full argument, but quoting from it in open court, I fear does risk issues to the constitutional rights of the parties. If the parties prefer to go into a closed evidentiary hearing on this issue in order to be unrestrained, and it appears Mr. Novak has requested that for a second portion of his argument, we certainly can do so, because I do not want to put out evidence that is not admitted in open court until the appropriate time, until the court has gone through its decision-making process on whether it should be admitted or not. So to the parties, if you feel you can move forward on this first portion of it, I'm happy to entertain that argument. If the parties feel at this point, at this juncture, that a closed evidentiary hearing is needed in order to fully explore all the issues, I will leave it to the parties, because I don't know your arguments, and I don't want to say, constrain you from saying, well, I don't know what you're going to say, but I can't read your minds, and the court will stay in its lane to ensure that it's in the proper judicial role. So the objection has been sustained to Mr. McBride. In regards to your response, the rebuttal to the argument by Mr. Novak, what is your request?
Yes, Your Honor. I do not believe it's necessary to close this hearing. I would argue against closing the hearing on the admissibility of this exhibit. However, the court needs to rule on that issue before I launch into the fullness of my argument, because I do not want to be admonished for discussing an item that I'm asking to be admitted into evidence in public. So I would ask the court to make a ruling on the closure of the argument about the admissibility of this hearing so that I can make that argument unconstrained. And after that time, if the court rules on that, I will make my full argument.
All right. Well, what I'm trying to do is, you've heard the reasoning of the court. I don't want to constrain you. If you're saying, as you stated, that you want to best represent your clients, and every attorney should be doing that, that is your duty. I don't want, if you feel that a closing.
SK's in the house. Jen, of course, Jen has the same controls I do. She can jump on here anytime. Anyways, but SK, good to have you. I think we're coming to a lunch break pretty soon. Hopefully.
Yeah.
And,
maybe we can maybe Jen and I can keep everybody entertained while you take a break.
There was about anyways, yeah, no, I will take a little break. Hopefully we'll have Josh Carr on during the lunch break as well, and we'll see when he can jump on here.
This hearing to the public is necessary in order for you to fulfill your duty. The court will entertain that, but I can't have it both ways. If you want me to close the hearing in order for you to be fully be able to argue freely as you feel you need to, I will entertain that. But I don't want to say, well, I'm not going to close the hearing, and then suddenly the issue is, well, I wasn't able to make a full argument. And so do you need a closed hearing to make a full argument?
I agree. We may be able to get Graham Allen on tonight or tomorrow, or definitely at some point. So yeah, for sure.
Commit to best.
Great suggestion. Great suggestion.
To represent your client.
I think defense counsel is asking to close the hearing so that the argument can be made without the public seeing it. I do not want to close the hearing. I do not believe it's necessary to close the hearing. That's not my motion. I do, however, want to make a full argument that requires me to rely on the evidence and quote the evidence as I have done. That's my position. If I am not permitted to quote the evidence in my argument, then we need to decide whether or not this hearing should be closed. I would oppose closing it, but I do think it's necessary for me to quote the evidence.
All right. Are you able to make your full argument to the best of your ability to best represent your client by simply referring to the paragraphs and to the lines so it is clear to the court what you're talking about? There's no ambiguity without quoting it verbatim in open court.
No, I don't think so.
All right.
Your Honor, if you're going to make that closure ruling, I'd like to be heard before you.
All right. I'll hear from you as well. If you would like to come forward, again, just Mr. Reimer, just stating your full name for the record, for the clarity of the record.
Sure. Thank you, Your Honor. David Ryman again for the news media. We have briefed this issue a couple different times so far. Sometimes there is a misconception that I think is running, particularly through what Mr. Novak argued, that suppression hearings, because the evidence may be suppressed or excluded, or in limine hearings, need to be closed unless the evidence is deemed admissible. That is the opposite of the law. That has been settled since the United States Supreme Court decided Waller versus Georgia. You can see it in Kearns Tribune, which dealt with a preliminary hearing and access to a preliminary hearing where, as you know, and as we've heard repeatedly today, all kinds of evidence is presented at the preliminary hearing that may not be admissible at trial. And so the universe of the public's right of access to proceedings is not limited just to what eventually gets admitted at trial, which, you know, if there even is a trial. And we've cited the court to, you know, numerous cases on this, and I don't have the brief in front of me, and the docket is huge, and I can find it for you if you'd like. But I just wanted to correct the misimpression that the public is not entitled to hear argument and to see evidence just because it may not be admissible. Otherwise, we would never have admissibility arguments in public. And I do want to I'll just make one other point. Kearns Tribune also speaks to this. And that is that if you do decide that there's and so let me just make two quick points. To the 403 point, just because evidence isn't admissible is not a basis.
All right, the same argument he's made multiple times already. Clearly, he's an attorney for the media. That's what it appears to me. Make no mistake, we have yet to see the full capacity of the Candidatar crew to make up stories, to twist reality. The devil knows no limit. I agree with you. Trying this again, Gary and team. Thanks for all your hard work. Thanks to Gil also. Yes, we appreciate his time coming on here. That's been great. It was hundreds of Jubies wearing little stinger holsters that stung Charlie Kirk on the neck. To be clear, I'm being sarcastic, just trying to prepare for new conspiracy theories. Cannot stand CEO and her ilk. If I was on the jury, I would not think the defense attorney is confident with the case. I also think it's telling that the defense is questioning everything without bringing up a different story. I wonder if she brought up behind. Well, let's hear what the judge would say on this.
It appears like, would you like to respond to that before, and then I'll return to Mr. McBride for any final thoughts, and the court will make its ruling.
Well, I just wanted to mention the Utah Supreme Court decision in State versus Archuleta.
Let me address this. I'm going to pause this real quick just so we don't miss anything. I wonder if she brought up behind the tent is because she's a candy cultist. Folks, I don't think any of these attorneys, including the defense, are taking Candace and anyone on that side seriously at all. I really don't. I could be wrong. I know what you guys know. I don't have any insider knowledge here, so I could be wrong.
I think they're probably just happy that somebody's injecting other theories into this so that there could potentially, possibly, maybe be one crazy out there that gets on the jury that thinks that some of this could be possible.
I agree. And I think I agree with that. And but I think it would be smart of them because of the lunacy and because it will probably damage their credibility that they probably stay away from most of the theories that are being presented or the information that's being presented by Candace Owens. And I don't think they take them seriously at all, to be honest with you.
857 P. Second 234, where this state's Supreme Court reminds us that the First Amendment right of access is qualified, and that what needs to be carefully judged in light of the qualified right of access with respect to preliminary hearing exhibits. That was the issue in State versus Archuleta, is the defendant's right to a fair trial. So we're in this slightly twilight zone situation where counsel for the media is saying, even if the court has decided that the exhibits are not going to be made available for copying and inspection, and the court may decide that this exhibit is either not admissible or admissible for the court's eyes only, counsel for the media is counseling that the court permit Mr. McBride to read the exhibit verbatim in open court. And that basically defeats all of those principles. So I don't think that's the correct path. Counsel for the media is correct that the court's sealing or closure should be narrowly tailored. And the 403 issue, which we are prepared only to discuss because of the sequencing of things in this case, in this proceeding, we're only prepared to discuss at sidebar, has to do with potential.
We were on such a roll too. I felt like we were making real progress. We're getting new information. We got all that extra video. We saw that there is clearly video that we haven't seen before, different perspectives. And then we get into this.
For this entire exhibit and discussion of it until later in the proceeding, then it may be that part of the 403 argument doesn't need to be at sidebar. And I think we're all assuming that sidebar proceedings in this preliminary hearing are going to be part of the sealed transcript until some later point in time. In other words, it's not sidebar just for the moment. It's because the transcript's going to be sealed. So it very well may be that taking this issue up at a later point in time in this proceeding, All
right, while he's talking, we can take a look at this right now. Our poll says, based solely on what's been presented in the preliminary hearing so far, do you believe that allegedly Tyler Robinson was the shooter? Yes, I believe Tyler was the shooter. 11%, no, I do not believe Tyler was the shooter. And we have 8% currently that says I'm still unsure.
Well, it looks like 11% of these people need to remember to not miss a dose.
that we need
Go
to
take your medicine, have a
I'm not asking for a
hydration
closed
break.
proceeding. I was asking the court to caution Mr. McBride not to read
The other thing, while we're sitting here listening to him ramble,
that are not received into evidence.
if you haven't done so already, folks, like the video, share the video. If you haven't done so already, subscribe. If you'd like to be a supporting member, there's a link down in the description below.
Anything further, Mr. McBride?
But like the video. Help us out. It costs you
So
nothing.
note, I have not
Oh,
made
you
my full
supposed to be
argument on
nice today.
admissibility.
My
That's
bad.
all.
What were you saying?
I said, you said we were supposed to be nice today. My bad. I heard you this morning. I was like, oh, darn.
We forgive you. We forgive you for occasional slip up.
All right, I appreciate the arguments by the parties. This is clearly something that's very important to you all and is important for this case, as is every piece of potential evidence. I note that Mr. Novak indicated that receiving this could create confusion for future potential jurors. And that he mentioned that it could suggest to a potential jury pool that this case is about religion. However, what is happening at a preliminary hearing is far different than what happens at a jury trial. The magistrate, myself, is the fact finder. And whether something becomes admissible at trial is far different than what is admissible at a preliminary hearing. The purposes are different. The standards are different. And different steps need to be followed. Something could become admissible at a jury trial, but given the nature of a jury trial, more steps are necessary. Under Rule 1102, one of the major differences is that reliable hearsay is allowed in a preliminary hearing under the Utah Constitution and under the Rules of Evidence 1102. That is far different than what would happen at a jury trial. Taking this into consideration, I look to the information going to the very beginning, whether this is relevant. And as noted by counsel, looking to count 1, which is squarely before the court, to determine probable cause at the end of this proceeding. And the court is not weighing in whether it will reach that or not. It's not predetermining anything, but what is before this court under count 1, aggravated murder, which is a capital offense, victim targeting enhancement in violation of Utah Code Annotated 76-3-203.14 sub 2. Tyler James Robinson intentionally selected Charlie Kirk because of Tyler James Robinson belief or perception regarding Charlie Kirk's political expression. And so if that was not here, this enhancement, and it also goes to count 2, felony discharge of a firearm causing serious bodily injury. And I'm just reviewing. And then finally, count 7, violent offense committed in the presence of a child, where the victim targeting enhancement also is in play. Because that is part of the information that's squarely before the court, this becomes relevant. Now, trying to determine what is political expression versus religious expression, that goes into different grounds. But at this point, the court finds it is relevant for consideration, and if for the very least for argument. What the court is going to rule is that the need for a closed hearing is not been met at this point, because what needs to be shown is prejudice, or that the exhibit contains inflammatory information that would prejudice the jury pool. That begins the path where we can consider closing the hearing from the public. However, that's not what's before the court, nor has the court heard that. And so the ruling of the court is, previously I sustained Mr. Novak's objection, and the court will expound upon that Mr. McBride in his argument cannot read the entirety of State's Exhibit 5.1. Can he reference points of it and specifically quote certain points? The court rules that he can, just as Mr. Novak pulled from this, and it was broad, but he quoted Matthew chapter 19. He stated that this came from the Bible. He talked about the going from paragraph 1 where he quoted, or at least drew from, about the Internal Revenue Service in order for the court to consider the argument fully and making the determination whether it is relevant and should be admissible. Therefore, the court rules that Mr. McBride can continue in his arguments in order that the court can make its determination whether State's Exhibit 5.1 is admissible or not.
Partial win, partial loss for the defense and
Thank you.
the prosecution.
5.1 is a general explanation of what Turning Point USA, Charlie Kirk's organization, is and was on September 10th. The exhibit describes the events that Turning Point USA holds, talking about at least 200 plus of these events featuring Charlie Kirk as a headline speaker had taken place by that time. That's in paragraph 3, that these events discussed political issues as well as religious issues. Most political issues in the portion I previously quoted talked about gender issues, in particular, gender, sexuality issues, the difference, or the Christian and political view regarding marriage and families and gender identity. And
That was poorly phrased. It's also the scientific view. It's not just political and religious. And that was one of the things that Charlie Kirk was very careful to argue from a standpoint of. He didn't, matter of fact, he kind of avoided the religious argument. And he was very careful to argue from a standard of science. And those are gender, biology, well established. It's a scientific fact. I know he talked a little bit about marriage and things like that, where that does get it a little bit more into the political and or religious. But the fact is that Charlie talked about that from a standard of science as well. He should at least include that as well.
That information is
Science
relevant
is fake and
to
gay.
the motive
True.
that we are alleging in this case.
Oh, look at this. Yes, it is.
And it's also relevant to the victim targeting enhancement, which is in part a motive type enhancement. And the evidence will be introduced through, or we will offer evidence through other witnesses that talks about some of the defendant's statements that indicate his gender persuasion, and
Jesus does
he
love
falls
trannies
into
too.
some of these political and gender views that Charlie Kirk argued against. That's the relevance of this statement, is it shows Charlie Kirk publicly in front of large gatherings of people debated and presented his views, his political views, which were tied to his religious views about gender identity, LGBTQ rights type issues. And the relevance to that is the defendant's motive is that he was on the other side of those views. And you'll see evidence that talks about that through other witnesses. It talks about that being the inference and the motive that he had, or the inference from that evidence supports that motive, which supports the victim targeting enhancement, and frankly, motive in general, which goes to identity. For that reason, Your Honor, this exhibit is relevant. I don't see the prejudicial effect, unfair prejudicial effect this would have on the fact finder.
I agree.
Whether or not it has, some capability of prejudicing the potential jury pool, I think that's a completely different question. I don't think it does. I think this case has already highlighted the political issues that we're talking about here. And but my job here is to present this case to the court, to you, Your Honor, for you to make a decision. This evidence is admissible for that purpose. Whether or not it's public or published for the public to see is a different question, which I'll submit. The media is very capably represented, and I'll let them make the argument on that point. But I would ask the court to admit this exhibit.
Mr. Novak.
Thank you, Your Honor. For the state to argue that this exhibit says anything about Mr. Robinson's state of mind should be rejected out of hand. This exhibit does not say anything about Mr. Robinson's state of mind. And that's what motive is. And that's what the victim targeting enhancement adopted by the legislature focuses on, is the defendant's perception. If Mr. McBride wants to propose significant redactions to this exhibit so that Your Honor, acting as a magistrate, can consider things that are narrowly tailored to what the information Robinson perceived, but this document talks, and the gauntlet, there's political doctrines, Orthodox Christian views on sexuality, marriage. State just
I think we all understand what his argument is.
Gender identity, gender ID. It's what Mr. McBride has just said, goes way beyond that. And that's why it's not admissible. Mr. McBride and the state want to rely upon, which they haven't presented yet, and Mr. McBride hinted at that. So I think that it's not admissible at this point in time. I don't think it's sense of it's true. That's to have to establish motive. Legislate. The other thing I want to say is opinion, rules of evidence.
Just going.
So what we have to be opinion is Robbins.
This guy likes to hear himself.
So where of Mr. Robbins'
It's unbelievable, actually.
I mean,
disagree document?
take a breath.
There may be other evidence. There's nothing in this document in the enhancement.
Talk about monologue.
It also
407 years ago.
which we will get to, that would or anything
To well, I do have a question as it relates to political expressions. Does religion or gender intersect with political expressions?
I think that's a great question, but probably not a question to be answered by me in this proceeding. That's actually a really, really complicated question that the state wants the court to say is a simple yes. The court's basically asking me to testify about where in question, the way it was written, an expert to prove knowledge the state has to prove, which is that Mr. Robinson had a state of mind.
Are you serious?
And I don't think that this court should all politics. And I mean, if the court question of we're talking about
Directly to the enhancements. Mr. Novak, I bring that up because you mentioned it and you said you cited directly to the enhancement. You said political expression, and then you went to the Bible itself. And so it appeared to the court that you put it into play. So I just wanted to get a little bit of guidance from your position. And so that's the reason for the question.
No, I totally appreciate the question. I'm not suggesting, Your Honor, that there's a problem with the question. Any question that the court asks is a question that counsel should take seriously. Sure. The legislature separates in the statute religion and political expression. The state selected the victim targeting enhancement based on political expression only. Now the state wants to I didn't bring Matthew in, Bible, to this, turning this into Mr. Robinson's identity, life, are anti-Christian. And this hearing is being broadcast to the entire jury pool. Mr. Robinson's life is inconsistent with what Mr. Engelhardt calls Orthodox Christian views. I'm going to just stop right here because I think the court knows what the problem is.
Thank you. All right, anything further before the court makes its ruling? I appreciate the in-depth argument and the passion behind the argument. You are advocating for your clients, and I respect that.
Yeah, Your Honor, I'd just say it provides context for the defendant's state of mind.
All right.
That's all.
All right, in making this determination whether it's admissible or not, I'm going to start at the beginning, which is this. This is a preliminary hearing. The purpose is to determine whether the state has established probable cause to believe a crime was committed and that Mr. Robinson committed it. As it relates to this case, as I turn to relevance, I turn to the information as previously stated, and is this relevant? What is before me? And without indicating my decision on probable cause, because I am not at that point, I'm withholding all decision-making until all evidence is properly before me. And so in this ruling, it is not indicating either direction that the court is heading. However, the court finds that it is relevant as it relates to the victim targeting enhancement, as it relates to Charlie Kirk's political expression. And the court recognizes the argument made by defense in regards to state of mind. And it is because of both arguments that the court finds that the court is ruling that it is provisionally admitted into evidence. And at such point, when it becomes relevant, based off what Mr. Novak has talked about Mr. Robinson's state of mind about Mr. Kirk's political beliefs, Then at that point, whether it is admitted or not into evidence will be decided upon. So as of right now, it is provisionally admitted. Because of that stance, it will not be published to the courtroom or media, but both parties can weigh in on that when this is brought up again, and the request for it to be fully admitted is made by either party. Then the court will re-examine whether it should be published at that time to those in the courtroom and to whether that is displayed or filmed by the camera. All right, let us proceed. Well, it's any party need the benefit of the record
All right,
before we
they're going
break
to
for
lunch, and more importantly, we have a very special guest with us today. We got Joshua Carr looking like he could be out there representing. I don't know.
I'm running for Congress, guys. No, I'm not. I'm just joking. It does look like that. I'm going to go take some new headshots today. That's why I'm dressed up like this.
I definitely, you look like you're getting ready to do something political. That's for sure. No, thanks for coming on, man. I know I sent you a text last night and we followed up this morning. So thanks for jumping on here short notice. You were there yesterday, all day outside, I guess, right?
Yep. I was outside. Can you guys hear me okay?
I hear you great.
Perfect. Yeah, I was outside. I got there pretty early. Wasn't early enough to get inside. They only have 14 seats available to the public and people are lining up incredibly early. I'm going to show up on Thursday morning at 3 a.m. to get in there, guys. So it's going to be crazy. I'm going to be doing interviews there with some other prominent people. I believe I'll be doing an interview with Jillian Michaels there at the courthouse. And so there's a lot of people really bought into what's happening right now, and they're really enjoying what the prosecution's putting out. But in terms of what I saw, and I actually have a friend who was in the courthouse yesterday as a journalist. She works for the Deseret News. But I saw everyone come in except for Don Jr. And Tyler Robinson as well. I saw Tyler Robinson's motorcade come up. There were about 20 police cars. So it was kind of hard to miss. But other than that, it was Don Jr. and Tyler Robinson that somehow, snuck in from underneath. But I saw Erica Kirk, saw Charlie's parents, saw Graham Allen, Brandon Tatum, the defense attorneys, the prosecutors I probably saw, but honestly, I didn't, I wouldn't recognize them if I saw them. And there were some other people that the media were very intent on filming, and I have absolutely no idea who those people are, but I have a video of it too because they seemed important.
So what's been your take over the last couple of days? But more importantly, I know there's a lot of folks out there kind of on the other side of this argument, right, that are out there. I'm sure we're outside. What have you heard? Go ahead.
Well, I was going to say you'd think so, but at least yesterday when I was there, I only saw one person there that was in support of the Candace Owens crazies. I forget her name. She's on X. She said she would be there. She was there, but she left after, 15 minutes after the trial started, and she was only there maybe 40 minutes before. So, and she was talking to someone. I heard her talking to them. She was like, we're going to go to our Airbnb and stream this and comment on it. But in terms of her actually wanting to be there in person, she wasn't there very long. Maybe that's because she showed up the next day at 2 a.m. to get in. I'm not sure. But other than her, I didn't see a single person there for Candace Owens or for Tyler Robinson. I know Tyler Robinson had 10 people there to support him in the courthouse. Other than that, every single person there was media or in support of Erica Kirk.
Well, that's I'm happy to hear that. Or that's just good news to me. I think, I don't know. I'm having a hard time reconciling the idea that, this is just going to continue to go on. I think between what we heard today, what we heard yesterday, but especially what we heard today, there's a lot of evidence presented today that, Joshua didn't exist. There wasn't these videos. They didn't exist at all. And I'm having a hard time believing that they're going to continue to push some of these things. Number one of the biggest things that Candace has continued to push is that Tyler Robinson wasn't there. I think unequivocally, we can see that any fair, reasonable-minded person, he was there. Not only was he there, but he was there multiple times.
Yeah, that's very clear. I've also I tweeted this out a couple times yesterday. You will never at any point hear the defense say the word Israel. It will never come up. She will, when I say she, I'm talking about the chief prosecutor. I forgot her name already. Or excuse me, defender, not prosecutor. She will never talk about Israel. She will not talk about the things that Candace Owens has talked about. Their chief strategy, and I'm sure you've seen this and your audience has seen this over the last 2 days, seems to be that there was someone on the ground level that had a pistol, and that was the person that shot Charlie Kirk. And what we're going to see during this hearing, and I think in the trial in a year from now or whenever it happens, is that that is going to be an entire case that they try to lay out. And I think that's where the conspiracies will go for Candace Owens and her followers as well. It's just so clear at this point, I think, to even most of them, that the exploding mic theory is just completely debunked. You know, we have someone on the stand saying, I heard a shot, I know it was a rifle. And we're going to have many more witnesses like that in the actual trial. The reason why Candace Owens is not commenting on a lot of this right now and not doing her show is because she is understanding and seeing where the conspiracy can migrate to. And so I think you're right that a lot of the things we've heard over the last few months are no longer going to be talked about, but we're going to see some new ones based on what the defense comes up with during this hearing.
No, that's my take exactly. I think her and Baron Coleman and the rest of them are out there trying to figure out what holes are left to where they can slip whatever the new grift is going to be into it. But I think at this point, most people have rejected the exploding mic theory. And I think if you have a brain between your ears, it's probably a good idea, especially if you're going to continue to push this and keep people on board, which that is their goal through and through. That's what's going to happen. What else is happening on your end that you don't think that most people are aware of? Maybe some things that happened yesterday or whatever else is going on with this hearing.
Oh man, that's a really good question. I mean, I'm excited to get into the courtroom and really see what's going on there. I think you've probably reported on the fact that Erica Kirk and her and Charlie's parents were 100% sitting next to each other, despite everything that Candace and her fans have been saying. They've been in solidarity together. One thing that is important to note, this is kind of fascinating actually, and maybe this hasn't been talked about, is that there were two ways to get into the courthouse. There's the one off of, and I'm totally going to mess up the street, and I'm just thinking offhand, I think it's 500, where now I feel like I'm off. I literally lived in Provo and grew up there, and I can't even remember which street was in front of the courthouse. But in any case, there's a main street right in front of the courthouse, and then there's the back way, and that's where all the media is. And so you have a decision to make if you are entering the courthouse that day of which side you want to go into, and you can do either of them. And so there's a reason why people either snuck through the front, which would be Don Jr., for example, would have snuck through the front, or maybe underneath. I think probably underneath, since no one even has a picture of him going in. I don't think, not that I've seen. Or you can do what Erica Kirk did, and we got a tiny video of her, and she was rushing in through the front. Now, the front is not where the media is. There's not tons of reporters there. There was only one person there. The back is where the media is. And so anyone who walked through that side wanted to be seen by the media. And this is what a lot of people are missing. Like, I had some criticism on my ex of, why did you film Charlie's parents? It's like Charlie's parents walked through the media in solidarity with Erica and Charlie. The whole reason they walked through was to show people we're here, we're strong, we're not afraid of Tyler Robinson or his defense team. And that was true for Brandon Tatum as well as Graham Allen. The defense attorneys did it to try to show strength as well for Tyler Robinson. Erica Kirk, on the other hand, had a very different strategy. She didn't want the publicity. She's had plenty of that. She wanted to sneak in, not make it about herself, and that's what she's done. So that was kind of an interesting thing that I observed yesterday.
That is, no, that's some interesting insight to say the least. And this is the first time that we're seeing, that I'm aware of, that we're seeing Charlie's parents at all. So yeah. I am glad to see that she's there. I'm glad to see that Erica Kirk is there. I don't know, man. It's when that's where you start thinking about it and you start getting sad, right? That is the depressing part of this, and realizing, having the empathy and sympathy that most human beings normally come just readily equipped with, that so many of the Candace folks apparently don't have. That's where things get real. And it's interesting to see how all of this plays out. But when it goes to them, that's where the human component is. And most of us, I don't know, it definitely becomes much more depressing. Do you know if Elizabeth Lane was there or in court or anything else?
I looked around for her. I didn't see her. I think the odds of her getting into the courthouse without someone seeing her were pretty low. The only way she would be able to get in is if she got a place with Tyler Robinson. And I don't think that would be possible. There's no reason why their defense would want someone like that in the court. I don't think there's any way she got into the courthouse. I mean, I'm 90% sure it didn't happen. I have people there on the ground. I have people I know who were there yesterday inside the courthouse, inside the room. I have people there today, 3 of them who I spoke to yesterday, who are in the courtrooms today. And they have not seen Elizabeth Lane. They're people who would recognize her if they saw her. And like I said, I was around the courthouse. I would have recognized her if I had seen her. It was there's not a lot of places to hide. It's just like right there. It's very open. I was looking. I was there for several hours. Didn't see anything.
Yeah, on all the wide shots over on the Tyler Robinson side, I've been looking for. I didn't see her there. I know there was a lot of talk. She tweeted multiple times that she was going to be there, and she's even suggested that she was going to confront Erica Kirk, and hopefully they're keeping her away.
Yeah, she won't even have an opportunity. I mean, all of that is just total talk. Like when they were moving, I watched her bodyguards move her in. There's 2 bodyguards. No one knows who's in there. There's black Suburbans everywhere, and you've got random people coming out all the time. Sometimes it's a prosecutor, sometimes it's a media personality, all kinds of famous people coming in, and randomly a black Suburban pulls up, 2 bodyguards step out, and in a matter of 8 seconds from the door of the car into the courthouse, and you're done. Nobody is allowed in the courthouse at all unless you have a hearing, or you're those 14 members of the public who are allowed in, who waited in line. Even then, you're with a bailiff the entire time. There's like physically no way anyone like Candace Owens or Elizabeth Lane are going to be able to confront Erica Kirk.
That's good to know. That's good to know. Did you get a chance to speak with Graham Allen or anybody else that was attending?
I tried to. Brandon Tatum and Graham Allen, when they pulled up, they were much less like rush inside. But I was on the media side, and there's, maybe I shouldn't be like this, but there's something that happens to me when I'm around the mainstream media, and I feel like I suddenly have to like act a little bit more professional.
Sure.
You know what I mean? Because I'm used to alternative media where I can just do whatever the heck I want.
Sure.
And I was like so close to walking up to Graham, but he was interacting with a police officer, with a sheriff, and the members of the media are all filming. And I just felt like if I walk up to him and he doesn't recognize me, he's going to be like, this kid, I don't know if he would have, but I feel like he's going to be like, this kid is, and he looked he's in a black suit. He looks very sad. And I just felt like it might have come off as like, I'm trying to get my moment in the spotlight. So I felt sheepish about it. I've reached out to Brandon and Graham to see if they'd be willing to do interviews. I haven't heard anything back, but I know they're busy this week.
Yeah, no, for sure. SK, you got anything to add to that?
No, I think this is great insight. I was curious about who all was there, and I think he's spot on about how people are entering. And when you're entering, walking through the press, you're obviously wanting people to know that you're there for a reason. So I think that's great insight.
I'm going to let you go here in just a moment. I don't want to keep you too long. I know you got to get lunch. So do I. But any real big revelations from your perspective that has been laid out so far?
I think the biggest one for me is the testimony that we got from Sergeant Hull this morning. I mean, it was just so meaty. I think yesterday was like, towards the beginning, obviously, it was a little rough just in terms of how boring it was, because that's how court cases are. Towards the end, we started to get to some meat of it. However, that meat that we were getting was graphic, so we weren't able to see it. And it was a little, just tough. And I was feeling for Erica the whole time. Today, I feel a little bit differently. I have a feeling that Erica and her team are feeling a little happier because it wasn't graphic, and they were just showing us videos of Tyler Robinson showing up not once, not twice, but 4 times even after. And, I didn't know this. Maybe this is new information. Maybe I just didn't know it. But he staked out that wooded area that's actually close to my house, and then went back and put the gun there. I didn't know that he had staked it out. I thought it was his first time there when he had stashed the gun. That was really fascinating. We have all that video. The other thing I found very fascinating was the fact that the sergeant testified that Tyler Robinson had only been there for about 15 to 30 seconds. And this was on the cross-examination. And when I say there, I should be more specific. He was in position, in sniper position on the roof for about 15 to 30 seconds. Yeah. And this was on the cross-examination from the defense. And I think the defense was trying to show people that he wasn't there long enough to assassinate Charlie Kirk. But in my opinion, it had the opposite effect, because what I'm thinking is the defense, like I said before, is trying to paint the story of there was actually someone on the ground level who shot Charlie with a pistol, and Tyler Robinson was on the roof. I don't know how they could deny it. We can all see it. He was on the roof, but he was up there to watch the Charlie Kirk event, and he got scared when there was a gunshot and left. That's what I think the story is going to be, even though they've kind of only alluded to those things. The problem with that 15 to 30 second narrative is that you have to be telling me that Tyler Robinson happened to show up the moment within 15 seconds of the shot being fired and then left. The odds of that, I'm not saying it couldn't happen, but the odds of that are just so low. I don't think that's going to play well with the jury. And I think just spelling out that timeline was really illuminating and exciting.
People may have some doubt, but it's not reasonable doubt at that point.
No,
that's what it comes down to.
Because then why would he have been texting Lance and the people in Discord saying the things that he said?
Yeah.
That
Well,
doesn't
why
make any
is
sense.
he 3.5 hours from home? Why did he make multiple trips to UVU? And I mean, onto the campus itself. Why did he go check out the wooded area where later a firearm was found? Why did he go back up? Why did he arrive again with a limp? It just,
Well, and this is perfect, right? The prosecution is doing a fantastic job. They're starting this very basic. They started with, was Charlie killed? Yes, he was. And it was by a rifle. Next up, was Tyler Robinson around at the time? Yes, he was. Now let's talk about the motive, because what the defense is going to say is that, yes, he drove there to see Charlie Kirk. I mean, there are some people, I know Utah well, there are people who would drive very far in order to see Charlie Kirk speak. And what the prosecutors are trying to do right now, and what they've been freaking out about, the defense has been freaking out about for the last hour and a half to 2 hours right before we went to lunch here, is that they did not want to show the motive of Tyler Robinson. And the reason why the prosecution wants to show it is because they're showing there's no reason for Tyler Robinson to drive 3.5 hours to go on this roof, because he clearly hates everything that Charlie believed in. And I guess with all of that, I'll just say the prosecutors are doing a fantastic job. And I feel really great. Obviously, we knew this was going to go towards a trial no matter what. But after seeing what we're seeing, I feel really even more confident for the trial itself.
No, I agree completely. You know, I haven't got the impression, and maybe your intuition is correct, that they're going to try to go with a defense of a handgun. I know they brought up the holster. I know they brought up another spent cartridge or unspent cartridge up on the roof. I still don't know exactly where that was. Doesn't really matter. I think the explanations of those are pretty well done. But the problem they're going to run into if they go with that defense is the fact that we have an ATF report that clearly says this was a rifle round. Regardless if it can be matched to that specific rifle or not, that's inconclusive. But it is a .30 caliber round that you're not going to be able to. I don't know how they're going to spin that. And quite frankly, I didn't get that perception that that's where you're probably right. You're probably right. I didn't think about that.
One of the things that. Oh, sorry.
No, I was just going to say what I thought they were trying to illustrate is that there was shoddy police work and there was a lot of things missed. Like, why didn't you stop and put, a 3-foot section of caution tape around that and get out your fingerprint kit right away? Those are types of things, because there are pictures. I've seen the pictures of a guy leaving the crowd and he has a handgun in his hand. And I'm sure that person can be tracked down and should be, so that he can identify it to confirm or deny whether that's his holster or not. But it is an open carry campus. There's 3,000 people out there. If you think 5 to 10% were carrying on campus that day, you're talking 150 to 300 firearms that were probably within 20, 30 feet or more from Charlie Kirk. But I hope they do pursue that, because it'll make them sound stupid once they pull out the ATF report.
Yeah, well, yeah, and you're right that the prosecution totally shut that down. They also talked about the fact that there were hundreds of police officers, immediately after any of the holsters or casings that were found. And they actually made the point of saying that these rifles that they hold do not have the bullets in the chamber, which means they're outside the chamber, which means there could be a bullet that would fall. If there's hundreds of officers, that's fairly logical. I guess the real strategy from the defense is that they're screwed, and that they're just trying to throw spaghetti at the wall until it sticks. So you're absolutely right that what I just laid out makes no sense. I have no idea what other choice they have at this point.
I think they're going to go with Tyler really wasn't on campus. That was just a Mossad hologram.
Well,
and
they may go with that. I think at this point they're just trying to obfuscate enough to create enough doubt to potentially get the death penalty off the table.
Yes. Yeah. No, you're right. You're right about that.
I think that's the only option they have left. Last thing, I'll let you get out of here. I know you got to go get something to eat. What do you hope to see this week? What is one piece of evidence, or maybe you have a theory or whatever it is? What is one thing that you would like to see that might fill some holes in your mind, or put down some of the arguments that we hear from the Candace crowd? The one piece of evidence you would like to see this week?
Yeah, that's a great question. I think the number one, and I think we're going to move to this maybe after motive, we'll see, And the prosecutor did mention that he'd have 4 witnesses, and we've only heard of 2. So this is one of the witnesses I think he'll call, and that is a forensics expert when it comes to the bullet and the fragmentation. Obviously, the number one thing we hear is that a 30-06 could not have done that to Charlie. It would have exploded his neck, which is I find very funny. They use the word exploded, and then they said there were explosives on him. Whatever. But they say it would have exploded neck, or it would have gone behind his neck and exited. I would love a forensics expert and some more autopsy reports on why that's not true. I would love a little more information about the fragmented bullet and a witness actually saying, yes, we cannot confirm that this came from the same hunting rifle, but we can determine that this is a rifle round and not a pistol round, so that can go to bed. I think that will be helpful, but who knows what the Candace Owens fans will come up with after that.
And they've already said that it was a 30 caliber round, so it is consistent with
yes, right,
weapon too. What were we going to say?
Right.
I was going to say, I was actually just looking at the documents this morning where they were arguing about contempt because over that report and what was said publicly and what was reported in the media. And they made sure to point out that they said that they could not, conclude that it was, yes, but also they couldn't exclude it.
Yes.
Right.
So
and one thing I did find very interesting that they talked about today, the prosecutors did a very good job with this with Sergeant Hull, and maybe this has already been talked about, but I just had missed it before, is that in a bolt action, if you fire one shot, that doesn't mean, and basically there should be no casings on the ground. The casing doesn't come until reactivate that bolt action.
Cycle the bolt, so you have to actually unlock the bolt, extract, eject, and then recycle. However, you're going to do that, but you have to cycle that manual bolt without a doubt. So
thank you. And so that's actually very consistent with the entire story. It's actually, in a way, kind of a good thing that there was no casing on the ground. That only further proves that theory. And my understanding is that when they found the hunting rifle in the woods, it still had several bullets and maybe the casing as well in the gun.
It did still have the casing in the gun. And what they did confirm was that the casing matched that rifle. And then, of course, they have the unspent cartridges, which his DNA was on, the spent cartridge, which his DNA was on, but they were also all engraved. And then they found another bullet exactly that matched the make and model of the bullets that they had with that also had the engraving and the engraving tool. So, I mean, it's wild to watch these people cope, and just they're going to have to come to grips with the fact that they've been duped, or they were wrong, or they were lying. They were being lied to, and it's unfortunate. It's unfortunate. Well, like I said, I want to be respectful of your time. I appreciate you coming on. Is there anything else you want to let everybody know out there other than make sure you guys go follow Josh Carr, go to his YouTube channel. I'll make sure there's a link down in the description below so that even people watching this later on are going to follow Josh. Josh, you're doing great work. I appreciate what you do. I want to see you. Look at you. Like you're a born politician, man. I want to see you. I don't know.
I will never run for office. I will never run for office. Maybe like school board of my city. But thanks, guys. I appreciate you.
Yep, we appreciate you, man. Have a great day.
You too. Bye.
Thanks. All right, folks. I am gonna go get some lunch real quick. SK, it's your show. You can do whatever you want. If you want to jump on here with Jen.
Oh gosh, I hate this so much. You're gonna make me.
How about you? What is that better?
Yes, that's so much better.
Let me just make sure that I've caught up on all the super chats real quick. I threw this one up there earlier, but I think it's worth repeating.
Jen's resting. Oh no.
Yep.
Somebody should join and come up here and chat with me. We can play a game in the chat.
You know what? I'll put a guest link down there. If somebody wants to jump on even audio only, that'd be great. Andrea Burkhardt just said it seems defense not denying guilt, but showing he turned himself in voluntarily to persuade a jury not to want to give him life, not death penalty. I agree with that. I don't see anything. I haven't seen anything where they're attempting to offer an alternative. I just haven't seen that. I think some of the things they pointed out today was they were a little bit, I think they're alluding to a rush of judgment. They didn't follow all the leads. They, were a little sloppy with the evidence. I think once we get other people up here and especially once it gets to the trial, when we have additional investigators come on there, people that were probably the forensic analysis analysts that were on the ground, probably going to hear from them. I think that'll paint a different picture altogether. Kamala school of word salad. Kamala, whatever her name is. Politics is downstream of faith. Couldn't agree more. It's really difficult to separate those two. And why does it matter? Like, the argument is that basically because of bigotry, whether it's political or and that's essentially where that enhancement is coming from, right? So whether it's politics or faith, I don't know that that really matters. It may not apply to politics. That may be where they're going with that. I have to look at that. I'm not a lawyer. Don't pretend to be one. Why are frogs good at baseball? They know how to catch fly balls.
I got that dad thing going. People this morning were saying they were saving them all for this afternoon.
Do you know the only car that is mentioned in the Bible?
What?
They said in Acts, all the apostles were in one accord.
That's funny, actually.
I'm going to paint my entire house. I will be done before this is resolved. Audio version 1,000 word essay when you only got 50. That was worth the super chat. Thank you, Loretta. That was good.
That was funny.
Josh, can you attest to Charlie's sister being there next to Erica? They're trying to say she hates her. I don't buy it. You know what? I will not only just send Josh a text, I will send Graham Allen a text, and maybe we'll get to the bottom of that.
And I did see somebody in the chat say that Fox had reported that Erica was sitting next to Charlie's mom and they were holding hands during the hearing yesterday.
Yeah, that was I believe when they were entering yesterday, but yes.
That was me, and Fox also reported that at one point during the testimony, Erica leaned her head on Charlie's mom's shoulder, and Charlie's mom comforted her.
Oh.
Yeah. The way that these people have gone after Charlie's family, created these false narratives, and then the way that they have went after Erica's mom, dying mother, it's probably one of the things that disgusts me the most. Really is. Can't the judge shut him down after he's more than made his point? He probably can. Look, folks, remember, this is the preliminary hearing. Almost everything that's going on here doesn't really matter that much. What I don't want, I think the judge has done a really good job being overly cautious of showing any sort of bias one way or the other, and I think he's going to continue to do that. I really like this judge. I think he understands the task at hand and the gravity of this trial. And so, like we were talking with Gil this morning, he's like, look, a preliminary hearing like this is usually fairly short. He said they've already provided enough information and testimony and evidence that would more than substantiate taking this hearing forward. So with that being said, I would rather the judge be as cautious as possible so that there is no chance of any sort of mistrial or anything that I want him to do whatever he needs to do or whatever he feels is necessary to make sure that he doesn't create any problems for himself later on down the road. And I think he's done a good job doing that. And I think he's a wise and patient judge. And I think he's the perfect judge for this particular situation. All right. I'm going to go grab something to eat real quick. There's a bunch of stuff that I do want to cover. I'm trying to think. I was thinking about this right before. I don't know. I'm sure I'll think of it.
Candace's expos are pretty entertaining today.
We should definitely pull those up. As a matter of fact, if you want to go through those, do you know how to share the screen down there?
I mean, I kind of know, but I've never done it before.
So you just if you hit presenter invite, you're going to get it says share screen. Let me make sure that I'm not sharing a screen right now. I'm going to remove this so that you'll be able to share all the screens you want to share. And then you'll hit share screen. Then you can go to your X. You can go through all those posts and talk about all that and keep everybody entertained. You run out of material, start twisting balloons into animals.
I can start dancing,
You can
telling
start
jokes.
You can do whatever you want to do. Do whatever you
I
want to
can't
do.
believe you're leaving me up here by myself.
It's
okay.
We can just take a break. We can just take whatever you
It's
want to do.
It's fine.
about.
The
All
chat
right.
probably wants to hang out and play a game.
I'm sure they do. All right.
See you later. Enjoy your lunch. So what's up? It's just us. Oh, Jen's here. Thank God.
I'm here with you, SK. I'm just in the background.
Good. We should play a game. What game should we play? What should we do? Chat, you guys are in charge.
I mean, we could always look at Candace's photos and pretend that they're like, I don't know. What is that called? Where you get arrested
I don't know.
and they take the photo?
Oh, a mugshot.
Yeah, we could pretend like they're mugshots.
Yeah, that would be funny. Or we could play like Would You Rather, and the chat can ask us, Would you rather, and give us options. Come on, guys. The chat is like hardly moving. Nobody's even giving suggestions. Hangman? Truth or dare? I don't know about that. Those are kind of like mugshots. That's exactly what that looks like, actually.
That's what I was thinking.
Somebody hurry. Where's Clipmaster Jake? There he is. Clipmaster Jake, you should go take that and put one of those slates in front of her. You know, like she's holding the thing.
SK, do you want me to go through her X account?
Yes, you should. If you know how to, well, obviously you know how. If you're able to, is what I meant to say.
Yeah, I'll pull it up and then you pick the ones you want.
Yeah, well, we should just go over all of them from today. Like her ex posts, because she's been, like she said, that one, there's a video there. Uh-oh. She blocked you. Or the person who posted that blocked you. There's a video there from in the courtroom, and it says, this is our daily reminder that the federal government hates us and thinks we are retarded. And it's a video from in court. Oh. Yeah.
Oh yeah, I blocked Danks. He's a scumbag.
I don't even know who that is. I know nobody.
So
They tried to delete this.
Yeah, here, you read it.
They tried to delete this stuff off the internet to craft a narrative post-assassination. Every PR agent and influencer in the Matrix was sent to attack me. Oh, this is good. Day in and day out. But it didn't work. It is absolutely true that what doesn't kill ultimately strengthens you. They tried to break me psychologically post-assassination, but I survived it. I now feel stronger and more prepared for this fight than ever before. Time to go, Max. But then if you scroll down, she comments again, and she talks about the NCRI thing that Data Republican posted about yesterday. It says, love your face in this segment, Blake Neff. Yesterday felt like a fun warm-up exercise. Surely you guys can do better than NCRI studies, referring to me as a digital assassin. Plus, Charlie was scared of her, and struggle session op-eds from my deranged former employer. Turn up the heat, clown. I'm bored. This is like max level coping.
And have you noticed how she turns everything about Charlie's like entire the whole trial, all the evidence, anybody talking about Charlie, TPUSA, everything she finds a way to turn around and make it about her.
Exactly. This is like, I feel like this is like, I always grew up being told, you know, when the Democrats are accusing the Republicans of doing something, maybe they're already done it or they are currently doing it. I feel like this is what Candace does. Like when she's posting these things and trying to say that it's other people, I feel like she's really telling you how she feels.
And why does she care how tall Tyler Robinson is? Because she's asking like repeatedly now.
Because she has stood 10 toes down on the fact that beyond a shadow of a doubt, Tyler Robinson was never even on that campus. And for the last 2 days, all we've seen is proof that Tyler Robinson was in fact on that campus. And that's why I've been joking around saying she's probably going to pivot to he wasn't actually there. It was just the Mossad holograms.
She's
It's all
saying
fabricated.
she's saying that he's over 6 feet tall, and that this whole not to believe your own eyes BS. Like, I can't tell you how many people have said that repeatedly on X. They want us to not believe our own eyes. No, we want you to believe what is actual evidence.
This is just like gaslighting at the like expert level. This is
Yeah,
narcissism on full display.
I mean,
In my non medical license opinion.
yeah, I can't look at her. She's such a vile creature. She is cuckoo, yes. Yeah, the chat is all saying that she's ignorant, she's cuckoo, she's crazy.
It was the Decepticons and the Galactic Empire in coordination with the Jews
I mean,
guarding the grid.
she's literally Satan's spawn.
I was saying this last night on the podcast that if you can watch all of this, especially if you look at Data Republican's thread that she posted yesterday morning with the NCRI study and the videos that she put together, and you go through that entire thread and you read it and you watch those videos, if it doesn't stir something in your spirit, I mean, I don't even know. I don't know how people make it through life. I mean, discernment is so important right now. And I feel like everyone needs to be praying for discernment because it is very easy. I mean, just hearing her speak and say the things that she's said and watching this play out in real time, it just stirs something in your spirit. Like you feel like it's actual evil. That's how I feel anyway.
So it looks like Liz is saying if the height don't fit, you must acquit.
That's funny.
Oh, Lord have mercy.
Oh, yeah. Andrew Colvett had some good posts. Sav Smiles said, can you show what Andrew Colvett said to her on X yesterday?
Yeah, I will pull that up.
And that thread by Data Republican is something we could go over too. And there are videos in almost all of the posts in the thread.
I am trying to find the one he posted to Candace. Ah, here it is. There you go, SK.
All right. He said, LOL, you were always friends? Always? Are you sure you want to go with that, Candace? You want to tell everyone about your, quote, friendly exit from Turning Point back in 2019? Or should I? Or should we just go back to how you weren't friends with us or CK at the end and have zero proof for any of your idiotic theories? Your narcissism and selfishness are over the years has given me plenty to talk about. Because Candace posted, first, it was Charlie never spoke to her. He was afraid. Now it's okay, they spoke and texted often, but Charlie was being fake and trying to placate her. So to be clear, Charlie sent me pictures of him and his son and daughter in the hospital after birth because he was looking, I can't see what the rest of it says.
There.
Because he was looking,
right here.
where,
looking for
oh, there it
things
is. Looking for things to placate me on, or just generally texting me when he was worried because Erica was rushed to the hospital in February of 2024 due to a preterm labor scare, which wound up okay, gratefully. All of that personal stuff to simply placate me You are a clown, capital letters, clown. You tried, but completely failed to accomplish anything today beyond exposing yourself as a routine liar who gleefully perverts Charlie's legacy to serve your own financial interests. Charlie and me were always, capital letters, always friends, and we never stopped speaking, and we always had each other's backs. You are powerless to undo that. Listen. She's crashing out in real time. I feel like this is like we are about to witness 2008 Britney Spears meltdown.
Well, she is crashing out. And the funny thing is, how many times do you know, or how many best friends do you know unfollow you and block you on X?
Yeah, 0. You don't do that. I don't even do that to people that I've gotten into it with and that I don't like or don't support anymore because I just feel like it's not right.
I blocked some people just because it hurts my head to read their content.
Right. No, I mean like people that you would be were friends with before that could have stabbed you in the back or whatever, you know. It's social media. But I don't even do that because I don't have any desire to try to, you know, take anyone else down or ruin anyone else or give anyone else any reason to find any drama.
Right. And the chat is saying, or don't invite you to their wedding. Like,
right.
Like if my best friend was out there, of course I would invite her to my wedding.
Exactly.
Like, I don't understand these people. And Candace is such a liar. I mean, I would like to see anything where she has friends, like photos of her and Charlie, or friends were like, hey, yeah, we all went out to go see a movie, or we all went out to go grab dinner. Anything in the last 2 years. And she's got nothing.
Nothing. Absolutely nothing. And I just feel like I can't imagine how she lays her head on her pillow at night and is able to be okay with herself. I don't know how she can do these things and say these things and attack Erica the way she has. If you pull up that Data Republican thread, you can see the exact process of how people come to be able to like accept political violence, not only accept it, but in a lot of cases cheer it on, like this group of Candace Owens followers has done. You can see in real time how exactly this has all worked. I think she had it pinned. Yeah, it's pinned at the top.
Wedding, and then came the children. You know, Charlie really loved Erica from the time I'm reading through the text today. Just loved her. He loved his family. He really did. And I came there and she was just lovely. She was genuinely such a nice person. I was like, Charlie, just go for it. Just go for it. But I know that Charlie was very happy with Erica. And I know that Erica was she really is just the moment. The speech that she gave, everybody was just, I think it was the most consequential speech in American history. A message that everyone needed to hear, including myself, a message of complete sadness. We were grieving with her, was when his wife, Mrs. Erica Kirk, addressed not just the nation, but the entire world. Around the world, obviously, have been moved by Erica's commitment to her Christian faith. The strength, obviously, that it takes for her. It's been, you could see the energy. She's going to fight. She's going to fight, and she is going to fight on the good side because every woman would know what her husband's going through. So I can't even. So are we. I love that you show Erica love and support. I do wish there was some sign that we could.
So this one.
The first thing that I think I should make abundantly clear is I am relieved that Erica Kirk is at the head of Turning Point US.
This one, just for context here, really quick. So the first, what she typed before this video is Candace yesterday pre-spun an NCRI report she hadn't read, calling it Zionist. The report is Candace's own show. It doesn't accuse her of anything. Her own footage does that. Before the investigation, Candace spent 40 episodes defending Erica Kirk. She called her genuinely such a nice person. She swore that nobody outside of my husband and Erica Kirk had the power to shut her up. She told her audience she would stop if Erica asked. Erica asked her to stop. Candace didn't stop. She couldn't. The investigation had become her primary subscription product. So she revoked Erica's authority the only way she could, by making Erica untrustworthy. No new evidence appeared between the praise and the accusations, just a new business need. And the business need may very well end up in tragedy. Here is Candace and her audience in their own words. Well, and then she says, thanks to me, because I am the one that put the music on these videos. But you guys, this is the process of how the political violence becomes acceptable and how you dehumanize. You know, she was praising her, and then she starts to dehumanize her and accuse, and then her audience picks up on it and they go spread it all over the place. So that's what this is about. This is her praising her and protecting her in the beginning. And then the second one, it says Candace built. Oh, is this still the first one? I think this is the first one, isn't
Yeah,
it? Or
this
is
is
it?
still the first one.
Yeah, you can probably fast forward it to that slide where it says Candace protecting her or whatever it said. I think it's further down. It was almost like maybe in the. Yeah, there we go.
The first thing that I think I should make abundantly clear is I am relieved that Erica Kirk is at the head of Turning Point USA, because just like I alluded to last week, and which I will double down, so out of a loyalty to Erica, he also doesn't want to make sure that I secured the footage so that Erica would not have to see it again. Like, but also the nastiness towards Catholics just needs to stop, point blank. I mean, Erica Kirk are just unfair criticisms of people that are attacking Erica, and I'll tell you why I feel that those criticisms are unfair. I meant it genuinely, was to pray for Erica a couple of days ago, and I said she is stepping into that you saw or check. That was not written by Erica Kirk. That will be an entire department, and these you should know that those decisions are not made by Erica. That's what it means to step into a company. You got my attention. What lie has Erica told that I'm supposed to be focused on? Okay, like absurdly making claims that I attacked Erica. And I know what these organic movements Point USA somehow means that I'm blaming Erica, who wasn't even working for Turning Point USA when Charlie died, because now she's the CEO. Like, there's like this threat, like they want me to say something bad about Erica because they want me to stop investigating it.
Candace specifically defending Erica Kirk and saying she would never make a claim like that about Erica, and that she.
No one, and I mean absolutely no one, outside of my husband and Erica Kirk has the power to shut me up right now. That's it. 2 people. You gotta make an appeal, you gotta go to them, okay? Nobody that has the capacity to get me to shut up about this except for Erica Kirk and my husband. So don't plead to his pastor. I'm trying to figure out what happened on that day. I'm not going to stop unless Erica Kirk asks me to stop, as I have said, or my husband asks me to. Questions actually came from Erica Kirk. They said that request was directed by Erica Kirk.
And then the second post, she goes on to talk about Candace built 4 mutually exclusive theories about who killed Charlie Kirk. Each version contradicts the last. None had a single named source. And this is where you can look at the process. You can see the first step is dehumanizing Erica. After this, it'll go into the dehumanization. And then building the contradictory theories, and then weak receipts or no receipts, and then escalation to violence. And this is where you'll see the followers start to make posts about doing bad things to Erica, and people have been arrested for threatening her, by the way.
Do you know which one it is, SK?
This is the one that has the different theories. This is the second post in the thread. The one that you just were on is
Okay.
the second. Not that one, the next one. Oh, if you open it up, like click on that thread, like click on the comments maybe. Like if you click on that top post, it'll open up so you can see all of the posts in the thread. Like just click, yeah, there you go. There you go. That second one right there. That one, how Charlie Kirk died. Yeah. This music's my favorite, by the way.
Governor Cox tells us that that is when the shooter, Tyler Robinson, arrived at UVU campus in a plain maroon t-shirt, light colored shorts, and a black hat with a white logo. So essentially he's saying that what that person we saw walking down the street right there arrived on campus at 8:29. I'm going to allow you hear Governor Cox say that himself because it gives us a timeline. He says to him, I assume right away, Lance says, you weren't the one who did it, right? And Robinson says, I am. I'm sorry. And the roommate says, I thought they caught the person. Okay. And Robinson responds, no, they grabbed. The fact that there wasn't an exit wound is probably another miracle. And I want people to know. I just spoke with the surgeon who worked on Charlie in the hospital. He said the bullet, quote, absolutely should have gone through, which is very, very normal for a high-powered, high-velocity round. I've seen wounds from this caliber many times, and they always just go through everything. This would have taken a moose or two down, an elk, etc. End quote. And then now this is Andrew, but it didn't go through. Charlie. Death certificate. Because they did not recover a bullet from a 30-06. Hunters and military men rejoice. It turns out that common sense still rules the roost. Definitively, that Charlie's shot did not come from behind. I can just take that or leave that. You can still go down that narrative. The persistent conspiracy theory that Charlie's road mic was rigged with PETN explosive. I haven't much spoken about that because I wasn't a PETN expert until this Butler situation, speaking with people. But conspiracy theory that Charlie Kirk may have actually been killed by his Rode microphone, which was rigged with an explosive. Now, I have always thought there was something there, okay? It was a theory that was at first posited. What I can state rather unequivocally is that there is now more evidence, more evidentiary support that Charlie may have been killed by a rigged explosive device that was on him than there is that Tyler Robinson shot him from a rooftop, committed his first assassination, buried them at Dairy Queen. I do not believe that he was on campus on top of Losey Center firing a shot at Charlie Kirk's neck. I can say that unequivocally. And you saw that we began to reintroduce.
And then, so that was the building the contradictory theories. And you see her, the next thing she does is she goes on, it says, the closest thing Owens comes to offering actual receipts is declaring a 30-06 could not have possibly killed Kirk and left no exit wound. One that is easily debunked by searching for counterexamples. And then she has that deer photo. Obviously, my son shot a deer on Thanksgiving morning in 2025. Just this last Thanksgiving, and the 30-06 round did not exit, and he was only like 35 yards away from the deer, and it didn't hit hard. I don't think it hit any bone, actually. I think it went between ribs, and then it was stuck under the skin on the front of the shoulder blade. It went through its heart. So it kind of came from the back on the top and then went through. And then let's see, the next one has, where are we at? The report maps Candace's words work as a permission structure for something much more ugly. Stage 1, dehumanizing Erica. Grieving wife becomes pageant girl. This is where you will see when you watch this, if it doesn't stir something in your spirit and you start to realize that things are not good. This is just not good. There is something evil about this.
Sheet. You're an idiot. She has no idea what's going on. She is what she's always been, a pageant girl. Tell her lines that she has to remember and she can utter them back to you. And usually it's not without and the perceived authenticity. Erica is not the archetype of a model actress seeking money and fame and then settling into a quiet life with a wealthy, good-looking husband. She is the wolf type who wants to be in the place of that husband. She is not born for security. We could not find a single example in human history where someone's wife just assumed their corporate role as CEO and chairman of their company following a death. Maybe still another coincidence, right? Erica's in pageant world, Trump's in pageant world, Epstein's in pageant world-ish. Then we took a week off to investigate Erica, and so think through the common sense there. If I want to do a documentary on EMPs, and I'm just a random girl that is like in pageant world, that's pretty much all she's accomplished at this point in her life, right? Charlie, in this direction. She has now completely dissociated from that previous person. She's now radically pro-Israel. Says it's like brain.
Is there another one, SK?
Yeah. If you go, just hit the back button and then it goes to stage 2, strip her grief. Operation Warp Widow. How's our emotional asset doing today? Mocking the widow scriptures. And then the infamous, that is not a real person. So it's the dehumanization, the building the contradictory theories, the weak receipts, and the escalation to violence. But this is still part of the dehumanization. Is it time to go back?
No, no, continue.
Oh. This is normal.
I'm just done with
this
lunch.
was a grief marketing campaign, but this is just a grift. There's no substance behind these words anymore. They just get up there and they just find whatever Bible verse they want and they tell you, this is what it means. This is what it means. People like her are the reason that there has been so much growth in the Catholic and the Orthodox Church, because you can just see it. That is not a real person. That is not a real grieving widow. And I simply don't care. Warp Widow. That's what we're calling it. It's Erica Kirk. It's the vaccine. And how's our emotional asset doing today? Anybody want to check in? It's a smile. I just could not put on following my husband's public assassination. To authentically like her. With enough ad spend, with enough tears, with the right outfits, with the right words and speeches written for her. She wants that feeling, that high that she's chasing is when she came out at the memorial.
So see, I mean, it gives me goosebumps. Like I can feel it. And then you go on to the next stage 3, make harm feel deserved. Compare Erica to Corey Richins, a Utah woman convicted of poisoning her husband, diagnosed her with psychopathy on camera, imply she needs to be jailed.
Look, I have seen enough, ladies and gentlemen. I've seen enough. Erica Kirk should be dragged into a police precinct for questioning. I'm here and ready to help. I suspect I won't be hearing from you. And dare I say, Erica, if you're interested, no. That you might be involved in trafficking, potentially murder. You should probably just respond factually and formally with something obvious, something other.
I think it's Satan himself. I really, genuinely, 100% believe that. That's the why. There could be some temporal explanation of why, some political why, but I think ultimately it is a satanic why. Charlie was turning his back on the Prince of Darkness, and he was removed for it. He was killed by supporters of the Prince of Darkness, by the people doing his bidding.
Studies on psychopathy, particularly those building on the work of
Psychopathy.
psychologists like Robert Hare, describe traits such as a rehearsed emotional display and shallow affect. That Erica was in charge of quote unquote modeling apartments for a bunch of underage Eastern European girls who were being.
Either Erica Kirk is evil and was in on it, or Candace Owens is an evil.
All right, you guys, straight to jail for questioning at least Erica. I don't care who's mad. I really do not care who.
And then the stage 4 is violence becomes, what was it? What did it say? Violence becomes conceivable. Candace denies she's accused Erica of murder, but her audience certainly has gotten the message. This is crazy.
That Erica killed Charlie. She's never said it that I've seen. Oh, but
It's the video. The sound on that video is low.
I believe Erica did it. I'll be the first to say I don't think Erica did it. I don't think Erica killed her husband. I don't think Erica killed her husband.
He does think she was in on it,
I know
though.
a single human being that does. I've never talked to anyone. That on this show, I don't know a single person who believes Erica killed Charlie. Not one. So what a weird thing to say.
Her husband. Now, let me at first also state unequivocally that I do not believe that Erica Kirk murdered her husband. I've never made that claim in public. Sincerely, I've never made that claim. What I have said and what I stand by today.
And then the last one is just more of the same, like her followers, her audience. It says, what's most alarming of all, her audience has started writing the ending. They predict her death. Pre-written alibis. If something happens to Erica Kirk, it reads as confirmation of the conspiracy, not a tragedy. And then at the very end of the thread, there's the link to the NCRI study, so you can see exactly the steps of the dehumanization and how political violence becomes acceptable. It's just so evil. It is so evil. And what's really sad is this isn't the only circumstance this is happening in. I don't know if you guys have noticed, but over time, people have completely dehumanized our politicians on both sides of the aisle. And I don't think that any of this is going to be solved until people can start looking at people, even people you disagree with, as human beings that have families and hobbies and friends and music they like and, you know, lives outside of their job. This is their job. Politicians are politicians. This is their job. They're still people with lives outside of their jobs. And when the humanity is stripped from these people, it makes it easier for crazy people to do bad things.
Oh, 100%. And speaking of dehumanization, this is when Candace had Bassem Youssef. They were laughing, discussing that Erica Kirk killed Charlie Kirk. So, what stage of grief is this? What stage of grift is this? That's the real question. What stage of grift is this? The other thing I wanted to show everybody real quick before we get started here, we were discussing the other night, both myself, Matt Tardio, and a guy named Midgray, who does an amazing video and audio analysis. We just completely dismantled any possibility that the exploding microphone is a viable theory. But I do want to share, let me see, stop this, and I want to share this with you. There was a picture that he was discussing, and it's obviously from a video that I want to share with you. Let me pull this up. There we go. Let me pull this down, manage this, and show. All right. So this is a picture of, obviously, of Charlie Kirk. It's a still from a video. But this one, and I'm going to just make this, fill the screen there so we can see what's going on here. This destroys any idea of an exploding mic theory for multiple reasons. But I want you all to see what's going on here. Let me pull this back. Okay, don't let me pull that back, whatever. I'll make this. There we go. All right. So I want everybody to be able to zoom in here. Look what we actually see. We literally see, and I know this is a little bit macabre, all right? And if you don't want to look at this, don't look at this. But we clearly see where the bullet has deformed his spine. And this looks like vertebrae separation that's protruding from his back. And the only thing that can really explain that is a high caliber rifle round. Exactly what we see, what is being alleged to be used. I mean, obviously, if you want to say there was something else, that's fine. But the entire exploding mic theory doesn't account for this. Doesn't account for this. They go back and forth between a couple things. Number one, if it's a shaped charge, the penetration of that shaped charge is limited by its design, and that's how shaped charges work. So we're talking about an inch or two at most, and that's not even what John Bray actually says. I think the penetration of what he's saying his design, or what he's alleging the design is a couple millimeters. Now, there's other people that are saying that, number one, it was an entrance wound into his chest, and what we see in his neck is an exit wound. That doesn't count for that. All right, so that's not true, and that's total horseshit to begin with. And then the other part they say is that the wound on the left side of his neck was part of the mic exploding, even though we can see that the mic, as a matter of fact, even in this picture, like the magnetic clip that you see in the bottom right-hand corner of this picture hasn't even moved. It hasn't moved. There is no burning. There is no charring there is no hole in, like, it's just so dumb. But the point is like, this confirms, it denies a lot of what we're hearing as far as different theories go. But again, the exploding mic theorists also say that the wound on the left side of his neck is part of the microphone, just basically we have a debris and shrapnel, which that doesn't make sense because there's not a line of sight to that. It would have to go around his Adam's apple essentially and hit the shallower portion of his neck on the left-hand side. So it does make sense. But I think it's really important to see what happened here. And it just goes to show, how desperate so many people are to push these things that don't make sense. All right. I do see there's a couple of other super chats we'll get to. If the height don't fit, you must have quit. don't know exactly what you're talking about, Liz.
We
616.
were looking at Candace's tweets. She's obsessed with his height now. She's trying to prove that she was right on he wasn't really there. The person in the videos is not the right height.
Got it.
So it's like the OJ. If it doesn't fit, you must have quit.
Got it. Yep. The glove don't fit, you must have quit. My expert opinion, they're already dealing for a lesser sentence. Families' testimonies for the state, videos and confessions, a deal for life beats that for sure, the death penalty. I don't see, again, I've said this multiple times, like a lesser sentence, a plea deal is only available if the prosecution offers it. I'm not seeing any indication that the prosecution is even contemplating that. They said they
No,
were
but
going for a death penalty, and that I think that's what they're going to do.
yeah, but we have to remember the Idaho 4 case, nobody thought any plea deals were going to be offered or accepted, that there wasn't a chance of any of that. The families didn't even know. And then right before the actual trial started, after years,
Sure.
they gave Brian Koberger a plea deal, and the families were pissed.
Yeah.
But they did it so that he would get for sure life in prison, even though he didn't get the death penalty. He did get life in prison.
No, I'm tracking. I'm aware of that. I'm just saying, so far we haven't seen anything, and it, like you said, it could be happening behind the scenes. I hope they don't. SK, a book could be written about the candy cult. I think it should be. As a matter of fact, the candy cult should be studied for years to come as a mass psychosis. Yeah, they should be.
Well, and we have the things like go to Data Republicans thread and click on the link to that study. And then there is another one about political violence that Charlie had talked about, an NCRI study about political violence and its acceptance and those things. If you go look at these things, people have studied it in depth. That's how you can watch Candace Owens and the things that she says and the progression. And you can see the dehumanization, because before anyone can accept political violence or even choose to commit violence against someone, they have to be dehumanized. People cannot see them as a human, which
Sure.
Candace has done a very good job of doing to Erica, including now they don't even call her Erica Kirk. They call her by her maiden name because they're stripping her of everything that has to do with Charlie.
Yeah. Well, and I would, we already know that happened with Donald Trump. We've now had 4 actual attempts on his life, I think, now at this point, and then multiple more that were planned, including the Iranian conspiracy to kill him. Guy that was convicted of conspiring with the IRGC to kill him. So we know that took place. I would argue that what has been done to Erica is far worse than anything that's been done to Donald Trump. She's been demonized worse. She killed her own husband. And then on top of that, she is an actual sex trafficker. And I say those in quotes. I don't believe that, obviously, but that is the message they're pushing. A child sex trafficker. That happened, I guess, while she was married to Charlie Kirk, or I guess before technically. But, the way that she's been demonized with zero evidence of any of it, and what they've done to that lady in her moment of grief, and being, that she is a victim in all this, that she lost her husband, her best friend. SK, I watch so many of the pictures and videos of her and Charlie together, and man, that is as genuine as it gets, in my opinion. Like, like she loved that guy, he loved her. They look at each other with such love and admiration every single time that, like, I don't get emotional very easily, but when I see those pictures and those videos of them together, and there's several of them out there, even I get emotional. So
It's so sad, and it is just so evil, which is why I feel like if you can't watch these things and see what's going on and what's being done to this woman, whether you like her or not, whether you agree with her politically or not, if you can see these things taking place and you don't just feel how evil this is in your soul, I mean, I don't know if there's any hope. I mean, this would
there's
be
always
evil
hope, but you are in a
regardless.
really bad spot. There's always
Yeah,
hope. You
that's true. There is always hope.
you have entertained evil to the point that you don't even realize what it is anymore.
Exactly.
You are addicted to evil behavior. And It really is sad. It's sad to see that so many people are so gullible in the United States. It's so sad to see people being entertained by all this, by participating in it the way that they do. Really is. It's really disgusting.
Yes, and just to think that not only has she lost her husband and she's going to have to raise their children, you know, without their dad there by her side and her partner, her best friend, her everything, her world. Then when they drug her family into it and her sick mother and all of these things and saying these horrible things, I mean, I can't imagine doing this to anyone. I can't imagine doing this to my worst enemy. I can't imagine doing it to anyone at all, any human being, because these are human beings with feelings. You know,
Yeah, and you're right. I wouldn't do it to my worst enemy. I really wouldn't. And
No.
it's crazy that people.
And I realize
participate
it
in
looks like I have a black eye. I've had an allergic reaction on my face for a while. I promise I do not have a black eye. It is a rash that keeps coming and going from an allergic reaction over the last few weeks.
I just thought your husband only had to tell you once.
That's exactly. My son was here for 4th of July and he's like, "Your eye is broken out again." I was like, "Yes, it came back again." And he was like, and my husband said, "I told her to make me a sandwich. She didn't listen." But when you're in person, you can see that it's like an actual rash. There's even like skin there that's coming off it.
I don't think
Sometimes
anyone
it
would even, I
stings.
haven't noticed it at all. So I don't think anyone
Well,
would even noticed it.
when you put me on the camera
I mean, like that.
on the black eye, yeah. See, it's a rash, you guys. It's on this side too, but there's no makeup on here at all. This
Looks like you have some makeup.
Oh, I have makeup under here, but not up here.
Don't
On
worry.
either side.
I literally can't see it. I can't see it at all. If you hadn't said anything, and matter of fact, I'm looking for it now. I still don't see it. So don't worry about it. All right.
AirPod.
Now I'm getting an echo. I don't know what's happening. Hey, real quick, Jen, you're gonna have to kill that audio. Even that music we played earlier, we're gonna have it cut out. So just play it without the audio.
The music on those video clips, I made it like on the AI thing.
Yeah, I
It's
don't
not
doubt that.
copyrighted.
Okay. There you go. All right, go ahead and play it without the music. That's where we're at, folks. This is what people. All right, so the trial's back in session. The hearing is back in session. Let me share that screen. We'll back it up. Now we'll back this up to the point where we have another witness. I'm curious to see what we're going to get out of that. Looks like we're about 5 minutes behind.
Now in session.
That's not bad.
Right. No.
How we're going to proceed is we're going to call her for a very limited purpose. We're going to pause and Falmuina, Your Honor. Just by way of preview, we are going to call Jen Falmuina, Sergeant with the SBI, but how we're going to proceed is we're going to call her for a very limited purpose. We're going to pause her testimony. Defense is not going to cross at that time. And we're going to call an FBI DNA analyst out of order. It's a defense witness, but that's to accommodate that witness's schedule. State calls Sergeant Jen Falmuina.
I'd like to come forward and be sworn in.
Melton said that the testimony you are about to hear now before the court will be the truth and whole truth and nothing but the truth, so help you God. Yes.
All right. After you're situated, there should be a bottle of water to your left, maybe behind the monitor. And if you wouldn't mind just bringing that microphone just a little bit closer to you so it picks up your voice for the recording. Mr. McBride, your witness.
Will you please state your name?
Yes, Jennifer Famuina.
Where do you work?
I work for the Utah Department of Public Safety.
What position do you hold there?
I am currently a sergeant within the State Bureau of Investigation.
What was your assignment September 10th, 2025?
I was assigned to oversee the crime scenes as well as the physical evidence.
And were you sergeant with the State Bureau of Investigation at that time as well?
Yes.
And do you have any kind of specialty in your assignment there?
Yes, I do. I am currently overseeing, or I am the lead over our evidence response team within our division. That includes not only conducting training, but also attending training and whatnot.
Okay. So if we hear ERT, it means Evidence Response Team.
Yes.
Were you called to the crime scene at Utah Valley University on September 10th of 2025?
Yes, I was.
And were there multiple scenes that you oversaw or helped to process?
Yes.
We've had some testimony about the rooftop of the Low C Center. Did you oversee or are you aware of evidence that was collected in that area?
Yes, I am.
Was there a screwdriver that was collected from that rooftop?
Yes.
And do you know how that was collected and what happened to that screwdriver?
Yes, that was collected by the Utah Bureau of Forensic Services Crime Scene Response Team, or also known as our State Crime Lab.
And do you know what happened to that?
Yes, it was packaged, and then that evening there was discussion on who would take custody of the evidence, and I was there along with FBI. Then it was decided that FBI would take custody.
And did that evidence actually go to the FBI?
Yes, it did.
And was it sent for testing?
Yes, it was.
Where was it sent? Do you know?
It was sent back to their equivalent of our crime lab.
Okay. Are there other areas there at Utah Valley University that were also processed for the presence of evidence?
Yes, there was.
Is there a wooded area that's northeast of campus?
Yes.
What was found in that wooded area?
What was found there was a long gun that was wrapped in a dark colored towel.
And you say a long gun. What does that mean, a long gun?
Sorry, that would be a rifle. So for to be more specific, it was a Mauser 98 rifle.
Do you know what caliber that was?
It was retrofitted to a 30-06 barrel.
And do you know what kind of action that had? Was that a semi-automatic, automatic, bolt
It was
action?
a bolt action.
What is a bolt action rifle?
I'm not too familiar with guns, but I just know there's a bolt and you have to pull it back.
Okay. And what was done with that weapon and that towel?
That was documented in place, and then eventually pictures were taken. It was documented in place, and then afterwards we rendered that gun safe and then packaged the gun as well as the towel.
What was done with the towel after it was packaged?
The towel was also provided to the FBI.
And those two items, well, let me tie up that thread. The gun, what was done with the gun?
The gun was packaged. It was taken to FBI custody. Then eventually it was provided to the ATF lab.
Okay. So the gun went to the ATF lab. Is that correct?
Yes.
The towel went to the FBI lab.
Yes.
And the screwdriver went to the FBI lab.
Yes.
Did you receive reports back from testing that had been done on those items?
Yes, I did.
I'd like to show you State's Exhibit 31. That's connected to the defense computer right now. Is there any way to switch it?
Law enforcement are not gun experts.
Thank you.
Most of them are firearm illiterate.
Okay, I'm showing you here on the screen, State's Exhibit 31. Do you recognize that?
Yes, I do.
What is that?
This is the FBI report that was provided to me by the FBI that documents DNA testing.
And does that include testing that was done on the screwdriver that we've spoken about and the towel that we have spoken about?
Yes, it does.
Okay, what I'd like you to do, Kimberly, if you'd please just scroll down so that Sergeant Falmuina can observe this exhibit. If I can have just a moment.
Doing good, loving failure. We're hanging strong. Today's been
And can you see who that report is signed by?
much less
Yes.
monotonous
Who's that?
than yesterday.
Amanda Baker, I'm assuming is how you pronounce your last name.
Is that in fact the report that you received documenting the testing results on these items and some other items from the
Yes.
FBI?
Sorry. Yes.
And does it appear to be in an accurate condition as to how you received it?
Yes.
I'd move the admission of State's Exhibit 31.
Defense?
No additional objection.
All right, so I'll note the standing objection and as it relates to admission, what is your request as to publication?
I'd move this admission and its publication both to the court and to the public.
All right. Anything further, Mr. Burke? No. All right. The court will admit State's Exhibit 31 into evidence and allow publication of this exhibit to the gallery and to the monitor on screen in the courtroom and for the camera to broadcast.
Okay, if you'll go to, Kimberly, if you'll scroll down to still on page 1 where the screen will show items 7 and 8. Sergeant Falmuina, do you see the lines that say item 7, that line?
Yes.
And will you read that portion of the report that describes what item 7 is?
Item 7, towel from around Mauser rifle, serial number 8863.
And there's also some other identification numbers. Is that the towel that you found with the rifle that day?
Yes, it
On
is.
September 10th?
Yes.
Item 8, will you read what that says is a description of item 8?
Item 8, screwdriver from perch.
And is that the screwdriver that you described that was collected from the rooftop?
Yes.
Okay. If we can go to page 3 of 6, please.
Just a note, and we've known this for a while, but they're still saying the rifle was so old that it didn't even have a serial number. Lie number 5,000.
Will you, item 7, sub 1.
When did they
will you
start
please read
serial
the results
numbers?
there from the title item 7?
Lots of manufacturers. So it became law, I think, in like the 50s that you had to have a serial number on a rifle. But I mean, most rifle companies have been putting rifles, serial numbers on rifles for, I mean, over 100 years. It
I
just
can
wasn't
check the
law
one
that you
behind
had
me.
to. Huh?
The one behind me is from like the Civil War.
Yeah. And it probably has a serial number or some
I'm
sort
gonna
of.
look.
Look at it. Look at it. A lot of the Civil War rifles actually had a serial number for accountability purposes going way back when. It just became a law that you had to have them.
7 until the word contributors.
Hey, don't handle that rifle, please. Hey, Please don't handle that rifle. That'll get us shut down. I hate to do that, but Jesus.
Really?
Yeah, 100%.
That's crazy.
It is crazy.
I thought it was okay for
And,
education
Would
purposes.
you mind repeating that, but with the microphone? I want to make sure
Not
that
all
the
live.
record picks up your objection. All right. Either way, if you want to come up, that's fine, Mr. Burke.
Judge, the objection is that her reading to the court, what's in the report is cumulative, since we have the analysts here who will be testifying to what the report says and what it means. So you've got the report in evidence. We don't need this witness's reading the report to the court. So it's a 403 cumulative objection.
Mr. McBride, do you wish to respond?
My point is only to draw your attention, Your Honor, to the relevant results that will be discussed by the other expert, as well as the results of the items we've discussed, the towel and the screwdriver. That's all.
All right. The court will overrule the objection and allow a brief overview of it, not going line by line, page by page. So if it is brief, I'll allow that.
Thank you. So if you'll read item 7.1 to the word contributors at the top of that page, if you will.
Yes. Male DNA was obtained from item 7 sub 1. Item 7 sub 1 was interpreted as originating from two individuals, one of whom is Twiggs. The DNA results from item 7 sub 1 and what are 1.7 octillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors.
Thank you. Let's skip down to item 8.1. Do you see that bolded and underlined
Yeah.
line there?
Yes.
And this is relating to swabs of the handle area of the screwdriver. Is that right?
Yes.
Will you read those same two paragraphs there? Male DNA ending with contributors.
Male DNA was obtained from item 8 sub 1. Item 8 sub 1 was interpreted as originating from two individuals, one of whom is Twiggs. The DNA results from item 8 sub 1 are 30 quintillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors.
Okay, thank you. A couple of foundational questions before we finish for now. First off, do you know who Twiggs is?
Yes.
Who is Twiggs?
Twiggs is Lance Twiggs. He was a roommate of Mr. Tyler Robinson.
And do you know if Lance Twiggs's DNA was obtained for comparison in this test?
Yes, it was.
And how was that DNA obtained?
It was obtained by law enforcement officers.
And was that by a buccal swab?
Yes.
What is a buccal swab?
A buccal swab is basically like a Q-tip or a swab that we'll just place in someone's mouth and just scrub the inside of their mouth to obtain the cells.
And then that Q-tip is then packaged and sent to the lab for testing and comparison?
Yes.
And was the defendant, Tyler Robinson's DNA, also collected in the same manner?
Yes, it was.
Okay. Thank you. Nothing else.
Right. Mr. Burke, cross-examination.
I'd like to reserve the right to cross-examine after the witness completes their testimony after the following.
Oh, would you mind grabbing the microphone? I just want to make sure what you say is on the record.
With the court's permission, I'd like to reserve the right to cross-examine on the area she testified about until she's completed her testimony.
Okay, okay, I see what you're saying. Any input, Mr. McBride?
Your Honor, that's what we expected to happen. We discussed this beforehand. We stipulate.
All right, that's fine. And so should I have the sergeant step down or?
Yes.
Okay. Sergeant, if you'd like to step down, you're still under oath, and so please don't discuss your testimony with anyone. And is she being asked to exit the courtroom, or what's the request of the parties?
Yes, to exit the courtroom at this time.
All right, Agent, if you wouldn't mind exiting the courtroom, and then we'll come get you when we're ready for you. All right? Thank you. All right, Mr. Burt, turning to you.
Your Honor, out of order, the defense would be calling Amanda Baker.
All right, Ms. Baker. All right, Ms. Baker, if you wouldn't mind coming forward right up here by the bailiff and being sworn in.
You do solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
All right, Ms. Baker, if you wouldn't mind being seated at the witness stand. Once you're situated, there should be a water bottle for you if you'd like behind the monitor. And after you're seated, if you wouldn't mind just pulling that microphone close to you so it picks up your voice, okay?
Okay.
Mr. Burt, your witness.
Your Honor, we're going to need the monitor switched over to our side if we
Okay.
could. While we're doing that, good afternoon.
Good afternoon.
Tell us your name, please.
Hi, good afternoon. My name is Amanda Baker. My last name is spelled Bakker.
Ms. Baker, what do you do for a living?
I am a forensic examiner in the DNA casework unit of the FBI laboratory located in Quantico, Virginia.
And how long have you been a DNA analyst at that location?
A little more than 10 years.
And just in general, what are your duties?
My duties are to manage a case. When a case comes into the DNA casework unit, I will review any information associated with that case. I will review any evidence that is submitted for that case, determine which items of evidence need to be tested and which tests need to be performed. I will then create something called an exam plan. You can think of this like a to-do list to let the biologist know which items I need tested. Once that testing is complete, I will review all the data, draw conclusions in the form of a report, and then testify if needed.
Ms. Baker, in this case, were you requested by the state of Utah to do certain testing?
Yes, I was.
And when were you called upon to do that testing?
That was September of 2025.
And do you recall when the case first came into your lab?
I believe we received evidence the first time was September 11th of 2025.
And just in general, when the FBI, your unit receives evidence for analysis, is it true that the turnaround time is about 200 days?
It depends. We've wavered between 90 days and over 200 days. I would say on average, it's somewhere between 180 and 200 days.
However, did this case come in on what's called a priority one level?
Yes, it did. And what that means is we worked 24 hours a day, 7 days a week until examinations were complete.
And is it true that you were conducting the analysis as the evidence was being inventoried?
That is true. Because of the high profile nature of this case, an item of evidence would be submitted to the lab. It would be inventoried by our evidence management group and then sent to the various units for testing. For example, the DNA casework unit. We would begin testing as additional evidence was being delivered to the FBI lab.
Now, as a result of your analysis, do you produce case files?
Yes, I do.
And document your examination in other ways?
Yes.
Do you have your case file with you?
Yes, I do.
Okay. And in your case file, are there notes of conversations that you have with people that are relevant to your testing?
Yes, that's called our communication log.
Now, do you have your case file there in front of you?
Yes, I do.
I think the pages are numbered. So I'll ask you to go to page 22 of your case file notes.
Okay.
And if I could direct your attention to the bottom of that page, there is a communication log entry dated September 13th. Do you see what I'm referring to?
Yes, I do.
And would you read to the court what your entry is for that date?
Yes. This is my communication communication entry on September 13th, 2025. All spoke with FBI Special Agent Folger and Utah SBI SA Dave Hull. Gave technically reviewed results that Robinson was included as a possible contributor to the DNA from the towel and the screwdriver. We discussed the additional examinations conducted by DCU, and they both agreed that no additional immediate comparisons are needed at this time. All remaining comparisons will be in the laboratory report.
Is that an accurate reflection of what you told the agents at that time?
Yes, it is.
And you told them that, quote, Robinson was included as a possible contributor to the DNA from the towel and the screwdriver, correct?
Yes.
Was the language that you used in conformity with requirements that you have for reporting out test results?
Yes.
All right. I'd now like to direct your attention, if I could, to exhibit number, State's Exhibit 31, which is in evidence, and I think it's our tab 2. And that's in evidence, so if you could display that on the screen.
Mr. Bird, are you requesting it to be displayed to just your screens or to all screens?
No, since it's an evidence.
Dear lawyer in the house.
To the public.
Okay, let's go ahead and put it on the main monitor as well.
Okay, could you go to page 6, please? And highlight the third paragraph. This is your report dated September 15th, 2025, correct?
Yes, that is correct.
So this is 2 days after you had the conversation with the agents as to what your results were.
That is correct, yes.
And in your report that you wrote 2 days later, you included this language that's highlighted there, correct?
That is correct.
This report conforms to the Department of Justice uniform language for testimony and reports for forensic DNA examinations. Correct?
Yes.
Okay. Now, I'd like you, if you could, to take a look at that standard that you referenced. And then I believe is that, and this will be just to the witness, not to the public.
Okay.
Calling up tab 7.
Que pasto.
Do you see that? See
I
that
love
on your
Kate
screen?
Basto.
Yes, I do.
Do you recognize this document?
Yes, I do.
And tell the court what this is.
This document is the approved standards for scientific testimony and reports for autosomal DNA testing.
And is this the document that you were referencing in your report?
One of them, yes.
And is it a true and accurate statement of what the policy of the FBI is in regard to reporting DNA in a case of this type?
Yes.
I move that document into evidence, Your Honor.
So is it just this page or all the pages? Because it says 1 of 6.
Yes, so this would be the entire document.
Mr. McBride?
I don't see the relevance of this document. I object on relevance grounds.
Mr. Burt?
Your Honor, the document is referenced in your report and it defines the parameters of what her opinion means. So I think it's very important for the court to understand the limitations of the opinions being expressed.
And just for my understanding, when you say in her report, are you referring to State's Exhibit 31?
That's correct.
All right, Mr. McBride, any further thoughts?
No, I'll submit it.
All right, so State's Exhibit, well, I'm sorry, how am I labeling this exhibit for the defense?
Your Honor, we have our exhibits organized by witness, and we would be submitting to the court electronic copies of these under named witnesses. So this would be Baker 7.
All right, Defense Exhibit Baker 7 is admitted into evidence, and as it relates to publication, what is your request, Mr. Burt?
Your Honor, I would ask that this be published since the report is published, and this is important to understanding the limitations of the report.
And so published in the courtroom and on the monitor for the media?
Yes,
Okay.
correct.
Any thoughts, Mr. McBride?
No objection.
All right, it will be admitted and published both in the courtroom and on the monitor for the video camera.
Okay, so this document has various subjects, correct?
That is correct, yes.
And it, in the beginning, tells you how to frame your testimony in terms of inclusions or exclusions, mixtures, sex determination, et cetera.
Correct, yes.
And then there's a section called statements not approved for FBI autosomal DNA testimony in our laboratory reports.
That is correct, yes.
Okay, so if we could go to page 5 for that statement. Okay. Under the topic absolute identification, is it the policy of the FBI when you're reporting out results that an examiner may not state or imply that a match provides an absolute identification of the individual from whom the biological material originated?
That is correct.
And you were following that policy in this case when you told the investigators that this was a possible match, correct?
That is correct, yes.
You never said it was an absolute identification of Mr. Robinson, did you?
Correct. No, I did not.
Now, the second guidance under that policy is an examiner shall not use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty in either reports or testimony unless required to do so by a judge or applicable law. You're not, in your report, did not use any language that suggested you were giving an opinion to a reasonable degree of scientific certainty.
That is correct. It was not.
Okay. And then the next one, not that one, one more down. Not going to talk about race, ethnicity. That doesn't apply to this case, right? But 5.4 says, an examiner may not state or imply that forensic autosomal DNA examinations have a 0 error rate or are infallible.
That is correct.
And you followed that policy in this case, correct?
Yes, I did.
You're not in your report stating to the court that your testing has a 0 error rate, correct?
Correct.
You're not saying that the test is infallible.
I am not, no.
What is the source of error rates in DNA testing?
I'm
You can
sorry.
take that, though.
Can you clarify your question?
Yeah. When it refers to don't state that there is a 0 error rate, what in general are the sources of error in DNA, in the kind of DNA testing that you do?
A human error could be an error.
Mhm. Anything else?
Not that I can think of off the top of my head. One of the big things is potential human error. I guess you could also associate the DNA testing itself and how items are collected or how those items are tested.
Now, to your knowledge, that policy statement that we just read in Exhibit 7, Baker 7, was based on a more general Department of Justice policy, correct?
Correct, yes.
And that policy is called the Department of Justice Uniform Language for Testimony and Reports for Forensic Autosomal DNA Examinations using probabilistic genotyping systems, correct?
That is correct, yes.
And could you display 8 for us, please, to the witness? Let me know when it's on. No, not on the big screen.
Okay, so not to go onto this main big
Correct,
screen.
this is
Thank
just
you.
for the witness. And you're familiar with that policy, correct?
Yes, I am.
Okay. And does it contain a statement that support for inclusion is an examiner's conclusion that there is evidentiary support for the inclusion of a known individual as a possible contributor to the DNA typing results obtained from an evidentiary sample?
I believe it does, yes.
And did you follow that procedure in this case?
Yes, I did.
All right. Does this same policy state at page 4 Fourth down. One more. No, next one. An examiner, does a policy state, an examiner shall not assert that a likelihood ratio of any magnitude provides an absolute identification or source attribution of an individual to an evidentiary sample.
That is correct. Yes, it does state that.
And you followed that procedure in this case, did you not?
Yes, I did.
You're not implying that those numbers that a previous witness quoted and are stated in your report provides an absolute identification of Mr. Robinson or Mr. Twiggs?
No, I'm not.
Okay. Thank you. You can take that down. Are you also familiar with a concept called formal activity level?
Yes, I am.
Tell the court what that is.
Formal activity level is determining an activity that causes DNA to be left behind on an object.
And does your laboratory have a policy about whether you can express opinions about formal activity level?
We do have a policy, and I cannot give an opinion as far as activity level goes.
And why is that?
That is because DNA can be left behind on an object for numerous different reasons. So just because DNA is on an item doesn't necessarily mean that an individual touched it or utilized that item. So because of that, we do not opine on what activity may have occurred.
And consistent with that policy, you cannot tell, if you interpret a piece of DNA as being present on an item, you can't tell when that DNA was deposited, correct?
I can't give an exact time, but there are some situations, if a piece of evidence has been buried for a long time or is in a river for a long time, it would be my expectation, based on my experience, that I probably won't get DNA off of an item that's been buried for 10 years, for example. However, I cannot give exact timing as to when DNA was deposited on an item.
And I was talking more about a situation where you actually find DNA on an object, be it a gun or anything else. You can't say when that DNA was deposited, correct?
Sure, that's correct.
And how long, in general, does the DNA persist on an item? Once you've made contact, how does DNA get deposited on an item in general?
In general, DNA can be deposited a few different ways, via body fluids such as saliva or blood, or skin cells. So touching an item or wearing an item, DNA could be deposited. Once DNA is on an item, if it's subjected to ideal conditions, it's out of heat and high UV, it's not subjected to any kind of cleaning or chemicals, it can persist on an item rather indefinitely. It can degrade slowly over time, but we've certainly worked items of evidence that are 40 and 50 years old, and we've been able to recover DNA.
Now, could you explain to the court the concept of degradation of DNA samples, what that means and what it suggests with your testing?
Sure. So degradation of DNA is breaking up the DNA. So if you think of DNA like a long rope, it's essentially taking that rope and cutting it up into pieces. Seeing degradation in a sample could lend me to believe that there may be, that sample may have been subjected to cleaning or high heat, an extended period of time. So I can't tell why an item is degraded, but looking at my data, I can tell if that sample is potentially degraded or broken down.
And two of the items that you examined were referred to as items 7 and 8, correct?
That is correct, yes.
One was a towel and one was a screwdriver.
That is correct, yes.
Were both those samples degraded to a certain extent?
May I refer to my
Certainly.
data?
They can't be sure it's him. There's only like a 1 in a trillion chance that it's him. So
So item 8 was the screwdriver from the perch. I would say that there was some degradation. As I look at the DNA peaks or the DNA data, in an ideal world, if there's no degradation, I would expect all the peaks to be at the same height. Here I see a ski slope type effect, meaning that the data on the left is a little bit taller than the data on the right. As far as item 7, item 7 was the tau. There was a slight amount of degradation, but not as much as item 8.
Okay. And what is the effect of degradation on production of the allele? First of all, what's an allele?
An allele is an individual's DNA type. So we inherit half of our DNA from our mom and half of our DNA from our dad. We're looking at something called short tandem repeats, or STRs. These are small segments of DNA that repeat themselves over and over again. We all have those same sections of DNA, but what might differ amongst us is how many times it repeats, and that's actually what we inherit from our parents. So for example, at one particular location, my mom may give me 14 repeats and my dad may give me 15. So when I'm looking at the DNA types, I would say that I have 2 alleles at that location, a 14 and a 15. As far as degradation goes, it could cause some of those alleles to do something called drop out, meaning when I'm looking at the DNA chart or the DNA data, I do not see information. I do not obtain numbers at that particular section of DNA.
And is it true that in the testing that you were doing in this case, STR testing, what you were looking at is the length of the, what I'll call, have you ever heard the boxcar analogy?
I have, yes.
Tell the court what that is.
So the boxcar analogy is how many times that section of DNA repeats. So that section is essentially letters. So for example, A, C, T, G. So you may have A, C, T, G repeated 10 times or 12 times. Each of those sections of H, C, T, G would be considered one boxcar.
And so when you're looking for alleles, you're essentially counting the boxcars. Could be 7 boxcars, and that person would be a 7.
That is correct, yes.
And from the mom and from the dad, he may have inherited 10 boxcars.
That is correct, yes.
And so that person at that particular location would be a 710.
Yes.
And what you're doing in your testing is comparing those numbers to what you get from a known sample to see if they match.
That is correct, yes.
Is that true?
Yes.
Now, is it true that what you mentioned the A, C, T, and G, correct?
Correct, yes.
Is it true that you are not measuring the sequence within the boxcars? You're just measuring the length of the boxcars.
That is correct. So the sequence would be equivalent to letters in a word. What I'm looking at is the number of words versus the letters that make up that word.
And we'll talk about this a little later, but people can vary not only in the length of the boxcars, but in the sequence within the boxcars, right?
And that is correct, yes.
And what your testing looks at is just the length.
Correct, yes.
Okay. Now, for the, and is it also true that you're looking across many different locations?
Yes. So at the FBI laboratory, we use a kit called Global Filer, and this is looking at 21 different locations on a human's DNA, in addition to 3 sex-determining locations. That lets me know if an individual is biologically a male or a female.
As between 2 individuals, 99% of their DNA is exactly the same, right?
That is correct. And that makes sense. We're all humans. We all have arms, legs, and a head. Less than 1% of our DNA is what differs amongst us, with the exception of identical twins.
But with the within that 1%, you're looking at these length differences, correct?
Correct, yes.
And you're looking at what you called short tandem repeats.
Yes.
How many, you said you looked at 25 locations?
We're looking at 21 and 3 sex determining, so 24 total.
What are the sex determining? They're called the locus, correct?
Correct. So locus is that individual section of DNA.
Right. And they typically have names or numbers associated with them, correct?
Yes, they do.
So what are the sex determining loci?
So there is amylogenin, and that lets me know if an individual is male or female. And then there's two specific male sex determining locations. One is Y-indel and one is DYS 385. Those just let me know that those are specific to male individuals.
Okay. And then for the other locations you're looking at, those you're just looking for two types at each location, correct?
Correct, yes.
Okay. Now, for the samples that you looked at, the 7A and the 8A, did you get a full, what's called a full profile would be a profile where you have all 23 locations present?
That is correct. So a full profile means I have DNA at every single location. It is above our threshold, and I'm seeing one or two pieces of information at each location. For item 7, I did develop a full profile.
For item 8, you developed a full profile?
Item 8 was a partial profile, so I did not develop DNA at every single location.
Okay, so what that means in your comparisons is you have certain information in the question sample that for whatever reason doesn't appear, correct?
Correct, yes.
So you can't make a comparison at those locations.
That is correct.
All right. What makes it not appear at certain locations?
So it could be that there's degradation. So those larger locations could be broken up so that it wasn't detected during the DNA process. It could be a low level amount of cellular material to begin with. So if I only have a few cells, I may not have enough to detect at every single location.
Okay. And for the 8-1 sample, did you measure Mr. Robinson and Mr. Twiggs's DNA at the 23 locations?
For item 8, I did not have a full profile, so I did not have data at all 23 locations to compare to either Mr. Robinson or Mr. Twiggs.
Right, but you had full profiles for Mr. Twiggs and for Mr. Robinson, right?
For their known sample?
Yes.
Yes. So for their known sample, that was a sample that was taken directly from those individuals, and I did develop a full DNA profile.
Okay. And just to illustrate how this works, is one of the loci that you looked at called the DYS 391 loci?
Yes, it is.
And what type was Mr. Robinson at that loci?
At that location, Mr. Robinson was an 11.
And I think you said you inherit one from your mother, one from your father. But when you say he's an 11, technically he's what's called an 11-11, correct?
So for this, so DYS 391 is actually that male location. So he would not have, or anybody would not have inherited anything from their mother. So at this location, I would only expect to see one piece of information, and I did see an 11 here.
Okay. And for the D3S loci, what was his type?
His type was a 17.
Now for that loci, you'd expect two types, correct?
That is correct.
And when you say he's a 17, do you mean he's actually a 17-17?
That is correct. He inherited 17 repeats of that location from mom and 17 from dad.
Other locations, for instance, the VWA, he's type 18-19, correct?
That is correct, yes.
So you're looking at those, and what the machine produces are peaks, correct?
Correct, yes. They're just spikes on a graph, similar to like spikes on a heart monitor.
And you said for 8A, you had certain locations where the test sample didn't have any results.
That is correct.
So at the TPOX location, Mr. Robinson's a type 8-9, correct?
That is correct.
Mr. Twiggs is a type 811,
That is correct.
but when you looked at the sample 8A, it didn't have any of those types.
That is correct. So I could not compare at that location.
Now, are there certain rules for when you exclude someone? In other words, when you're comparing two samples, are there rules which say, here's where I would conclude that he could not possibly have contributed this sample?
Yes.
Your field has a lot of literature written about it, correct?
That is correct. Yes.
And do you generally like to keep up with that literature?
I do. Yes.
And across time, there have been several books, publications that attempt to educate you and courts and lawyers on the technical aspects of DNA testing, right?
Correct. Yes.
One of the books, the early one, DNA Technology and Forensic Science by the National Research Council.
I'm familiar with that. Yes.
That's an authoritative book that was really one of the first books on DNA testing.
Yes.
All right. And then by the same organization, National Research Council, the evaluation of forensic DNA evidence,
Correct. Yes.
published in 1996. So you're familiar with that as well.
Yes, I am.
And then there's an author, I believe, who did his research work at the FBI named Dr. John Butler.
Yes, I'm familiar with him.
And you have studied his work both in your training and your continuing education.
That is correct. Yes.
And he's got 3 current textbooks on the topic that we're talking about, right?
I'm not familiar with how many textbooks he has. I know at least the one.
Fundamentals of Forensic DNA Typing,
Yes.
familiar with that. Forensic DNA Typing Methodology,
Yes, I'm familiar with that one as well.
and Forensic DNA Typing Interpretation.
Yes.
Everybody in your field relies on these publications and use them as teaching tools.
Yes, I would agree with that.
And then in addition to those books, there have been studies that have been done on particular topics, correct?
Yes.
This case, we're dealing with mixtures, correct?
Yes.
And mixtures present certain challenges that are not present when the samples are not mixed, correct?
Not necessarily. So first, to define a mixture, that simply means DNA from more than one individual in a sample. So if I were to take a sip from a coffee cup and my husband were to also take a sip, if I were to swab that coffee cup, I would get a mixture, his DNA and my DNA together. As far as it being difficult, you can have some mixtures where there's one contributor that donates a lot of DNA and the second contributor donates a little bit. For DNA interpretation, that is not challenging for me. Where it can become challenging is if you have 4 or 5 individuals within that sample all donating roughly around the same amount, it may be challenging for me to determine if a person is included or not.
And would you also agree that that
Turn
challenge
down her
exists in
voice just a little
situations
bit.
where you have what are called low quantities of DNA?
Again, that could be possible. So I could have low quantities of multiple individuals, which is simply just saying that I can't determine which piece of DNA goes with which individual. So that's possible.
What is drop-in?
Drop-in is where you have environmental DNA that's not inherent to that sample that's detected during our DNA process. DNA testing is very sensitive, so it could be that we have a peak that's detected, like I said, from the environment.
And what is dropout?
Dropout is when you have an allele that is not detected or a piece of DNA information that is not detected. So in the DNA chart, there is no number associated with that particular location.
And degradation can cause dropout?
Yes.
So if you have a person at a particular location that is a type 1415, and because of degradation, that 15 drops out, what you're seeing on your chart is just the 14, right?
That is possible, yes.
And that presents a certain challenge, does it not? Because if the 15 is not there, you could misinterpret that as a type 1414. correct?
Not necessarily. So we have thresholds. We have something called the stochastic threshold. If that 14 is above that stochastic threshold, I'm confident based on our validation, our testing, and my training that the DNA type there is only a 14. If that 14 falls below that stochastic threshold, that could be indication that there is another peak. So when I'm interpreting, when I'm comparing, if that 14 is below threshold and someone is a 14, 15, I will not automatically exclude them.
What is stochastic effects?
Stochastic
I'm
effect.
going to object at this point. I think we've gone beyond the scope of preliminary hearing. I think this is getting into 702 material that's not necessary for the probable cause determination.
All right.
I think
Mr. Burt?
it goes directly to the reliability of the testing results that the state introduced. I think the court has to understand the limitations and the potential sources of error in order to assess whether these results are reliable.
Thank you, Shababy. Get in there.
In
Cook
regards
food.
to this line of questioning, how
Thanks
far
for
are you going
tuning
to
in.
go on this line of questioning?
I have this one question and then I'm moving on.
All right, Mr. McBride.
I'll hold them to that.
All right, well, Mr. Burt, so the objection is overruled. You may proceed with that question.
You can answer.
Could you repeat your question, please?
Tell the court about stochastic effects.
Stochastic effects, when you have low-level samples during the DNA copying process, based on how the DNA is copied, you could have alleles that are copied better than other alleles.
Okay. Now, on another topic, I mentioned studies before. One of the studies that you're familiar with is called the PCAST report. Are you familiar with that report?
Yes, I am.
And tell the court what that is.
PCAST stands for the President's Council of Advisors on Science and Technology. And this was a committee that was found, I believe, under the Obama administration that gave guidance on different areas of forensics.
Including how to deal with mixed samples and how to deal with samples that have low quantity of DNA.
I don't know that I would agree that it's how to deal with them. They gave some of their concerns on low-level samples and mixtures.
Right.
Thank you,
And
Toledo.
they also
Toledo.
did a follow-up
glad
report
to
to
hear that.
assess whether using the kind of software that you used in this case had been established as reliable, correct?
That is correct.
And what was the software that you used in this case to reach your statistical results?
The software is called StarMix, STRMIX.
And the PCAST reports,
You mean like Operation Star Mix? That's what we're going to hear. Oh, I can't wait for her to pull that out. I know there's not an Operation Star Mix, but it sure sounds like something Candy would say.
specifically addresses whether reliability has been established with respect to StarMix, correct?
I don't believe reliability came into question. I think PCAST thought that there needed to be additional testing as far as mixtures and low-level samples go.
Mixtures and low-level samples that had certain characteristics, right?
That is correct, yes.
Including mixtures where what's called the minor contributor was in the sample below 20%.
That is correct. So the minor contributor would be an individual that donated less DNA to that sample. So PCAST called into question mixtures of 3 or more individuals with that minor or that low-level contributor making up 20% or less.
7 and 8 samples in this case were both mixtures, correct?
Yes, that is correct.
And did you determine what the proportion of mixture was between what I'll call the major contributor and the minor contributor?
So I did not calculate that personally. Part of the StarMix software, it does a couple different things. One, it takes a mixture and it uses math and biological modeling to try to break that mixture into its individual contributors. And then it also calculates a likelihood ratio, which is the statistic that I report. During that process, it does give an estimate of the breakdown of those potential contributors.
And what was, first of all, for the 7 sample, was the minor in there at less than 20%, according to StarMix?
Yes, it was. For one of the runs, when I compared to Mr. Robinson conditioning on Mr. Twiggs, it was a 5% to 95%.
And how about for the other sample?
For item 8, one of the contributors was 11% and the other was approximately 89%.
So below 20%, right?
Correct, yes.
And the concern expressed in this report, which was written by experts in your field, correct?
No, that is not correct. The PCAST report was written by individuals that were not practitioners or any type of laboratory personnel.
Right, but they list the experts who provided input into that report, do they not?
Yes, they did.
One of them was Bruce Bedoli, correct?
Correct, yes.
Who's Bruce Bedoli?
He is a DNA expert within the field.
Well, he was the head of your unit for a number of years before you came on board, wasn't he?
He was, yes.
And he's written extensively on forensic DNA testing, has he not?
He has, yes.
The report also lists Eric Gilkerson, correct?
That name does not, I do not recall that name.
Forensic examiner for the Federal Bureau of Investigation Laboratory.
I don't recognize that name.
How about Bruce McVicker, forensic examiner, Federal Bureau of
Objection,
Investigation?
Your Honor. I'm going to renew my objection. I think this is beyond the scope of determining probable cause. The standards that apply here are that the court weighs the evidence in the light most favorable to the state and avoids credibility and balancing the evidence to the stage. I think we're far
Sustain.
into 702.
I'm going to
territory at
sustain
this
that
point.
objection.
Mr. Burton.
I'm not sure I understand the objection into 702 territory. 702 deals with reliability of evidence. That's what the court is here to determine. So again, it's directly relevant to reliability. This report criticizes, for the specific samples she's using here, the reliability of this testing. And her response was, oh, but they weren't experts. But the
I'll be covering this trial hearing all week, covering every bit of it. I don't want to miss a moment of it.
report indicates that there were experts who were consulted on this report. So I think it is relevant, and I think it goes to the issue of reliability, and it's the only question I have on this area as well.
Anything further, Mr. McBride, or do you wish to respond to that?
Just that 702 deals with admissibility. It does discuss reliability, but it's directly related to admissibility of the testimony at trial under the Utah Constitution and under the robust case law in this area. The court does not weigh the evidence, draws the inferences in the favor most in the light most favorable to the state. And I think we're beyond that point now, getting into the admissibility questions.
All right. Anything further, Mr. Burt?
No, Your Honor.
All right. Well, as this is the last question, I'm going to overrule the objection, but as a reminder to all parties that this is a probable cause standard, and as it relates to, well, I will just leave it at that.
Are you familiar with that analyst?
No, I'm not.
Okay. Just to close the loop on the PCAST report, what they said in the report was that published evidence
Both said 9-2.
supports the foundational validity of probabilistic genotyping with some programs of DNA mixtures of 3 individuals in which the minor contributor constitutes at least 20% of the intact DNA in the mixture, and in which the DNA amount exceeds the minimum required level for the method. Isn't that what they concluded?
That sounds accurate, yes.
And do you know why the level 20% raises reliability issues?
I do not know.
Okay. But you do know that in this case, both your samples had minor contributors below 20%.
That is true, but in this case, it was also only a mixture of 2 individuals.
All right. Now that's the next thing I was going to ask you about, which is what is NOC?
V. Scott.
NOC.
She knows what she's talking about. Now I want to bully you, V. Scott. Freaking nerd.
Stands for number of contributors.
And when you use this program, this genotyping program, StarMix, who decides what the number of contributors is?
That's my determination based on my experience and training, looking at the data. That's something I input into StarMix.
Right. And that's a complex determination, isn't it?
Well, Jim is tooting my horn. I'm going to add to that. I've brought on legal experts, multiple of them. I've also brought on multiple eyewitnesses, all of this, everything that Jim is saying. I'm assuming he's saying audio specialist. Done all of this. We did a 3D mapping survey of the entire place, gave that free to the public so they'd have a 3D model with the help of CJ Correnti and his team. We went there. We've had multiple people on with eyewitnesses. We've brought on different experts to talk about different things. Like, she has a lot more resources than I do. She hasn't done any of those things. She could have retired forensics experts coming on and doing all those things. Like, she could have a whole team of people, legal analysts, private investigators, former forensics people, bringing on different lawyers to go through the case. She's never done any of those things. Just common sense approach to any sort of legitimate investigation. She's not going to do that. She has to control the narrative, and she doesn't want these people coming out there and saying something that's off messaging, right?
That's exactly what would happen.
Sure.
That's exactly why she doesn't do it.
No,
Did
100%.
this report conclude that it remains
It's narrative over the truth every single time. She has a narrative. She has to push it. She doesn't care about the truth.
unclear if visual inspection
That's not true.
renders consistent
That's
number
not
of contributor
apparent to you.
estimations across analysts over time?
I sent you the
you repeat?
exhibit list.
Did the report
What'd you say? What'd you say you sent me?
I sent you the exhibit list.
Oh, perfect. Thank you.
the NIST report that you referenced conclude that it remains unclear if visual inspection renders consistent number of contributor estimations across analysts over time?
I think that goes to the DNA evidence. Again, we never truly know the number of contributors in a forensic sample. So like I mentioned before, you could have DNA mixtures that are made up of 2, 3, 4 individuals. I have training, I have experience, I followed standard operating procedures. So I'm making the best determination based on the evidence, the DNA evidence that I have as far as number of contributors goes.
Now, if I could, I'd like to return to your case notes, and could you display for the witness page 365 of tab number 4? And while he's doing that, by the way, it's true that if you change the number of contributors, you're going to get different numbers from the software program.
It depends. So actually, each time you run the software, you will get a different number based on the math that the software system does. But there are studies and validations that show we don't expect that math to be greatly different, usually by a factor of 10. Changing the number of contributors, it depends. If you have a major contributor, someone who's made up most of that DNA profile, if I originally interpret something as 3, calculate a statistic, if that major contributor is the individual that I'm comparing to, if I change the number of contributors to 2, based on the studies and based on my own experience, it doesn't change the likelihood ratio of that major contributor by much.
But it does change it, correct?
Yes.
And you just said, I think, that even when you put in the same parameters, you don't get the same answer if you run it through STR mix more than once, right?
That is correct. Based on how Star Mix utilizes math and distributions, you will never get the same answer twice, but it will be no more than a magnitude of 10.
So the
Bring real receipts.
that test is not reproducible in the sense that you can run it a sample or your assumptions in there 10 times, you could get 10 different answers.
That is true. Again, all within the first
Thank you,
time I
Beth.
run Star Mix, I'm not going to get a likelihood ratio of 10, and
Appreciate
the
you.
second time get 10 quadrillion. I might get 10 quadrillion the first time, 2 quadrillion the second time. But even if I run it 10 times, I'm still going to get around the same likelihood ratio value.
Now, could you look at tab number 4, your case notes at page 365, if you could bring that up for the witness? Let me know when you have that in front of you. I think you need to scroll up.
Get those likes up,
Page.
folks. Let's get 1,000 likes. Let's do it.
I also
There we
sent
go.
you a
Can you identify
like
this
graphic
page
that
from
has a
your notes?
QR code for
Yes, I
socials
can.
for Patriot
These-
Source.
Perfect. Okay. I will put that up.
Were
You don't have
notes
to do
that
it right
my
now.
technical reviewer made, and my technical reviewer, they will review all of my DNA evidence. They will draw their own conclusions as far as number of contributors and comparisons, then compare it back to my conclusions.
All right, so this is regarding the 7 sample, correct?
That is correct. That is one of the samples.
And your original assessment was that there were 3 contributors to this sample, right?
That is correct, yes.
And that conclusion was reviewed by a reviewer, correct?
Correct, yes.
She read the same electropherograms are the name for the output of this technology you use, correct?
She utilized the same electropherogram, which is the chart that the DNA is on.
And does this page in front of you, is that an accurate representation of your case file?
Yes, it is.
I move into evidence page 365. And that would be Baker 4.
Mr. McBride?
Yeah, I'll object on relevance grounds.
All right. Did you want to respond, Mr. Burt?
Your Honor, it's relevant because the witness originally determined that there were 3 contributors. And I'd like her to explain to the court how she reached that conclusion, because I think it does go to the reliability of her testing here.
All right. So as it relates to Baker 4, and this is her personal notes from Ms. Baker as it relates to what I'm assuming is State's Exhibit 31, these notes were prepared as part of the report in State's Exhibit 31. I will find that it is
Your Honor,
relevant
Your
and that it is admitted into evidence as regards to publication. What is the request?
Your
Mr.
Honor,
Byrd?
if I may clarify, I think the testimony was that this was not her notes. That these were the notes of her technical reviewer, is what I heard.
Please correct me if I misheard that from both sides. I want to
Yeah, I
make
did.
sure. I want to make sure, are these Ms. Baker's notes?
Could I clarify that?
Absolutely.
Ms. Baker, these are notes in your case file, correct?
Hey,
These are notes in
Pasto.
my case file, but they're not my notes.
And the way your lab works, you're not the one that does all the different steps in the testing process, correct?
That is correct.
Other analysts have input that then all goes into the case file, which you have access to and rely upon in rendering your opinions.
That is correct, yes.
All right.
And this particular page is a note written by your peer reviewer.
Congrats,
that you
Two Goats.
relied upon.
Good to hear, buddy.
Correct. After I made my interpretations and drew conclusions, my technical reviewer then reviews the data and draws their own conclusions. So this was created after I had already drew my own conclusions.
All right, I'm just trying to put it together here. So the question I'm trying to get to, counsel, is, was this particular, and I recognize it as it being prepared by someone else, but as it relates to States Exhibit 31, was this relied upon in order for States Exhibit 31 to be put together as the report? Because I'm trying to determine relevancy as it relates to that, and that's a crucial point I don't have the answer to just yet.
Okay. Let me lay a more adequate foundation. The case file notes are assessed by you at every step of the analysis, correct?
Not necessarily at every step. Before I issue a report, before I write a report, I review all of the case notes. So that will be any communication log entries, any documentation from the laboratory, the biologists that perform the DNA testing. I will review all of that, write a report, and then give that to a technical reviewer. They will draw their own conclusions to determine if they agree with me. If they do, they will sign off, and then my report and my case file will go for an administrative review to make sure that the laboratory number is correct on all the pages, that if there's any crossouts, there's dates and initials and so forth.
We'll see you.
Those
Well, thank you for
two
stopping that, buddy.
reviews have to be done before I can actually make it a final report and case file.
If you haven't done so already, folks, like, share, subscribe, all those things. If you'd like to support the channel, down in the description below is a link. You can become a contributing member. It's a couple bucks a month. You're not even going to notice it. Also on X, make sure you're following us on X and you can become a subscriber over there as well. Again, a couple bucks a month. It goes a long way to support what we do. Thank you.
I did it today. You're my first, Gary.
All right.
That gets submitted
In a PG
and
way.
sent to the field.
In a PG
And
way.
in this case, correct me if I'm wrong, but the sequence was you originally determined in sample 7, that there were 3 contributors. That conclusion got reviewed. Then you ran some further testing, and then you change your conclusion, correct?
That is correct, yes.
Right. And before you change your conclusion, you of course go back and look at what the reviewer said about her review.
We would have a discussion. If I say a number of contributors was 3, he or she notated that it was 2. We had that discussion. She agreed with 3. So for that step of that process, because again, we're piecemealing this. Typically in a normal case, we will work all of the evidence. I will write a report. For this situation, I had DNA evidence coming to me throughout the day, throughout the night. So I had reviewers at different steps, which is not usual for a case. Usually I have one reviewer. So in this case, that
I would consider prosthetics.
Yeah,
Like
just cut it off.
Like there's so many good prosthetics. Like just
Yeah.
let's out with the old in with the new.
at that
You don't even
particular
need that
time, I
hand
had a
anymore.
reviewer. Then when I was submitted additional known samples and used those for comparisons, then I did have additional conclusions and additional reviewers.
But you certainly took into account this notation on this page before you change your conclusion, correct?
I don't know that I would agree that I took into account. We had already had that conversation. And again, once I received additional known samples and additional information from the field, I then did amend my conclusion.
And these notes
Bill's
are
back
kept
in
in
the
the
chat.
ordinary course of your
Hi, everyone.
business.
Yes.
And they're part of the case file that you rely upon in reaching your
Exactly.
conclusions.
They are kept with the case file after I draw my conclusions.
So Your Honor, I think there's a foundation for this. The state has offered all kinds of hearsay here, and certainly this is, there's no question about the reliability of the entries.
Anything further from the parties before I weigh in on, well, make my ruling on Baker 4?
No.
We still in the middle of an
The court
objection.
finds that it is relevant and as it relates to State's Exhibit 31 and Baker 4 is admitted into evidence. In regards to publication, Mr. Burt, what is your request?
That it be published
All right, to in the courtroom.
in both the courtroom and to the cameras.
All right. Any objection, Mr. McBride?
To be clear, Nana Deborah, I don't even think that's what's being discussed right now. They're not talking about throwing it out or anything else. I don't know how much you heard of all that argument, Gil. That didn't seem to be what they were discussing.
No, I've been missing everything. I'm not gonna
Yeah, no worries.
force you to reiterate, but yeah, taking care of a sick daughter and got to get some stuff done. So
No worries. No worries.
yeah.
All right, go ahead and publish that to all screens and may be captured by the media.
So these notations at the top there, 7-1 mail, discuss 3 NOC and okay with 3. Could you translate that for us, what that means?
Sure. So when my technical reviewer took a look at the DNA evidence, she determined that male DNA was present, and she concluded that she would have called it a number of contributor of 2. She compared it to my
Yeah, no, this is a defense lawyer. So we're clear. This is the argument of the defense. They're basically impeaching the results of the DNA tests. That's what's taking place here, folks.
conclusions. I said number of contributor 3. So we had a discussion as to why she thought it was 2, why I thought it was 3. And she said she agreed with me calling it 3 based on our discussion.
Okay, so was that an extended discussion you had with her or just?
No, this was a quick discussion, and this is not unusual. We have discussions like this during the technical process quite often.
And the stamp on the bottom, approved by Tara Benson, is that the reviewer?
Yes, it
we're
is.
Talking about? All right, thank you. Now, I want to ask you to look at page 128 of that same exhibit. No. Is this an electropharogram that is a part of your case file?
Yes, it is.
And is this an accurate representation of what's depicted on this page?
I'm sorry, there's nothing on the screen. Am I?
Yeah, 128.
Make sure myself. 9 toasts
Make
is
sure.
appropriate testimony. I consider it a career DNA forensic examiner.
Yes, it is.
I move that into evidence, Your Honor. This would be.
All right, I'm tired of talking about this. All right, just throw the DNA out. I don't think like, just throw-
1828.
I'm done with it.
Oh, I thought I already admitted Baker 4. Is this
I would
different?
need like hazmat, like rubber,
The previous one was
thick
Baker
gloves,
4, as I
or like
understood it.
an electrician.
For page 365.
Oh, okay. So
And
Baker,
so this is Baker 4, page 128.
right, so the previous admitted exhibit is Baker 4, 365. The current proposed one is Baker 4, 128.
That's correct.
All right, Mr. McBride.
I would never
It's like
kick
I'm
you
just
out,
a minute to
SK.
update my notes on those page numbers.
All right.
I just live here now.
365 was the previous one, unless I heard it wrong.
Yes, that's right.
All right, and the current one is 128.
I just don't want to do this alone. I just don't want to.
Hey, I'll be here for you. Tomorrow I don't even
appreciate
have
You've
gymnastics.
been
I'll
great.
be here
I
for
love
you.
it. I love it.
I just
love
don't want to like move in and overstay my welcome.
You're good. You're good.
First, I'll note, this is the first I'm seeing these as exhibits. Of course, I have this file, but I was unaware that we were going to be, these are going to be offered as exhibits. So I'm looking to find them in my file as we go. Second, again, I'm going to object on relevance grounds to the probable cause determination. We're going through the finite details of the analysis here. And once again, I think these are appropriate questions to raise in a 702 hearing. But when, with the standards that apply at the preliminary hearing that I've already discussed, I think we're beyond the scope of probable cause determination as we dive into this evidence.
All right, Mr. Burt.
Your Honor, I think this exhibit is particularly important because the court does not yet have in front of it what an electropherogram is and how it's interpreted. And this particular page will illustrate to the court how the analysts interpreted the peaks on this electropherogram to reach the conclusive court and looks like.
So I'm viewing today's Exhibit 31 as a summary, and this more of showing the work of how the summary was reached. Am I misunderstanding how this fits in?
This fits into how the analyst originally was of the opinion that there are 3 people here and not 2. And she will go on to explain how she changed the interpretation from 3 to 2. And the point of this is to illustrate to the court that this is a subjective process to a certain extent, and that people can read these things in different ways. And so I think it will help the court understand exactly what's being compared here. You've got peaks on a line. He and I met with this analyst, out to us, and he concluded that there were 3 contributors. So this is not something that's being sprung on the page, was identified by the analyst from 3 to 2.
All right. Anything further?
No.
All right, under Utah Rule of Evidence 1102, B4, it says scientific, laboratory, or forensic reports and records. I find that this is admissible and is admitted into evidence as Baker 4, page 128, and is a request to publish this document.
Okay. You can
Was that a yes? Oh, okay.
Yes.
All right. So published, I'm assuming to that
Yes.
screen as well. All right.
Correct.
It may be published. Counsel, just as a reminder, as this is a probable cause, I understand and I appreciate you give me a pointer of where it's going, but just as a reminder, as probable cause, is it?
SK, Gil, and anybody else in the chat, when we get to a point where we can, remind me, I am going to go over the evidence list, and it also is the witness list. I think that tells us a lot about what we haven't seen or who we haven't heard from so far, because I do think that is relevant to this case. So please don't throw it out, Your Honor. But
I'm
anyway,
trying to see if I can buy the DNA report because I know it's been submitted, but I'm trying to find it on the docket to see if it's available for purchase. I kind of want to know what type of DNA it is because they haven't said that, have they?
I think they've covered everything you could possibly cover about DNA. Whether it's RNA or
No, whether it's touch DNA, whether it's like bodily fluids, saliva.
You opened up a whole
semen.
other world to me. I was just going with touch DNA. So,
Yeah, no, that's why we've been joking about the
DNA.
crusty
Let me tell you,
towel.
as far as I want to know, it is just touch DNA. If you find anything else, please don't share that with me. I don't want to know it.
Skin
I don't want
cells,
to have.
you never know. It's skin cells.
We'll
It's probably
discuss
skin
it,
cells.
but I definitely want to keep this within the track of probable cause.
I don't want to know.
All right.
Thank you.
Mr. Burt.
List.
Okay. Is it true what I just told the court that you pointed this particular
Furry
page out
DNA.
as illustrating
Hey,
why
Pasto.
you originally thought we had 3 contributors?
Yes, that is true.
So explain to the court, is this an electropherogram?
Yes, this is an electropherogram. Each of those rectangles at the
This
top,
works
for
out.
example, D2S441, that is that small segment of DNA that I referred to earlier.
Sorry,
And
Sam.
each of those peaks has a
Sorry,
corresponding number that is
There we
the allele. So that corresponds to
See?
the number of repeats that an individual
We got Nana keeping us straight.
inherited.
And this is what you
Leave it to the
ultimately,
mature
after
one.
you get this electropherogram not through running it through STR mix. There's a different device that you use to produce these electropherograms, right?
Correct, yes. During the DNA process, this is the last step of that process. So what it's doing is so we DNA is found in cells of our body. We're taking those cells, we're breaking them open with chemicals to release the DNA from those cells. We're making photocopies of those pieces of DNA so that we can essentially see them. And then the last step is to separate those pieces by size, and the ultimate output is this electropharogram.
Okay. And is it true that you set the parameters for what the machine will pop up in terms of numbering the alleles?
Personally, I do not set that up. That was done during our validation of the chemicals and the software and the instrument that we utilize. But there are parameters. So the output of the DNA lets me know, for example, the different types of alleles, but that's not a parameter I set.
I want to make sure you answered that. You set, or your lab sets, what the machine does in terms of labeling particular alleles, correct?
Yes, that's part of the whole process and the validation, yes.
So you could tell the machine, give me all the peaks at whatever level and label them as whatever the alleles are.
I see. So yes, so during our validation, we determine our thresholds, our analytical threshold, and that stochastic threshold that I mentioned before. The analytical threshold is a threshold that was determined during validation that we input into the software that I utilize. That says, for example, our analytical threshold is 150. Any peak that is 150 or greater, the software system will give me that allele call or that number for that peak. Any peak that's below the 150, the software system will not give me an allele call for it.
Even though it might be a true allele.
Correct, yes.
So you could say, and you referred to a measurement, you refer to that as RFUs, right?
Yes, that is the unit.
What does that mean?
It stands for relative fluorescent unit.
So in your lab, you tell the machine only label peaks that come above 150 RFU.
The software that utilizes the information from the machine, yes.
However, it's true, is it not, that in determining the number of contributors, you look below that 150 RFU level.
And that is true, yes.
All right, now on this is only showing 1, 2, 3, 4 different locations, right?
Correct, yes.
And you see a number of peaks at each one of these locations. Some of them are labeled, some of them are not.
Correct, yes.
So tell us how you originally looked at this and said there's not 2 contributors, there's 3.
Sure. So first what I do is I count how many labels that I see. So how many of those little squares under each of those locations. So for example, at D2S441, there are 3 squares. Knowing that one piece of information comes from mom and one comes from dad, if it's a single source profile from one individual, I expect to see no more than 2 squares. Because I see 3, that gives me an indication that there's at least 2 individuals. Same
Kids
thing
are gonna have to
for
tune
the
out.
next
We're getting a birds and the bees talk.
D19S433, and as well as FGA. There were 3 peaks that were called. So I knew this had to be at least 2 individuals. Then what I do is I take a look at the peaks that are not called and determine, could there potentially be a third person?
Is self-immolation an option? A third option to that? Just saying.
Included. So for example, at D2, the location farthest to the left, I'm asking myself, that 12 in that bottom box, is it the same contributor as, for example, the 22 under FGA all the way to the right? Because I see peaks that are not labeled, it could be that the 12 belongs to one individual and those 2 peaks that are not called belong to a second or third individual. And that at FGA, I could be seeing the 22 from that third person, but that second person has dropped out. Because I'm able to use information below the threshold and I see peaks, that gives me an indication that I can increase my number of contributors to 3, which I did in this case.
Okay, and when did you reach that conclusion, time-wise?
All right, folks, I just posted, posting this poll down in the chat. Make sure you guys, if you haven't participated in, I did it earlier before we went to lunch. If you haven't participated, I want you to participate in it. Open up another browser. You can still listen, all those good things, but give you a chance to wake up a little bit.
If I recall, it was somewhere around September 12th.
And when did you change your conclusion?
That I would have to refer.
Sure.
I've never seen this level of detail anywhere near this level of detail on any prelim before.
Well, the defense, to your point, the defense has objected multiple times. I mean, the prosecution has objected multiple times, saying like this is beyond the scope of what we need for the preliminary. And you have the judge overruling him, I think 2-3 times now, saying he's going to allow what they're doing.
I
So-
changed my conclusion on September 13th of 2025.
And explain to the court why you changed your conclusion?
I was submitted an elimination sample from Mr. Twiggs, and an elimination sample is a sample in which it's from a known individual, and then there's an expectation that the individual's DNA might be present. In receiving that sample and talking to the investigators, it was decided that Mr. Twiggs should be used as an elimination. When I compared him to this sample, all of the DNA, unlike that major contributor, matched to Mr. Twiggs. So because of that, I determined that there's actually only 2 individuals because those small peaks, there was nothing left for a third individual to be compared to.
Process of elimination.
You use a phrase elimination sample. That's typically used, is it not, in a situation where you're testing a sample that has more than one contributor?
Not necessarily. An elimination is just simply an individual that we're expecting their DNA to be there. So for example, if we have a stolen vehicle, I will request an elimination sample from the known driver of the vehicle so I can subtract out their DNA to see what I have left over. It doesn't necessarily have to be more than one individual. There certainly has been times where I only detect that known expected individual.
And you said you had a conversation with the investigators as to whether Twig should be included as, or you talked to them about whether you should get elimination samples?
I talked to them with regards to if I should utilize Mr. Twiggs as an elimination versus comparing him and offering a statistic.
Okay, but in your report, you concluded, did you not, that one of the contributors to both samples was Twiggs?
That is correct, yes.
Right. You didn't just assume that, you reached the determination that he was the source of both those samples, one of the sources, right?
I don't want to use the word source, but knowing that there was an expectation that his DNA could be present, when I compared him to that DNA sample, I did see his DNA types present. So using the word assumed, that's verbiage that we use when we calculate our statistical calculation. I'm letting the software know, I know this individual is there. I'm assuming that they're there. Based on my comparisons, I did see evidence that that person was there.
But I guess what I'm confused about is we talked before about how your language should never imply an absolute identification. But in the body of your report, you say that one of the contributors is Twiggs. You don't say he's a possible contributor like you do for Mr. Robinson. You say he is a contributor, do you not?
I do, and with elimination samples, that's slightly different. So for example, let's say I have a sexual assault case and I have a vaginal swab from a female. She has a consensual partner. I can request an elimination sample from that
she is
consensual
assuming
partner.
gender again.
If I see that they're present,
God.
I can say they're present and say the DNA foreign to that victim and that consensual partner is one person, for example. So it's different than comparing a known individual. If they're an elimination sample, I can say that I expect their DNA to be there, and based on my interpretation and reviewing that data, they are present.
And based either on your conversations with the agents or other people, why did you think that Twiggs was someone whose DNA you would expect in those 2 samples?
So from what I recall, in speaking with the investigators, Mr. Twiggs was a roommate of Mr. Robinson, and it was thought that those items came from potentially Mr. Robinson's home. And I don't recall exactly if it was a situation where a particular towel was known to have been in that house. I don't remember that exactly, but in talking to the investigators, based on their investigation, it was important to assume potentially Mr. Twiggs was present.
Right. Did any investigator ever tell you that the towel did not come from Mr. Robinson's home, but was found in a bush out at the university?
I was aware of that, yes.
So you knew that that towel was not found in a place where you would expect Mr. Twiggs's DNA to be present.
That is correct. It was found outside of a home, but again, based on speaking with the investigators, they had information to suspect that that towel came from Mr. Robinson's home, and I should utilize Mr. Twiggs as an elimination.
All right. And again, you didn't assume that, you actually concluded it based on the match, right?
Based on reviewing Mr. Twiggs' DNA profile to what I developed from these items, I used him as an elimination sample.
Now, you did various STR mix, what I'll call runs, correct?
That is correct, yes.
And the way this works is you input the number of contributors. You determine that. And then they also have something called HD and HP, right?
Correct, yes.
Tell the court what that is.
So those are different propositions. So in calculating the likelihood ratio compares the probabilities of seeing a DNA profile given one of two different scenarios or explanations or hypotheses. One is that a particular person of interest is a contributor, and the other is that an unknown, unrelated individual is a contributor. So depending on the question being asked is how I set up STAR mix, number of contributors. For example, if I'm utilizing someone as a known elimination sample, I will apply their DNA profile both to the HP and HD.
And the theory of this
Gary.
HP is the prosecution hypothesis.
Break up the monotony.
And
If I was a prosecutor at this point, I would say, Your Honor, are we gonna get into the history of how the DNA helix was discovered? Because this is so in the weeds. I would be objecting as a prosecution. This is coming from someone who hasn't been here the past few hours. So
Yeah. There's been at least 3 objections, basically saying the same thing, and he's been shot down every single time. I think he's just letting it go at this point. Go ahead, SK.
When I was looking at the documents, trying to find the exhibit list, I saw where the defense had been requesting like access to proprietary information about the DNA test. And also they wanted access to like the entire CODIS database.
Really?
Yeah. I saw that as well. It's
So they
pretty-
could run a comparison, I guess, or something.
E is the defense hypothesis.
Correct, yes.
So, and these are things you plug in based on your understanding of what the prosecution and the defense are contending.
Correct, yes.
So how do you plug in the HD in a case where you don't yet have a defense postulating what their theory is?
So HD, or the defense hypothesis, is simply the DNA profile, the probability of the DNA profile, given that it's another unknown, unrelated person to the prosecution's potential person of interest.
Mr. Burt, I don't want to interrupt your line of questions, but we've been going for just shy of 2 hours. Would right now be a good time
It'd
to
be a
take
great
15
time, Your Honor.
All right,
Thank
let's take a 15-minute break. Let's see. We'll come back at
see how far behind we are. We might be able to catch up here. All right.
The judge is
At
like,
a
we need
minimum,
a break.
minimum of 12 minutes, so we were about 600 seconds, or 500 seconds. So Yeah.
One thing I'm looking up right now is if in Utah, the judge at the preliminary hearing is going to be the same judge as the trial. Usually it's separate. It's a different judge.
Yeah. Okay. The preliminary hearing versus the trial hearing.
You know, versus the jury trial. Yeah.
Interesting. Don't we? Isn't he scheduled to have the trial as well, or no?
I'm going to find that out because in California, at least in my experience, they try to make it a separate judge, a different judge.
Interesting. I do want to show, matter of fact, I can just go over here and switch. Let's talk about the evidence list and the witness list. Let me just make sure. Okay, that's showing. Let me make sure that it is. We have it magnified here. All right. Let's see. We got witness name Officer Bagley. We obviously already had him. Officer Hull. We had him yesterday and today. Agent Brigner Mortensen, SBI. Do we have Brigner Mortensen, SBI? That's this lady, right? Wasn't her name Brickner? Let me see. Amanda Baker. All right, so different. She's not even on the evidence list, right? Or the witness list. Agent Hall, Brickner Mortensen, Agent Davis. We haven't seen Agent Davis yet. We have the Lance Twiggs testimony that's pre-recorded. Anybody feel free to jump in, and I can't see the chat right now, so if anyone's correcting me, SK, that's on you.
Do what? What's on me?
I was saying, correct me if I'm wrong when I say these things about who we've seen and who we haven't seen, and if anyone's, and right now all I can see is the document, so I can't see the chat right now. So if anyone in the chat corrects me,
Yeah, I've totally got you on that. But also, I think this is the state's list, so
Okay.
I need to go see if there's one from the defense.
fair enough. Yep, that is a good point. Yeah, so as I understood it, and maybe I just assumed that Judge Graff was going to be the judge in the trial as well, but
Well, I just looked it up. It could be. There's no rule prohibiting it. In California, in my experience, it's different, but there's also no rule in California that makes it so. It's just kind of a logistical question.
fair enough.
So it probably will be the same judge.
We already heard from Agent Famina. I was wondering how you spelled her name. Now we know. All right, so here is the evidence list. We have drone image UVU all the way through 1 through 3. Photo of screwdriver. Daytime photo of sniper perch. Photo of sniper perch 4 and 5. Video of mother with her children in crowd 6. They showed that. We did not see that. Written statement 1102 of A. Wright. I believe we saw that one.
A. Wright, I think, was the mother that took the video.
That's correct. Yep.
Yeah.
Video shooting from behind the questioner.
I have some of those written statements too, I think.
Okay.
Let me check my screenshots because I was able to zoom in. Clipmaster Jake sent them to me yesterday.
Video of shooting from behind booth. Photo of rifle in the bushes. We have not seen that. I am curious to see that. Photo of rifle in the bushes, number 2, 10.1. Photo of rifle in the box. Photo of rifle in the box. We have 2 different ones. I can't wait to see those. And here's why. Freaking the fraud named Ian Carroll is going to see that it was not a stock photo. Medical examiner report. Or I don't know, maybe I'll end up owing Ian Carroll an apology, and he was right all along. And I'll tell you what, I'll be the first one to apologize and do it publicly if he was wrong. If I was wrong, I have no problem doing that. But it's the photo. UVU surveillance from 910, doorbell camera surveillance from 910, and we've seen at least elements of that. I don't know how many different clips. We saw most of that UVU surveillance footage today. Written statement of C. Noble, written statement of Mike Mitchell, video at WCSO. That's Washington County Sheriff's Office. Is that footage of him turning himself in? I don't know.
That,
I don't know.
Oh
that's
my
going to be a
gosh.
huge one.
I don't know. We
So
have it
then we're going to be
listed.
able to show when he was actually in custody so we can
We're-
put all that to bed.
I all I know is I've heard that this video doesn't exist. This video was erased from the record.
Weird. It's almost like they withheld evidence until it was time.
It was relevant so that they could present and it's like they preserved the evidence so they could present it in court. As
It's
we
almost like
typically
Tyler
do with
Robinson's.
our justice
Sorry.
system. No, that's fine.
Yeah.
Never cut me off
It-
again. I will ban you.
Yeah, my bad. I'm so sorry. It's almost like Tyler Robinson's getting a fair trial because, innocent until proven guilty and preserving the evidence and not putting it out all over the internet.
Yeah.
It's also almost like the prosecution is not conducting this investigation according to Candace's whims, but
What?
I know it's crazy. It's
Is
like,
there anything that matters more than her whims?
right.
Like, what
Yeah.
kind of monster are you? Now, let me ask you this, Gil. Just because we have this evidence list here
Yeah.
or the preliminary hearing, does it necessarily mean that they're going to show everything in the list?
No, definitely not.
Oh my God. I will go down there and I will have a stern talking to Judge. I'm just joking, folks. But if they don't show all of this.
I mean,
I'm
again,
typing a strongly worded letter.
as I've said before, there's more than enough. Right now, it's like almost like beating a dead horse. They got the probable cause, without a doubt. But yeah, I mean, if they want to keep going, this judge is very accommodating. Most judges are like, I have 5,000 other cases on my docket. Let's get this done. But that's not really the angle, or that's not really the way the judge is viewing it, which is a good thing.
I don't think you were here earlier, but I mentioned this. I do appreciate that Judge Graff he understands the task. And that is, this is probably the case of his lifetime, but also understanding the importance of this entire process and to make sure he gives the defense as much room as they possibly can to ensure that we don't have any, there's no complaints about that at the end of it. And ultimately, a mistrial or anything else, or of course, when they go to appeals. So while it's painful to watch and it's painful now, it's probably a good thing, right?
Yeah, I agree.
FBI press release photographs, photo of round 1 from rifle, photo of round 2 from rifle, photo of round 3 from rifle, and so forth. Photo of burnt note from apartment. Photo of targets from apartment. ATF DNA report, rifles and cartridges. FBI DNA report, towel. My God, if we talk any more about DNA, I'm going to lose my mind.
It just is missing Krusty.
Your guests are hilarious. The comments I'm seeing are just cracking me up.
Our chat's the best.
I'm a bad influence.
Our chat is not only hilarious, but they are smart too. And when you go to the other ones, they're neither. They are neither funny nor intelligent. All they say is, yes, Baron Coleman. Yes. This was great. This was great. Gary Paramount, not so tactical. Oh, Burn City, population 1. He's going to regret ever saying anything mean about you. Let's see. What do we got here? Jeffrey S. Gray, Utah County. Tyler Robinson Defense Team via email. Dear Defense Counsel, for preliminary hearing preparation, I have included a witness and exhibit list below. This is our best effort at identifying witness and exhibits with our preparation to date. All right, so this is the letter to the defense.
Yesterday, that report they were scrolling through had Farnsworth's statement in it.
This is one thing I didn't see up there that's really important. We have DNA report on the Dremel tool, and tool marks report. Now, I don't know if the tool marks, I'm assuming that's separate from the tool marking testing that they do with the ballistics. So I'm assuming this is relative to the Dremel tool and the engraving on the brass portions of this. Yeah.
What about the screwdriver? Maybe, I don't know if that makes sense.
No, Your Honor, it doesn't. Dismissed. Probably. I don't know.
Can you guys? I don't want to bore everyone by making you repeat what they just watched, but can you guys give me a 30-second overview of what I missed, or no?
I'm trying to think when you came in here. I mean, basically, what you missed was literally 2 hours of them going through the DNA.
Okay.
I mean, that's primarily what you missed. I'm trying to think what you missed. I don't remember when you left.
So I took the break at the right time, it sounds like.
Yeah. You saw
You
all the
missed me
footage.
switching my laundry.
Oh man,
We did miss that.
I'll have to rewind it for that.
You saw all the campus surveillance footage, right? I think that was.
Yes, yeah. I stopped at 11 a.m. PST, so was that like 3 hours ago?
Yeah. I think you missed the entirety of Jen Falmelina's testimony. She was the SBI. She's a sergeant, team lead for the evidence response team. She was just talking about what they did as far as collecting evidence, what evidence they collected, the towel, the screwdriver, the firearm.
Where was the towel collected from? Was it next to the gun?
No, it was the gun was wrapped in the towel.
So it was with the gun. Okay.
Yeah. Which purports.
Or was it? If
Or
it
was
was standing on its own.
I did see some tweets from Candace during the break, during my break, and she's bringing up the height of the person in the surveillance camera being 6 feet as opposed to 5'11". Like somehow she could tell the difference between 1 inch in the security camera footage.
Yeah, I'll go back to, well, you know what, let's just go to, we'll share this tab instead. Candace Owens, there we go.
And then apparently some people are pushing the theory that Lance Twiggs is the actual shooter. And to me, it's like, what does that do? What does that do for you? It's like, okay, so Lance Twiggs is a shooter. You know,
How could he be the shooter when it was an exploding microphone?
Right. And it didn't even happen because it was a hologram.
Well, there's that whole piece of it too. Tyler Robinson is just above 5'10". That's what this looks like. We're, I don't know, 70. It actually looks like he's at least 5'11". This is 71 inches, and he might even be closer to 6 foot. I can't see the top of his head. Oh, that's convenient, Candace. Matter of fact, we're going to look at a better picture because the picture that you just put out is horse shit. Tyler Robinson.
But even if he's 5'11", her point is that the person in the surveillance camera, just based on her assessment, must be 6 feet. So she's like literally nitpicking an inch, just eyeballing it.
Yeah,
it's pretty funny.
Of course, most of those pictures that I can find only show it. Let me pull this up. Oh, that's a crappy picture. How come there's not pictures of him with numbers beside it? All right, so here's what we'll do. I mean, just for funsies here. I'm going to share this tab instead. All right, as far as I can tell, that looks like the 72 mark. Let me go back to what she was posting. Yeah, it's going to be the 72 mark. And he is every bit of, let's say he's 5'11" and freaking 3/4, depending on where that is, right? So that he, from a visual perspective, his hair is well over the 6 foot mark. So from a visual perspective, especially you put on a hat, I mean, he is easily over 6 foot. So let's just say for some reason that Candace can judge, oh my God, that guy's not 5'10", he's 6 foot. I can see him from in a camera from 400 yards away. It's not that far, it's like 400 feet away. So, I mean, she just kind of debunks herself. No. And I'm going to save this picture and I'm going to post it to her in response just because it'll give me pleasure
But
to do so.
I just don't get how she's coming up with the guy in the photo must be 6 feet. Like, is
Don't-
there a measuring stick right behind him or
Don't,
something?
my God, please do not hurt yourself trying to figure that out, because you will.
She is posting the arrest record that states he's 5'10", probably because they're using his driver's license.
Sure.
And I'm not sure if people are aware or not, but
Do younger teens grow?
males continue to grow after they get their driver's license.
Yeah.
Although most guys do lie and add an inch or two to their driver's license, so you never know. But
How old
either
is he? 20.
He's 22.
see, one of your commenters says I'm 5'7" and identify as 6 feet. Either way, there you can't judge someone's height by a surveillance camera with no reference height, you know, from a photo.
You guys, it's really freaking me out when you put she in the chat and you're talking bad about Candace because I'm the only she on the panel. And for a second, I think you're calling me retarded.
Hey, malignant narcissist, this is not all about you.
Thanks, Gary. God.
That's the
got
cost of
yelled
coming on my
at.
show. That's the cost
I
of
have-
coming on my show. You're going to get
I have
verbally abused.
PTSD. Listen, if you didn't make fun of me, I would think that you didn't like me. Because if I'm
Don't
not
make
making
me
fun of you,
don't make me dot that other eye, woman.
my husband will laugh at that.
Oh.
I know it wasn't me. I just see she every now and then, and I'm like, wait, what?
And cope harder, Candace. Cope harder.
She's posting the arrest record or like the booking document to say, look, proof he's 5'10".
Yeah. Okay. In fact, I'm not even gonna post that there. I'm gonna cancel that out. I'm gonna repost and quote tweet. Boom. Boom.
So we got like 6 more hours of DNA discussion.
No, they're gonna shut it down here in the next 30 minutes. I almost guarantee it.
Yeah, I mean, usually like a lot of this stuff would be not in the prelim if they wanted to get into the nitty gritty details of it. There is some other evidentiary motions and hearings that they could file.
Yeah.
So
Taylor
it's not
Hansen
usual.
got in on this. Did you
Okay.
see that?
No.
Taylor Hansen commented on that and posted himself there and said, like, posted the photos side by side of Tyler walking down the stairs and Taylor Hansen at the same spot. And he said, I'm exactly 6 foot, by the way. The person in the security footage is clearly shorter than I am. What's the next goalpost now? Let the preliminary hearing play out like a normal human being.
Yeah.
I never thought Hansen would be my hero for the day.
Well, I mean, according to this, and you know, when these these measuring tapes are, who knows how perfectly accurate they are. I mean, he's 72 inches, thereabouts.
Yes, Rachel. Like
So-
Mbop, Taylor Hansen.
Anyways. All right. There's that done. My at least minimum daily troll of Candace Owens on X.
Yeah, I mean, if this was like the actual jury trial, I would feel, I mean, maybe I'm exaggerating here a little bit, but I feel like they're presenting enough to possibly get a conviction. It's like they're really hammering in a lot of evidence. So
Yeah, I mean, it
it's
sure
pretty- it's pretty
seems that
strong.
way.
I wonder if the defense has more witnesses. Do we have a defense exhibit or witness list?
That's what SK promised me she would have that if she came on today, and
Yeah, okay.
and we don't at this moment. So
I'll find it. What are you wanting?
Defense
Oh,
potential.
yeah.
wit-
I said I was going to look for that and I got distracted by the chat. Thanks, guys.
Yes.
gonna get
I'll
me
let you
fired.
answer this. I think I can come up with a good answer, but I'll let you kill. When there's a confession, why does there have to be a preliminary? Well, the other part of that is there wouldn't be a preliminary if he pleaded guilty, and that's not what he's doing at the moment. Like, I don't even think we have an official plead, right? He hasn't
Yeah.
pleaded anything right now, right?
Did they not plead not guilty yet? Usually you plead not guilty at the arraignment. Sometimes you continue it. I've never heard of not pleading before a prelim.
Let me look this up just so that we're
Yeah, I mean,
accurate and true.
But that type of confession, I think maybe we're conflating admissions with confessions. I don't think he ever signed like an official confession.
That's true.
He admitted it and turned himself in, surrendered, but that is not the same as admitting guilt, as a confession. So, and they're going to argue that those admissions were, should be excluded for one reason or another.
I mean, according to Grok, current status as of July 7th, Tyler Robinson has not entered an official plea.
It's not entered an official plea. Huh.
I didn't think he did. Does anybody have any information contradictory to that? Feel free to share.
No, that's
You
that's
guys.
probably right. I guess that the prelim is going ahead without an official plea being entered. I mean, he would again be asked to enter a plea after the preliminary hearing once the complaint is filed. So right now it's the information. After the preliminary hearing, it turns into a complaint, and then he would plead not guilty then. But usually you also plead not guilty at the arraignment, which happens earlier. That I don't know. I've never encountered that, but
How did I miss the whole narrative about the judge being corrupt because he was searched from Israel prior to Charlie's death and he was appointed after that and sworn in on August 4th with his first case ever being the Tyler Robinson case. Oh, and he appointed the defense. This is a kangaroo court.
Yeah, of course, it's a kangaroo court.
I mean, on what rulings has the judge even shown any ability to be corrupt? It's been pretty the judges they have a say in what type of evidence gets in and stuff like that, and objections.
You're
but
assuming these people have the ability to reason and use logic and understand the judicial process.
Folks, breaking news. There is literally zero evidence that this is Tyler Robinson. This hearing is a joke. It's a joke.
It's a Jewish hologram, Mossad, space lasers.
Left leg bends while the right stays stiff. Yes. One of the things I probably will do, I think it's probably worth doing, is going over at the end of this, if you guys can bear with me and think it's worth it, going through the Turkey Tom videos, at least skipping through, and hopefully, because I think those are really important.
The Discord?
Yeah, well, there's two different Turkey Tom videos specifically about Tyler Robinson case. One is the Discord, and another one covers some other areas. Basically, a lot of information that was both of them. There's a lot of information that comes from a mutual friend of theirs that has been to their house. He has pictures inside their apartment, and I think it does give a lot of relevant. And by the way, pictures of the Discord chats that Tyler sent from other people that were obviously watching the Discord screenshots.
Yeah, and those pictures inside that apartment are crazy. And the person talking about Lance and Tyler and what Lance would do when he got in his like whatever state of mental illness it was, when he would just lock himself in there and yeah.
By the way, again, correction, I keep reversing complaint and information. The complaint is what's filed first. After the prelim, it becomes the information. I'm wondering also if at the jury trial, if there's going to be a whole bunch more circumstantial evidence that, in addition to all of this direct evidence, that the prosecution's going to seek to admit, maybe like other statements he's made to other people, talking about hatred for Charlie Kirk, stuff like that.
Sure. Hey, real quick, because I've already seen this listed multiple times, and Liz Wheeler corrects the record. I couldn't remember exactly what was said, so I didn't want to get out over my skis, but you're about to see a massive fake news about an out of context quote from the Tyler Robinson hearing, and I've already seen this multiple times. Here's the truth. The prosecution did not say, and I'm showing this, right? I'm showing this. Yeah, there we go. I want to make sure I'm showing this. Prosecution did not say they don't have video footage of Tyler Robinson firing the shot that killed Charlie Kirk. What actually happened? The prosecution was asked if the compilation video that was released to the media today showing Tyler Robinson on campus 4 times on 9/10 included footage of Robinson firing the shot, to which the prosecution answered no. Very big difference. Nevertheless, you're about to hear, oh my God, the prosecution doesn't have video of the shot. I wonder why. Israel, Erica, fed slop, shiny pants. She cries too much, doesn't cry enough. Peddled by the liars who want you to buy their evil, baseless, false allegations and also need you to ignore the truth. Be forewarned, that is getting shared. Boom. I'm just going to share post. We'll just share it without that. Repost. Here we go. Buckley Carlson.
Gary, how come it suggests for you to follow Jimmy Dore?
Because we go back and forth all the time. I have a couple videos calling him a liar. He's a couple tweets attacking me.
Oh, nice.
But I win because mine are truthful. His is bullshit. It's just the
I
way it
got
works.
your back on that one.
A U.S. Army report on 30-06 ballistics know that full metal jacket bullets may exit cleanly if no yaw, but early yaw increases the temporary cavitation up to 30 centimeters diameter and fragmentation leading to retained fragments and no exit. Chris Lash out there putting out God's honest truth. They hate that. Did everyone know that Ian Carroll worked in Candace's home every single day at some point? Because this is the first time I've heard about this. Yeah, he was actually covering for Ian. Ian Carroll was guest hosting for Candace while she was pregnant, I believe, out on maternity leave, but he was definitely guest hosting for them for a really long time. I don't know how much he knows about the internal workings of their home and who covers finances and everything else. So there's that.
I always thought that guy was the guy from the show My Name is Earl. You remember that show?
Yeah, I know who you're talking about. You shouldn't insult that dude like that.
He does look exactly like that. I've been trying to figure that out. Just like this judge who looks like Brian Enton.
Yeah. He does look very similar to Brian Enton. I don't know about the exact same.
No, not the exact same, but he could totally be his uncle or something.
Sure.
Someone's saying the hearing started again.
All right. Well, let me.
Your show, you do what you want, just letting you know.
Yep. We'll share this tab instead. Make sure we're all the way forward.
Or it was determined that I was off.
Back this thing.
That was the
Oh
only
my God, we're still
time.
talking about DNA. I almost know it. Boom. Yep.
Witness.
Ms. Baker, would you take a look at, in your notes, page 24,
Did I turn on the volume? Yeah.
379?
Because her mic was so loud.
Very bottom of the page. Did you write there on the 15th of September, 2025, spoke with Special Agent Folger, gave update on report timeline, discussed it upon review, it was decided that additional statistics needed to be run. Report will still be issued with Twigs as an assumed contributor per previous discussions with Folger and Carmack. You see that?
Yes, I do.
And what additional statistics needed to be run at that time?
So at that time, I believe I ran statistics with just Twigs comparing that individual to the sample. If I may refer, I think that was the only additional.
Well, Ben, did Summer get your stuff to you? You can send me a text.
Yes, after discussion with my reviewer, it was determined that I was also going to calculate a statistic or compare Twigs by himself, comparing him to the evidence and having that run in my case file.
Okay. And could you go to tab 38, page 39?
Oh,
Yeah, it should not be on the screen.
let's pull it down from the screen. Thank you. So
Okay.
just to the monitors of the attorneys and the witness, Mr. Burt?
Just for the witness, Your Honor.
Okay, just for the witness.
39. And this is page 39. Is this the DNA report? I'm sorry, the star mix report that was produced as a result of your inquiry that involved a comparison of the sample to Mr. Twigs alone?
Yes, it is.
And is that a 6-page report?
Yes, it is.
And is it a true and accurate copy of the STR mix report for that particular sample?
Yes, it is.
And move that into evidence, Your Honor. This would be Baker 38, page.
Make sure you like, subscribe,
39,
share our content, folks. Let's get the truth out there.
44.
Baker 38, page 39 through.
I'm seeking admission as well as publication to the audience and the camera.
I just want to make sure I have the label correct. Baker 38, pages 39 through 44. Did I hear that correctly?
That's correct, Your Honor.
All right. To the state?
Yes, Your Honor, I object on grounds of relevance to the probable cause determination.
All right. And Mr. Burt, would you like to respond?
Submitted, Your Honor.
So I'm not exactly sure what this is in order to
Sure.
determine
Let
how
me-
it fits into the probable cause analysis.
Sure.
So a little bit more information, because as of right now, I don't have enough.
Really
to admit
is.
it.
Understood. And I apologize.
Really
to
is
the
that
court.
dude's
So the
buy into
report
the
that was
bullshit.
admitted into evidence has the conclusion in it that both samples were contributed, that Mr. Twigs was a contributor to both samples. And this is the report that the analyst ran in order to make that determination, I believe.
All right. Did these reports, were these made prior to State's Exhibit 31 being prepared?
Yes, that's correct.
All right. I will admit, Baker 38, pages 39 through 44 is admitted and may be published.
You like J Knight,
Again,
folks.
as a reminder,
All the cool kids are
for
doing
all
it.
attorneys, this is a
All the
probable
cool kids are
cause
doing it.
standard. So if all parties can just keep that in mind as we're moving forward on this.
Sure.
Thank you.
Thank you.
And so it may be published to all screens.
Yeah, it's page.
Sounds about right.
Um, So is this the report that you referenced in your notes that you needed to run the sample through StarMix?
Yes.
Now, at the top, this is the StarMix unit dated September 15th, and it relates to item 7-1, correct?
That is correct, yes.
All right. And then down below that, the kit used, if you could go to the summary of the input.
Agreed.
You tell the software program, assume there are 2 contributors, right?
Correct, yes.
You input sample 7A.
Boom.
Correct, yes.
And when you input it, it's
Vocal
just the
cam,
raw
100
data,
bucks.
right?
Correct, just the numbers from the graph.
The numbers, and then known contributors under HP, the prosecution hypothesis,
Correct, yes.
right? And you put in sample 61,
Yes.
right? That's Twiggs's known sample.
Correct, yes.
And then the known contributors under the defense hypothesis, you left that blank.
Correct.
Is that because you didn't know what the defense hypothesis was?
No, again, the defense hypothesis for this situation, if I'm comparing someone, is an unknown, unrelated individual, and that is taken into account during the calculation.
Okay. And then you input that data, and what you get out from that is a likelihood ratio, right?
Correct, yes.
So let's go to page 2 of that report. And is this a summary of the results from that test on the 15th in terms of a likelihood ratio?
Yes, it is.
What is a likelihood ratio? What does that mean?
A likelihood ratio is a statistic that calculates the probability of seeing a DNA profile given one of 2 different hypotheses. One is that a particular person of interest is a contributor, and the other is that an unknown, unrelated individual is a contributor. The probability with the higher number gets the support, and the magnitude of the support is determined by the ratio of those 2 numbers.
Sean blocked me too
That's
a while back.
pretty technical stuff, but the bottom line is that your
Sean Ryan.
software computes the numbers, and then you look at those numbers and determine whether it has any significance, right?
I don't know that I would say if it has significance. I report the value that's calculated.
Right. And why
There you
is
go,
one
folks.
column, these columns relate to different, what are called population databases, right?
That is correct, yes.
The one on the far left, BAH, is an
The only thing that can make this DNA conversation more boring are spreadsheets. And here we go.
And right now, I think what they're going through is not even a statistical analysis of Tyler's DNA, but Twiggs's elimination DNA analysis. So we're really in the weeds here.
FBI population database on Bahamans,
And African Americans, yes.
African Americans.
I agree
Another
with
one for
this.
Caucasians,
Correct, yes.
SEH is Southeast Hispanics,
Correct.
and then Southwest Hispanics.
Correct.
Objection.
That's all I have on that. I'm just trying to explain the chart.
All right, well, there's an objection. Let's pause and turning to Mr. McBride.
Sure.
Your Honor, at this point, I'm going to object on, again, grounds of relevance to probable cause hearing, State v. Drosbeck, State v. Merrill, State v. Ramirez that the court has cited. all hold that the court should bind the defendant over for trial unless the evidence is wholly lacking and incapable of reasonable inference to prove some issue which supports the prosecution's claim. I don't know that any of this analysis goes to whether or not the expert's testimony and her report is wholly lacking and incapable of reasonable inference to prove her result in this case. We're far beyond this. We're hours into this examination. This feels like a 702 hearing to me. I think we're
Sounds
far
like a
beyond a probable
702
cause hearing,
hearing.
Your Honor. I would ask the court to
Shut this guy up. I want to ask the
sustain
court
the objection,
to
not
shut
allow
this guy
questioning
up.
on this or any other matter that does not deal with the issue of probable cause.
Yeah,
Thank you, Mr. McBride. Mr. Burt.
Your Honor, the state offered this report on a very technical, complex, scientific area of inquiry. And they offered to the court a conclusion in that report that Mr. Robinson and Mr. Twiggs were contributors to 2 samples that were found at the crime scene. They obviously think that's relevant to the probable cause.
This guy needs to clear his throat. He needs to clear his throat. It's going to drive me crazy. Like, clear your throat. If that's
Is
your
the
voice,
judge going to remind them to drink water again?
please. And no, what he said was, you can drink water, just please don't spill it.
Inquiry, or they wouldn't have offered the report in the first place. So having done that, I think the defense is entitled to inquire whether those conclusions are reliable, because that, again, is the court's ultimate determination here, reliability of this evidence. And the court can decide
Oh my God.
it's not relevant, it's not reliable.
All right. Well, while they're just yammering on, here's a good question. Gary, will they specify the grain of the bullets during the trial? What they're going to ultimately do, and this is my speculation, and Gil, you can let me know. They do have unfired, and they have the boxes. So they have unfired rounds, and they have the boxes in which the ammo come in. That actually is listed in other documents. So they know what the grain is, how much does bullet weigh, and the ammunition type. And what they're going to do is, I would assume that the ballistics would hopefully confirm or deny whether or not what they recovered is consistent with the same ammunition that was, number one, recovered at his apartment, as well as the unfired ammunition. I don't know how that works. I don't know if they can determine that, but I'm sure through other just basic analysis of what was not fired and what was fired and how much of that they were able to recover, they should be able to say whether or not that's consistent with the ammo that they discovered. That's Gil, you got anything to add to that?
No, I mean, I think you know more about those details than me.
I don't know how the forensics lab is going to process that ammunition or what their capabilities are. I'm just saying I would be able to, like, if I was cutting open a deer and be like, okay, Gil he shot a 30-06. This, I weigh what I can find and realize what is not there. And then compare it to what the ammunition that you do have on you, like, okay, this is consistent. Is it probably exact? Probably not. I don't know what other capabilities they have. They can get to the point to where they're actually doing testing to where they can molecularly analyze the lead and other bits of the metallurgy. And do a comparison. I don't know if they're going to do that. I know they don't do that all the time. So I don't know what they're going to do or what to expect with that. So I'm on the edge of my seat as far as the ballistics of this as well.
Would exceed the probable cause standard for a preliminary hearing for what is before me. And so, Mr. Burt, as it relates to the objection, I'm going to sustain it in part. If you want to briefly address this and move on, you certainly may choose to do so, but as it relates to where we're at, my hope is we can keep this very brief as opposed to going through all this, so we can move on to whatever else you would like to present.
Thank you. We'll do that, Your Honor. And
You are the best.
in the interest of doing that, could you
on the
bring up
interwebs
on the same screen part of her report, People's Exhibit 31?
And let's take that off?
I'm going to need that up there because I need to do
Oh,
it.
so is it part of the same?
I was thinking that the other day. I'm like, Judge Graff looks like the dad you want to have, like the super calm, chill dad. Okay, come over here and explain to me what your thought process was, for punching your sister in the face. And I also feel like that if you give him a well enough and a good enough explanation, I'm like, okay, yeah, that makes sense. All right, go do whatever you're doing.
Because it was on that screen. I want to make sure that what you're calling up on the screen right now, is it part of this that was already admitted or something else?
It's part of this, which has already been admitted compared to people or plaintiff's exhibit 31, which
I
has
see.
also
Okay.
been admitted.
Okay,
Yeah.
thank you.
Both
I just wanted to clarify.
There's more than once
Right,
I thought
so,
about that too.
Do you want that published on this all
Yes.
screens?
Really, more
Let's go
so
ahead
the
and
other
do so.
guy. The other defense attorney that we had on earlier that was going, what was he going on and on about? And just wouldn't let it go. I don't remember, but
And the chart I would like you to bring up from that report is on page 5.
Yeah. It's strange that the defense is getting into this
level of
subject
minutia.
matter. Yeah.
Yes, they have unfired rounds with the rifle, and then they have unfired rounds of the same
Just highlight that.
Brandon type at his house, along with shot and unfired targets.
Thank you. So what we've blown up there is from your report, plaintiff's 31, and you provided this chart in the report, correct?
That is correct, yes.
Explain to the court how this works, what this chart is supposed to represent.
Sure. So this is our verbal scale. In addition to the numerical likelihood ratio value that I provide, I also give a qualitative or a verbal equivalent to that numerical value. That gives some kind of context to what that likelihood ratio means.
Okay. And on the left, explain what the greater than 1 million, less than 1 in 100 means. What does that scale relate to?
Sure. So that scale is the numerical value of the likelihood ratio. So if I have a likelihood ratio that's greater than or equal to 1 million, I designate that as very strong support for inclusion. The next example, 10,000 to less than 1 million, I would say that's very strong support for inclusion and so forth.
So you need to reach a likelihood ratio of 2 in order to get even limited support for an inclusion, correct?
Correct, yes.
Okay. If you could not reduce that. And go to page 2 of the report on the left. So from this chart, when
Thank
Mm-hmm.
you
you,
ran
Lord. We appreciate you.
Mr. Twiggs against a sample, what was the likelihood ratio that you determined?
I believe this chart is not
Bad mom.
the comparison to Mr. Twiggs.
Appreciate you, Tracy.
It's not in the report.
The chart at the bottom of the screen is not my comparison to Mr. Twiggs.
Let's verify that if we could take that down. The
I agree
highlight.
with this. Lidina.
Maybe the defense strategy here is to bore the judge to dismissing the case.
And repost
I would have tapped out already.
38, page 45. I'm sorry.
Just 1 cent. Just 1 cent. Liz Wheeler has an
Page
episode
39
showing.
that isn't in evidence. There we go. Second page.
So I guarantee you those pictures in that episode, Ladina, it came from the Turkey Tom videos, which I will try to get, if we have time, to go through them very quickly. I think it's really important for people to see that.
I think it's very important, and there's a 100% chance that's where they came from because
Is
that was
this
the only person
the
that had that
likelihood ratio
information.
from
Came
your
directly
Twiggs
from the
comparison?
source.
Yes, it is.
Okay. Now, what was the likelihood ratio that you calculated based on this chart?
Likelihood ratio was 1.
1.
Yes.
So that doesn't rise to the level of even limited inclusion, correct?
Correct. It would fall under an uninformative.
Uninformative, and yet you concluded that despite this STR mix reading with a likelihood ratio of 1, that Mr. Twiggs was a contributor to both item 7 and item 8, correct?
I did. So actually, I didn't utilize this calculation to determine that Mr. Twiggs was a possible contributor or that I could use him as an assumed contributor. I visually looked at the DNA sample, and the DNA, unlike that major contributor, he also had those peaks. So that was one proposition or one hypothesis that I determined that he was an assumed contributor. There are multiple different ways. We don't have a threshold. I don't have to see 2, 4, 8 peaks to determine I think an individual is present. Given that the field submitted him as an elimination, I assumed he was a contributor. When I compared him to that data, I did see his DNA present. So when I calculated the statistic for Mr. Robinson, I used Mr. Twiggs as an elimination.
Let me see if I understand that. The STR mix that you relied upon to include Mr. you relied on the STR mix to include Mr. Robinson as a possible contributor, correct?
Correct, yes.
But when you ran Mr. Twiggs's sample through STR mix, the result you got was that he was not a contributor, correct? Or that it was of not even of limited value in including him.
Based on the STAR mix run, it was uninformative, but I did use my own knowledge and training to determine that I was going to utilize him as an assumed contributor.
Okay. Your own knowledge and training. Is there some standard that you use for deciding when not to rely on the STAR mix results and when to sort of disregard it and rely on your training and experience?
I can't say that I disregarded it. When I'm comparing someone, that's my first determination. Do I think this person is potentially included or excluded? If I determine that I think they're included, I will run STAR mix to give weight to that inclusion. Elimination samples are different. If I'm told that an individual is submitted as an elimination sample, I can assume they're there. Visually, I'm able to look at the DNA evidence and determine, yes, I think there's enough evidence there to.
She's a really good witness. She clearly, this is clearly not her first day in court. I think she has been extremely informative on this, be able to respond confidently and accurately, and she just comes off as extremely credible. So congrats to the nerd that I would bully and take her lunch money. No, she's doing a good job.
Assume that individual, which is what I did here.
Okay. At D16, Mr. Twiggs was a 912, right? According to your electrophorograms.
Yes, she is. She is in full crack.
That is correct. Yes, Mr. Twiggs was a 912 at D16.
912. And did you find 912 at that location in the 8-1 sample?
I'm sorry, the sample 8 or sample 7?
Sample 8.
The only piece of information I had for sample 8 at item D16 was a 12.
And you said Twiggs at that was a 912, right?
Correct, yes.
But at that location, the evidence sample was not a 912, but a 12.
That was the only piece of information that was recovered at that location.
This rifle is not particularly rare. Just not that particularly rare. We can talk more about that. Like a Mauser 98 action is very common. They still make them. There's lots of, I don't know when he got this. I don't know if it was built after World War II, if it was a, a World War II surplus, which is possible, but you can still buy Mauser 98 actions. There's nothing super rare about this.
Location.
Let me ask you about
Hundreds of different bullets that could have
your
been
interpretation
was
rules for excluding.
chambered in
someone.
30-06.
Is this an accurate statement? This is from Butler's textbook. In forensic DNA analysis, if any STR locus fails to match when comparing the genotypes between two or more samples, then the comparison of profiles between the question and the reference sample is usually declared a non-match, regardless of how many other loci match.
I would agree with that if it's a single source sample. So single source, again, meaning from one individual. If I have a DNA profile from evidence and I compare it to a known individual, if there's a difference at even one location, I can say it's an exclusion. If I have a mixture, it's not that cut and dry. I have to take into account how many people are in that mixture, how many pieces of information I have, is there potential dropout? So it's just because someone may not be present in a mixture doesn't necessarily mean that I'm going to automatically exclude them.
I see. At D19S, what was Mr. Twiggs's type?
It was a 1416.
Did you find a 16 allele in the 8A sample?
No, I did not.
Judge, get a hold of this guy. We're going on and on and on.
Tho, what was Mr.
Oh yeah, it'll be brief, Your Honor. It'll be
Twiggs's
quick.
type?
He was a 7.9.3.
Did you find a
What I'm kind of confused about is that
sample?
the point here is that that Twiggs's DNA is not a match. Like, what? I don't see how that gets to. I mean, I can see how maybe not being able to adequately eliminate other person's DNA would have an effect on, conclusions, but we're so far afield from the probable cause standard. It's almost like if I was the prosecution, I'd be like, you know what, can we just forget about the DNA right now? Let's just go on the surveillance and other stuff.
No, I did not. But again, this is a mixture and there is some dropout. So just because I didn't see a 7, for example, does not mean I would automatically exclude someone.
It's a mixture, so
Agreed,
there was
Chad.
some
Well
dropout. So
stated.
did you assume that at that location that the allele that dropped out matched his allele?
I'm at that location, no, there's only one individual represented there. So when comparing an elimination, I would essentially ignore that location. I'm looking at the other locations where there was 2 individuals present.
Okay. Now, a couple more topics and then we're done. When you received the evidence, you got more than 7 and 8, correct? You got a number of other samples.
Correct, I did.
You got a backpack, which you labeled as Exhibit 9, and a bunch of items from that backpack. Correct?
Correct, yes.
Can I
You were
phone
eventually-
in
you
an
were
objection?
initially told that those items related to things that may have been discarded by the suspect.
So initially, we didn't have any information. So we processed that. Those are items that are good for DNA. Not having any information from the investigators, we process them for DNA. As the investigation continues, it was determined that that backpack was potentially left behind by a bystander, and there was no comparisons needed at that time.
Well, left behind by a bystander, or according to your notes at page 20, the
I've heard your
backpack
detractors
belongs to
mention all
Kirk's
your lady viewers as
detailees.
a supporter. I have to mention it too. The ladies surely love you, Gary. You might have the only 2A channel that swings female. I'll take it. Whatever.
Yes, based
I
on
got a
the
lot of
individual
male
that
viewers too. I don't know what
that was not my
percentage is.
communication log. That was someone else within the laboratory. That was the information that they received.
Before you received any samples, did you request to perform what's called destructive testing on the samples?
Yes, I did. And destructive testing is essentially consuming the sample, cutting the cotton off of the Q-tip or the swab, subjecting it to testing. There's nothing remaining. I have to request permission to consume prior to doing so, and I did in this case.
That's
why did you
the
do
defense.
That is part of our protocols that we have to request permission to consume, and we consume, so DNA, we can't see it. So when an item is swabbed, we don't know how much DNA is on that swab, if anything, or how that swab was used. Did someone just swab using one side of it? Did they roll it and use all sides? Because I don't know that, it's our practice to consume that swab. It's our best chance of getting any DNA evidence.
And that's a determination that you made in this case before you even saw any of the evidence, correct?
That's right, Jim.
Determination to consume?
Yeah.
Yes.
Okay. Now, remember I referred to that NRC report?
Yes.
1996. Did they say there a wrongfully accused person's best insurance against a possibility of being falsely incriminated is the opportunity to have the testing repeated? Such an opportunity should be provided whenever possible.
Yes, that does say that.
And does your laboratory
Prosecution, object.
have a policy?
Object again.
Standard 7.4, which says, where possible, the laboratory shall retain or return a portion of the evidence, sample, or extract.
That is correct. And we do actually return the remaining extract, the liquid from our DNA testing. So we did consume the swab. However, there was a small amount of liquid.
You missed nothing. We're still talking about the DNA, and nobody knows why. Or even the point.
Yeah, because
at this point.
this is like maybe stuff you get into at a jury trial, and usually you would bring on your own expert witness to corroborate this as a defense lawyer, but you do not get into this much detail in prelims. It's very unusual.
That was left and returned.
Silly.
On some of the items, right?
I believe on all of the items.
We'll get to that in a minute. And that policy that I read is from your lab policy, right? The
Yes.
FBI's lab policy.
Yes, it is.
And
It will not stop.
Is there also a similar policy from the
Folks, this is not going to, for the hardcore candidates, it's not going to change anybody's mind, no matter what the outcome of this is. Their stance on this from the beginning is this is all Fed slop. It's all made up. All the evidence is fake. There's lots of people saying that not only is the defense in on it, but his own family are in on it. 20 years from now, they're going to be making documentaries going back to how the Charlie Kirk assassination was this huge conspiracy that included Israel. And chances are they'll completely fool, especially that much time departed. And they'll have the gossip mill going the entire 20 years plus. Just like I question what I really think about when it comes to JFK and MLK. Because not too long ago, I 100% believed that there was a conspiracy to kill JFK. I think there's more evidence. All right, there's eyewitness saying that there was rounds shot at different locations. There are stray rounds that aren't accounted for from his. So there's more evidence, and that's why I believe it. Not just because we've had the rumor mill and we've been able to say like, oh, you can't explain this, and all this fake conspiratorial nonsense. There's some pretty good evidence that indicates that there was more than one shooter when it came to JFK. Now, again, we're going to see evidence that is fabricated. We've already seen it by the pod slop. They've literally have fabricated videos. They fabricate all kinds of things. And I think that will be interjected down the road. So 20 years from now, we're going to be hearing this, and they're going to completely try to rewrite history, saying that Israel or the United States itself killed Charlie Kirk when, here in the present time, which is why it's so important to combat this stuff, because that'll be used if the United States still exists in 20 years, by the way. That'll be used as a different psychological operation and be like, see, look, the government killed. It'll be an established fact that the government killed or Israel killed Charlie Kirk or the both, or I don't even know anymore. The French, Mormons, Freemasons, they all did it. But yeah, it's not going to change that much.
quality assurance standards, the FBI quality assurance standards, which says the laboratory must have a policy on sample consumption. The policy is expected to provide instruction for if and when
God's sakes, man.
the laboratory
Object.
may or may not consume a sample, and any documentation that the laboratory requires.
That is correct, yes.
Okay. Now, your report indicates that certain samples were
I agree with that.
destroyed, consumed.
Candace can have
That
the
is
wine
correct,
swap
yes.
moms.
And
I
which
have all the
samples were
intelligent women
consumed?
watching this. Thank you, ladies.
Items 1 through 6, which were swabs from possible smudge, swabs of hand swipe, swabs from possible sweat drop, swabs from possible smudge, swabs of possible smudge, and swabs from possible sweat drop. In addition to items 54 and 55, which were swabs of swiped finger areas and swabs of stairwell railing.
Okay, so when you wrote in your report that those items were consumed, which of those items, and by that you mean the actual swab was consumed?
Correct. So a swab is just like a Q-tip. So the cotton portion of that swab was cut off the wooden stick, placed into a tube, subjected to DNA testing. So we consider that consuming. But again, there is liquid at the end of the process that is returned to the field.
And the normal procedure in terms of sample preservation would be something called sample splitting, right?
Will
You
do.
split the swab and you use half, you save half so that your testing results can be replicated and retested.
Look, the reality is, and I most of the women that are watching this are actually, they came over from my OF. All right, my OnlyFans page. That's that's the truth. I admit it.
So yes, however, again, I don't know how an item is swabbed. So even if I were to cut that swab in half, it could be that I'm testing the half that doesn't have any DNA and the other half may have some DNA, or the swab may have a little bit of DNA on one side and a lot on the other side. So for the best possible chance of getting a DNA profile, it is our practice to consume the entire swab.
So for the first 6 items, those were swabs that were taken from the northeast corner of the Losi building, correct?
Correct, yes.
And you used all of the swabs and you concluded that there was no DNA present on any of those items, correct?
That is correct.
So you couldn't do any comparative testing.
Correct. There was nothing for me to compare to.
Okay. And what did you have left after you did that in terms of the volume of
Why does that matter?
So it was approximately 3 microliters. So a very small portion.
very small portion, and you
This is true.
actually used 10 microliters
So
to do
true.
your testing for those.
Well,
Imagine how
That is
long
correct,
this
yes.
trial is
So if
going to
you
be.
Getting your
What's up, Gil?
as a defense lawyer, if this was a trial, I would, I'm just putting on my defense lawyer hat. I would say, okay, well, you guys took the DNA evidence and consumed it, didn't find anything, and there was nothing left for the defense to be able to, try and figure out. I mean, it's kind of a stretch. It doesn't really go far in terms of a defense, but maybe at trial I could see that. But again, at this prelim, it's just I can't believe the judge is really. I guess the judge just wants to be really clear that
There's no
the
bias.
defense was allowed to do everything
Absolutely.
they wanted.
Yep. And like Yasmin said, the irony is the louder someone claims to be following the evidence, the more obvious it becomes when the evidence isn't following them. Candace is on the wrong side of history. And every single time they believe all of what they are, they're following the words of a bunch of grifters. And when you get down to it, there's so much that they don't know, they've never heard of. They never heard of Turkey Tom videos. They never heard of, most of the stuff in the charting documents. They're not aware of the actual chronological order of events. Like there's so much that they don't know, and they have hung on every word, and they have notebooks of what Candace told them, and they'll say things like, well, what about the bomb dogs that missed the rifle? That didn't happen. There's lots of different talking points and false narratives that they follow that there's absolutely zero evidence for, and she's 100% spot on every time I have these
the
discussions.
results with 10, what you left over would not be sufficient to get any sort of independent testing done, correct?
It could be tested. However, my expectation, if I took 10 microliters and did not get any DNA, the remaining 3 would also still not give me any DNA.
Okay. And for item 55, that was 2 swabs of a stairwell, from a stairwell railing where the suspect touched the railing, right?
As far as I know, they were swabs from a stairwell.
And correct me if I'm wrong, but I understand from your lab notes that you took those 2 swabs and combined them into one sample and then used the whole sample, right?
That is correct, yes.
Okay. Before you did that, did you inquire whether the 2 swabs came from 2 different areas? For instance, maybe the suspect touched it here, but the other sample was taken somewhere else?
I did not. They were both labeled as coming from the same.
I just want to inquire with Mr. Burt, and we are at the 4:30 point. I just want to inquire without
I just
applying
have
pressure,
one
just trying to
area left.
understand. Okay.
Be done with it. We talked earlier about your
Right.
and is it true that there are different alleles that have the same length when you measure by STRs, but
Oh my God.
you have
Objection,
This is
relevance.
irrelevant.
34.
Right.
Mr. McBride.
I thought that was the chick saying it. Your voice and her voice are very similar.
Thanks.
Yes, I object. Unless this exhibit is reasonably likely to defeat the prima facie showing of probable cause, this is irrelevant to the preliminary hearing.
Mr. Burt.
Did they really object to that?
This exhibit and the next one go
It wasn't
directly
too bad. It
to
was something
whether
later on. I
the
fast forward.
comparisons being made between Mr. Robinson's sample and the evidence samples are usable and reliable to make a determination that he is a probable contributor.
I'm not sure I'm following with what you're saying on there, right?
Yeah,
Maybe
none of
it's
us are.
just because it's late in the day. Could you
Yeah, it could
repeat
be.
that?
So this chart illustrates what allele she found at each location for Mr. Twiggs
Yeah, I'm with you,
Mr.
Kendra.
Robinson.
I agree.
and for the evidence samples, the 71A and
I think they're being as careful as the judge as well.
81A, the other 81. And for instance, Your Honor, at the, you'll see that under,
That's a little bit different analysis that the trial judge applies, but as a magistrate, taking a look at this and looking at the probable cause standard, how does this comport?
so it comports because it goes to the ultimate opinion expressed in the report that the state is offering, that the report offers reliable support that Mr. Robinson is a possible contributor. And we're asking the court to consider that the comparisons are only based on a limited number of length-based comparisons, and that there are sequence differences so that she cannot distinguish. And I believe she'll testify, she cannot distinguish based on the testing that she did in at least 5 separate locations, whether the evidence sample and Mr. Robinson's sample, or for that matter, Mr. Twiggs' sample, matches the sequence differences here. And this is my final area, and I think I can do it very efficiently. And I think it
No,
is
you can't.
important. for
No,
the court
you
to
can't.
consider,
You
should have
sir
just
are
started
a
with that
liar.
especially as it
question.
relates to the comparison to Mr. Robinson.
You can't do anything
Mr.
quick or
McBride.
efficiently.
And she is also going to testify that the analysis she does is based on looking at the totality and all of the different markers that match and are consistent. And that's how she comes to the opinion that she does. The point is, there are explanations that are susceptible to different interpretations and arguments. Ultimately, we're going to have an expert hearing where all of the literature is going to be before the court, and the court's going to determine if it meets a threshold of reliability for admission at trial. But at this stage, even granting that there may be some argument that may come from defense counsel's position, the court can't weigh it. This does not go to the probable cause determination, and I don't think it's relevant. And this exhibit in particular is not relevant without the testimony of the witness And so the exhibit should not be admitted on its face either.
That's why I was trying to lay a foundation that she would, and offered a proof to the court that she would testify that in fact there are these sequence differences at the 5 or 6 locations, 6 different locations relevant to the comparison.
Bro, you had the time to lay the foundation of the Burj Khalifa. Like, well, like how much more foundation do you need, dude?
Comparison to Mr. Robinson. And when the state says the court cannot
He
weigh
hasn't
it, the
told
court
us the meaning
can
of
weigh
life yet.
reliability. The court has ruled that. So we're simply asking the court to take into account the limited nature of these comparisons and the fact that she cannot, based on the testing that she performed, and Robinson also testified that the FBI is in the process of implementing this kind of testing.
All right. Thank you to both sides. I'm going to allow the admission of this evidence, but I'm also going to set a limit of a limited number of questions. We are now at 4:40. This is on the cusp of whether it is applicable to the probable cause standard. I want to afford defense its full opportunity, but I still have to rein it in to keeping it to probable cause and not going into a full exploration, because that's not the purpose of a preliminary hearing. So I will admit Baker, you to.
I've been a second, so alleles displayed for the court so the court can see what we're talking about, and that's it.
All right.
I'm just going to have her document that in.
Which is, I need to cross-examine this witness. She's got to leave town today. I would like 20 minutes to cross-examine the witness.
All right. Well, I will go with the I accept Mr. Burt's representations the amount of time, and I'm going to talk less because that's consuming more time. And also nature on the screens
of efficiency, pull up the. I want take that one down. And is this exhibit the same chart with what are called the isoalleles indicated?
Yes, it is.
And isoalleles is a term used to refer to these alleles that have different sequence but the same length.
Correct, yes.
So across the top there for allele 17 and D3, there is a allele 17A, allele 17B, allele 17C, all with the same length, but different sequences for each of those 3.
Correct, yes.
And similarly at VWA, where you say that Mr. Robinson is an 1819 and 1819 in the evidence sample, there's an 18A, a 18B, a 19A, and a 19B.
Correct, yes.
And similarly for the other areas I've indicated there, I've accurately stated what the different sequence alleles are, correct?
Yes.
So I move this exhibit into evidence, Your Honor, and for publication.
Is this Baker 34?
Yes. 35. Baker 35.
Same objection, Your Honor.
All right. I'll admit it into evidence under the previous statement as it relates to Baker 34. It may be published.
And as you look at these 5 areas, you can't distinguish the evidence samples from Mr. Robinson based on the sequence differences, can you?
Correct. I only utilize length differences, STRs in this case. The FBI laboratory does not use sequencing for nuclear DNA testing, nor am I qualified in it.
Right. What is NGS?
NGS stands for Next Generation Sequencing.
And your laboratory is involved in validating next generation sequencing, correct?
We utilize next generation sequencing for mitochondrial DNA, which is a different subset of DNA testing, but not for nuclear DNA testing, which is what we're talking about today.
Right. But the people who market STR Mix also market a sequence platform, do they not?
I'm not aware if they do or do not.
Last question, take a look at.
Let me take 40 seconds to get to that next question or longer.
Well, I'll save that for redirect. Thank you.
Thank you.
This was a prosecution's witness, right?
That was the defense witness.
This was a defense witness?
Yeah. Or at least the defense called her to the stand and questioned her first,
I want to start by asking you
I believe.
what
Hard
your
to remember.
training and experience is. First of all,
Does the defense
do you have any
present an
education?
improbable cause?
Yes, I do. I have a
Yes, but usually it's after the prosecution presents all of their case.
Oh, I think it's because she's going out of town. So they had to go out of order.
Okay.
Bachelor's of Science in Biology from Salisbury University.
And do you, after your bachelor's in biology degree, what did you do for your career and in further education?
As program and was my biology time, I did produce a forensic definition is a formal recognition that our laboratory is following to those standards. Look at our standard operating procedures to ensure that we're following those standards.
And you mentioned your training. So what do you have to do as an examiner there, as a scientist there, for your lab to maintain its accreditation?
So for my training program, I had to complete a 2-year training program. During that time, I learned the science behind DNA testing, and I showed that I understood that science by completing oral board examinations and written examinations. I also then had to show that I could relay those scientific results to a jury by completing moot court exercises. And before becoming qualified, I then took something called a competency exam, or it's like a final examination to show that I'm qualified to perform my duties. During that accreditation or that audit process, my training records were reviewed to make sure that I had the proper coursework, the proper college degree, as well as completing successfully that training program.
And do you have to keep up with ongoing education to maintain your, do you have a certification?
I'm not certified. I'm qualified as an examiner.
To maintain your qualification, do you have to have ongoing education?
Yes, on a yearly basis, I have to complete at least 8 hours of continuing education.
Looks
And
like
this
it's
can be
just you and
done
me,
by
Gail.
attending conferences or lectures or reading scientific literature.
Do you also have to undergo proficiency testing?
Yes, and a proficiency test is a test that we receive from an outside vendor. I process that test like I would any other case and submit that those answers to determine if I'm satisfactory or unsatisfactory. This tests not only me to see if I'm still proficient in my qualifications, but it also tests the laboratory process to ensure that we're getting accurate and reliable results.
Now, as you discussed your work in this case, you talked about your work needing to be reviewed by another analyst.
Correct, yes.
And is that true in every single case?
Yes, in every one of our cases, they have to undergo a technical review in addition to an administrative review.
And it sounds like during those technical reviews and administrative reviews, there's discussions between you and other analysts. Is that accurate?
Yes.
And is that an opportunity for training and learning as well?
Yes, absolutely.
And I assume that training and learning goes both directions, that you're learning and you're also helping others understand your thought process, which may train them as well. Is that accurate?
That's true, yes.
The tools you use, are the tools you use validated?
Yes, they are.
And what does that mean to have a tool that you use validated?
So a validation is a thorough testing of a process or procedure. So before we subject any evidence to testing, we ensure that those process and procedures, something called standard operating by-step instructions on how to do our process and procedures. And then both myself as an examiner, as well as the biologists, were all trained to those standard operating procedures and tested to those standard operating procedures during proficiency tests.
Now, you've talked about, I think, a couple of the tools you use. One you call Star Mix, is that right?
Correct, yes.
And is that tool validated?
Yes, it's validated both developmentally and internally Developmentally it's validated by the creators of the software. And then we, the FBI laboratory, also tested StarMix to ensure that we could use it within our laboratory and produce accurate and reliable results.
Now, when you say it was developmentally validated, is that in a peer-reviewed study?
Yes, it is.
And is StarMix used? How widely is StarMix used throughout the world?
StarMix is used in approximately 120 laboratories, both domestically and internationally.
Which is the DOJ about an Exhibit 8.4, Baker 8.4, which is the DOJ Ultra, which is the Uniform Language. What does that stand for?
Uniform language for reporting and testimony, I believe.
Okay. It talks about language that you should use and language that you shouldn't use as an examiner and a scientist, correct?
That is correct, yes.
Now, I want to ask you a little bit about what you do when you have a conclusion, like you did in Exhibit 31. Do you know? Let's see. Limits the adjectives you can use to describe the evidence and the conclusions that you reach. Is that accurate?
Yes, it is.
And the thinking behind that is to decide how they want to describe that number. Is that accurate?
Yes, it is.
Pushing that. Put it on the screen. And Kimberly, if you could scroll to page 3. Thank you. So item 7 sub 1 is the swabbing from the towel from the rifle. We have the number in written form in the second paragraph beneath the heading. And then beneath that, you have a table, correct?
That is correct, yes.
And the likelihood ratio gives the number, right? That's the likelihood ratio. And that's stated in sentence form in the paragraph preceding the table, correct?
Correct, yes.
The only language you can use to describe what that number means from the DOJ directive is very strong support for inclusion, correct?
Correct, yes.
And the sentence there that says the DNA results from item 7.1 are 1.7 octillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors. The reader can assign whatever value they want to that, correct?
What do you mean?
Meaning adjective to describe what that means.
Sure, yes.
The adjective you can use is very strong support.
For inclusion, yes.
Okay, for inclusion. All right, if we go to 8.1, if you'll, Kimberly, if you can scroll down just to make that a little bit easier to view. Same question there. The results are from 8.1 are 30 quintillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors. The adjective you're allowed to use is very strong support for inclusion again, correct?
Yes.
Okay, we can take that exhibit down. Thank you. You were asked about formal activity level, and you described this as the lab cannot testify about, or you cannot testify about what action left the DNA on the object. Is that right?
That is correct, yes.
Does that mean that an individual did or did not touch? Well, let me ask you this. How can DNA get onto an object?
DNA can get on an object via direct contact, so an individual touching an object. It can also end up on an item via body fluids such as blood, or through transfer. So if I were to touch an object and then that object is given to someone else, my DNA could potentially be on that other individual through the transfer of DNA.
And your lab can't, or you cannot testify as to what precise action left the DNA on the object, correct?
Correct, I cannot.
Okay. Same question about time. You can't testify about the exact time that DNA was left on an object, right?
Correct.
But there are some indicators that may give some information about how long and the conditions under which DNA was placed on an item, like degradation.
Yes, degradation or the condition of the, I would expect with the water
We're
rushing
gonna
over
do.
that item, I may or may not be able to detect DNA. Also, if there's an item of evidence that is exposed to the elements, something that's been left behind 10 years ago, I don't necessarily expect to recover DNA, but something that may have been left yesterday, I might be able to detect DNA.
An item that has been left in the dirt or has been rubbed in the dirt, could that affect your ability to recover DNA?
It could, yes.
Could it also affect degradation?
Yes.
Can UV rays affect degradation?
Yes, it can.
Does degradation keep you from doing your work?
No, it does not.
Is degradation normal?
Yes, it is.
Does all DNA degrade?
It does, yes.
I imagine if it's kept in a pristine environment, it would degrade less than if it's kept in, or if it's found in a less or out in the open. Is that accurate?
Yes.
Okay. You said with regard to the screwdriver, there was some degradation. Did that affect your ability to reach conclusions in this case?
No, it did not.
You said on item 7, the towel or the swab from the towel, there was slight degradation, not as much as exhibit 8. Is that accurate?
Yes.
Did that degradation affect your ability to reach a conclusion here?
No, it did not.
Hey, Gary.
Yeah.
Wondering if maybe you want some commentary and then you could speed through this after.
Sure. Go ahead.
Yeah, so I'm wondering if she was called by the defense, but she does seem to be somebody working in the crime lab.
Yeah.
So they probably, otherwise they would have just got the conclusions in the report. And the defense wanted to call her so they can cross-examine her about the conclusions and the
Sure.
methodology and all that. And apparently she was called out of order because she's scheduled to leave town. Is that?
Yes, that's correct.
That's what's going on. Okay.
Yeah. Yeah, I mean, it seems like the defense called her so that they could attempt to impeach her results. I mean, I think that's the entire strategy here.
But I mean, the strategy is still kind of perplexing because they're not going to convince the judge, even if everything they say somehow concludes that the DNA conclusions should be thrown out. It's not going to change the judge's opinion about probable cause. So,
well, let me ask you this: do you think this is strictly for the public?
I mean, I guess you could kind of take the view that it's it doesn't hurt the defense to try everything, right?
Sure.
But it's kind of a snowball's chance in hell that even if every single thing that they want to get across is accepted by the judge, is going to be enough to overcome the probable cause. So,
sure.
I mean, respect. I always sympathize with the defense, so I respect them pulling out all the stops. But, yeah, it's not going to.
That's like, I'm not a lawyer, but this seems to me like they're talking to the public. They're taking advantage of the fact that there is a public out there that wants to believe that that Tyler Robinson is innocent, and hopefully, maybe even again, they're trying to, prejudice the jury pool and saying, hey, right off the bat, I don't believe that this DNA evidence is all that credible. So that's what it seems like to me, just as a layman looking into this.
All right.
You're asked about the PCAST report. You testified that gave.
Recall the year.
Do you know if it's been within the last 5 years?
No, it is not.
Meaning it's older than that?
Yes.
Do you know if it's been the last 10 years?
I think it was 2016, but I'm not entirely sure. I would say within the last 10 years.
Let me ask you this. Has the science in your area, can I refer to it as probabilistic genotyping?
Probabilistic genotyping is the math in my area. Yes.
The science in your area and in your field, has it developed over the last 10 years?
Yes, it has.
And have there been studies that have made suggestions which have been implemented in the field?
Yes.
You testified about exhibit 7 and 8, that they both had mixtures. Excuse me. Yes, items 7 and 8. In your testing of these items, that they both had mixtures. And you stated, I want to make sure I understood this. You stated, I believe, that the minor contributor was less than 20%, and that it was actually 5%. The ratio was 5% to 95%.
For one of the samples, yes.
You remember that?
Yes.
Does that mean the 5% was from twigs, and the 95%, that 95% is assumed from the defendant, the Robinson?
When I calculate the statistic, Twiggs' DNA profile aligned with the 5% contributor, and Mr. Robinson's DNA profile aligned better with the 95% contributor.
Okay. Same question with regard to 8. I think you said the ratio was 11% from the minor and 89% from the major. Is that Twiggs being the 11% and Robinson being the 89%?
Yes, Twiggs better aligned with that 11% contributor, and Mr. Robinson better aligned with that 79% contributor.
You're asked about Baker 4, an exhibit that was titled Baker 4 365. Do you remember this exhibit by chance? I don't have a copy of it, so well. Do you have Baker 4 365? Put that up.
I just saw a post earlier by Evan Kilgore, who for whatever reason is still a simp of Candace Owens, and he had this completely reversed. He said the exact opposite. He said that it was Twiggs on one of those samples that was 95% Twiggs, 5% Robinson, and 11% Robinson and 79% Twiggs on the one that she's now. So she's corrected that record. I can't wait. Everybody go out there. If you're on X right now, please go hit them with the community notes. Yeah, they're wrong. They're wrong.
And item 7 is the towel, right?
Yes.
Item 8 is the screwdriver.
Correct, yes.
Thank you. You know,
You know what? I hate to do this, but I'm gonna do it. I want to make sure I know which sample they're talking about.
2015.
so 11 labs accreditation. What is
Very national accreditation education background outside body will come the science behind the process.
to maintain your qualification? Do you have to have
And
a we discussed your work in this case. You talked about your work needing to, and it sounds like during those technical reviews for
work within our laboratory.
that tool validated.
Yes, it's
And
mixes
Baker 8.4, which is the DOJ Ultra, which is the uniform language. What does that stand for?
uniform language for reporting and
Kids you can use to is now. They want to describe. And let's see. The directive from the Department of Justice to do an examiner and a scientist. It talks about examination. You were asked about an exhibit 8.4, Baker 8.4, which is the DOJ Ultra, which is the uniform language. What does that stand for? It talks about language that you should about. We can. We about
back too far.
How can DNA get onto an object?
an item of evidence.
Does degradation keep item 7?
Here we go.
Did that affect your ability to reach conclusions in this case?
No, it did not.
You said on item 7, the towel or the swab from the towel, there was slight degradation, not as much as exhibit 8. Is that accurate?
Yes.
Did that degradation affect your ability to reach conclusion here?
No, it did not.
You're asked about a PCAST report. The science in your area.
Math in my area.
Ways that have made suggestions which have been implemented. You testified about exhibit 7 and 8, that they both had mixtures. Excuse me. Yes, items 7 and 8. In your testing of these items, that they both had mixtures. And you stated, I want to make sure I understood this. You stated, I believe, that the minor contributor was less than 20%, and that it was actually 5%. The ratio was 5% to 95%.
For one of the samples, yes.
Do you remember that?
Yes.
Does that mean the 5% was from Twiggs, and the 95%, that 95% is assumed from the defendant, the Robinson?
When I calculate the statistic, the 95% contributor.
Okay.
Which
Same
one
question with
Twiggs?
regard to 8. I think you said the ratio was 11% from the
so
minor and
7
89% from the major.
Got
Is
it.
that Twiggs being the 11% and Robinson being
All right.
89%?
So I got it now. All right. So the towel number 7, item number 7 was 5% Twiggs, 95% Robinson. The screwdriver, item number 8, was 11% Twiggs, 79% Robinson.
Yes, Twigs better aligned with that 11% contributor, and Mr. Robinson better aligned with that 79% contributor.
Forfeit. You know, it's 5 o'clock. I'm going to wrap up. We can go ahead and take that down. I'm sorry.
Yes, I did.
Thank you.
Statement in the
Oh,
Oh, no.
oh,
you referred on cross-examination to your training and experience, right?
Yes.
Do you agree with the statement in the PCAST report? Experience or judgment cannot be used to establish the scientific validity and reliability of a metrological method, such as a forensic feature comparison method. Moreover, a forensic examiner's experience from extensive casework is not informative because the right answers are not typically known in casework, and thus examiners cannot accurately know how often they erroneously declare matches and cannot readily hone their accuracy by learning from their mistakes in the course of casework. Do you agree with that statement?
I don't. I think experience, they're right in the fact that we never know the true answer. However, my experience means that I've seen a lot of different DNA. I've seen a lot of validation data. So that does help me come to a conclusion.
Do you agree with this statement? By that same report, good professional practices, such as the existence of professional societies, certification programs, accreditation programs, peer-reviewed articles, standardized protocols, proficiency testing, and the code of ethics cannot substitute for actual evidence of scientific validity and reliability.
I don't think I agree with that either. The science has been heavily validated and tested to show that's reliable. Following protocols that are based on validation, again, shows that my results are accurate and reliable, as well as being proficiency tested.
By the way, you said that that report was not authored by experts, but the head of that group was Eric Lander, who is one of the foremost experts in the area of forensic biology, is he not?
That name does not ring a bell. I don't know who that individual is.
You don't know who Eric Lander is?
No, I do not.
Okay. When did you go to school? What years?
2003 to 2007.
You said that STR mix was widely used and then it's been validated. The PCAST report said the problem is it's been validated by the people selling the product, right?
Developmental validation, yes. Internal validation, no. A laboratory that's going to utilize STAR mix has to validate within their own laboratory.
And the PCAST report said that we need validation data, not by the people selling the product, but by independent scientists in order to make this reliable, right?
They do, and that's exactly what happened. There was 31 laboratories that came together in response to the PCAST report and gave their validation data on how they internally validated STAR mix.
And then after that information came forward, the PCAST committee reviewed it, and they said PCAST was unpersuaded by those studies. While likelihood ratios are a mathematically sound concept, their application requires making a set of assumptions about DNA profiles that require empirical testing. Errors in the assumptions can lead to errors in the results. To establish validity with a range of parameters, it is thus important to undertake empirical testing with a variety of samples in the relevant range. And they specifically address the studies you're referring to, did they not?
I believe we did, yes.
The defense.
And then lastly, you said that STR mix is widely used, but as I understand your testimony, you didn't use it and rely upon it for your conclusion about twigs, right? The software told you there was no support there for including them, and you ignored it and decided otherwise, correct?
I did not ignore it. Again, given the type of sample, it was an elimination sample. I compared that individual to the DNA profile that I developed and determined that I could conclude that I could utilize him as an elimination sample.
You said your laboratory was accredited, correct?
Yes.
But you're aware that in 2004, the Inspector General did a comprehensive audit of your laboratory and published a report called the FBI DNA Laboratory Report, a review of protocol and practice vulnerabilities, which found a number of errors in the way that your lab does testing, correct?
Objection. The 2004 study is hardly relevant to this proceeding 22 years later.
It's relevant because he's relying on accreditation to somehow say that these results are valid. This lab was accredited when this study was done.
I'll allow this single question. She may respond. So I'm overruling the objection, and then we'll continue to move forward.
You're aware of that study, right?
No, I'm not.
Okay, thank you. That's all I have.
All right. Anything further for this witness?
Yes, I think there's one follow-up that needs to be asked. You were asked that, or you testified that you never know the true answer with field work, correct?
Correct, yes.
And that's compared to ground truth studies where you do know the true answer and you can compare the conclusions that analysts draw with the true answer, the ground truth answer that is the basis of the study. Is that right?
Yes, and that is what our validation is.
Your validation actually studies is a ground truth test in essence.
Yes.
Okay, thank you.
Anything further for this witness?
Thank you.
May this witness be excused.
Yes.
Thank you, Ms. Baker. You may step down.
Thank you.
All right. Well, does either party need the benefit of the record before we go into recess?
No, Judge.
All right. Having both parties said no, we'll go ahead and be adjourned until tomorrow at 1 p.m. We do not have morning court for this proceeding, and we'll start up at 1 p.m. in the afternoon. Court is in recess.
All right. Wow. Wow.
I think you have an announcement to make.
Apparently I do. I had to hand my phone off to my wife so that she could talk with Jen. Apparently we're going on Jeremy Boring tomorrow. So that's awesome. Look forward to that. I don't like announcing anything until it happens. You know, you just never know. I mean, but no, number one, the big thing here is Jen, thank you. Jen's been so awesome with everything that we do here. She's taken our podcast to the next level. And she did mention something earlier that is extremely frustrating, right? And that is we are extremely, extremely shadow banned. And it doesn't help that we have, which is intentional, and we know what it does. We constantly have all these trolls that come in and downvote our videos and everything else. So, you know, when we have great guests on and we have 285,000 followers, we have great guests on like Gad Sad, and we get 3,000 freaking views. Are you kidding me? It does get a little bit frustrating. So, you know, we're continuing to, you know, push back against that, do everything we can, and just try not to get so frustrated to the point to where it's like we throw in the towel. You're not going to make us quit. But I will tell you, like, you know, and I don't even like talking about these things, right? But like revenues are down to the point where it's like, does this even make sense? Because we're losing our asses on this. So, you know, it's not just about me. There's a lot of other people that are experiencing the same thing. And this is not a popular or profitable topic, but it's one of the most important. So for those of you that do support us, that share our content, that support us monetarily and financially, we really appreciate that as well. So, but also Jen has been great in getting on great guests and changing things up. And, you know, but anyways, we're looking forward to talking to Jeremy Boring tomorrow for sure. What I want to do real quick, just so that we don't leave anyone behind, is run through our super chats real fast, and then we'll see where we're at. I'm not smart enough to interpret what's happening. Can anybody tell me if there's anything of significance right now? So basically what it just took place there is that there's like 1 in a quintillion chance that it's not Tyler Robinson. And then what we did after it was all said and done, what the prosecution was able to pull out is there was a mix of DNA on the towel. 5% of it was Lance Twiggs. 95% of it was Tyler Robinson. On the screwdriver, there was 11% Lance Twiggs, 79% Robinson. So I think that is pretty clear and concise. I think that's the most important development out of the last 5 hours, essentially. Anything beyond what we saw regarding the video footage, which I think was the other big element and big development. Do you guys remember anything else other than that?
I'll just say, you know, from the defense's point of view, they were trying to attack the methodology that arrived at that conclusion that it was Tyler Robinson's DNA. That's where they were going with it. So, you know, that's their angle. I couldn't gather if there's still some DNA that's like left to be tested, you know, to be retested and reconfirmed. A lot of it was just so in the weeds that.
Well, I think it's reasonable to conclude there's probably still DNA on. So what they were saying, and you correct me if I'm wrong, or anyone else correct me if I'm wrong. Basically, we take this cotton swab of, for instance, on the rifle or on the towel, and then that swab gets used up. All that DNA on that swab. There's nothing to say that they couldn't go back and collect additional DNA off the firearm or the towel. Does anyone disagree with it? Am I getting that wrong? So,
I know DNA degrades over time, but I don't think it degrades that much over this period. Yeah.
She
No,
said
they go back.
decades.
Yeah. They go test now that DNA is even a thing. DNA testing, they go back and test cases from long ago.
And I'm assuming that these items are fairly properly stored. They're not being exposed to UV rays and things like that. So, you know, there's that whole thing.
So even if they were correct in saying that there's some methodological issues with the DNA testing, it wouldn't be, you know, mean anything more than like, okay, let's do it again. You know, it would be obviously very easy to get a sample from Tyler and Lance to compare it to.
Sure.
And Gary, thank you so much for having me on again. You're a big podcaster. I'm small creator, and it's very gracious of you. I very much appreciate it.
No, man, we appreciate your professional analysis and the expertise that you're able to bring to the table. We really appreciate that. So it's great having you on, Gil. Thank you. And I love that. I love, I'm not that big of a podcaster or a YouTuber or anything else. But whatever I can do to promote other people that are coming up, I think is just really important. And quite frankly, I get a lot more out of it. I've had some really big names on our show, and I'll tell you, I get more out of having SK and Patriot Dad and all these other people that should be famous. These people should be famous because they put a lot of work in what they do. They have great analysis. They have a lot of common sense. They're entertaining. They're fun. And they should be famous. And all these people that are freaking whack jobs that shouldn't be famous, somehow they are. It blows my mind. They have no business. Nobody should listen to any of these freaking clowns.
It's like a train wreck, I think.
Really
People just get sucked in. They can't look away. Oh,
Make sure
look,
you
he's
guys-
got his thing. Put it
Yep.
up.
Make sure you guys go. Those don't work. But
Those don't work. Okay.
Go-
Check me out. Whole Truth one
Whole
too. I
Truth.
appreciate it.
There you go. Whole Truth on YouTube. Whole Truth on YouTube.
Thank you.
How the defense lawyer speaks is no surprise the defense needed so many more months to prep for the trial. Like they got an uphill battle for sure. Candy just posted she'll be proven right. She says Lance Twiggs will be deemed a federal asset who helped set up Tyler Robinson, and no gun was ever fired from the lawsuit, and that Charlie's mic exploded. She's psychotic. I agree with that. I don't know if you're a licensed practitioner in the realm of mental health, but I agree with that analysis. And if you're not, you should be. Candy now calling people stupid who think TR had a rifle inside his pant leg. It's very clear she's going to refute everything to keep the grift going. Her income depends on it. Of course she's going to. Gary, again, thank you for doing this for your subscribers and others interested in hearing the down and dirty part of the preliminary hearing. Yeah, you're welcome. I was going to have to listen to it. I wanted to make sure, and I'm just using you people for moral support. Not really, but you know what I mean. You guys are contributing to me as much as I am to you, so thank you guys. Gary Melton with Jeremy Boring, two guys Candace hates. This will be epic crash out. I wonder if we could schedule getting Ben Shapiro on as well. That would be like...
Are you going to him, to Jeremy's place?
Yes, apparently. I don't even know what's happening. All this stuff, like freaking Jen called me and then she texted me and I was like, okay, well, there's some travel that needs to be done. And I was like, all right. I ran my phone up to my wife. I'm like, take care of this. I don't know what's happening. I'm going to go get the debrief as soon as we get off there, but it sounds like it's a done deal. So that'll be great. And
Yeah, Gary, you're flying out in the morning. You will be on with Jeremy and Will Chamberlain at 4 p.m. Central. And then I think you guys are going out for Mexican food.
Oh, that's awesome. I love some Mexican food.
Well, pass along my regards. I'm fans of both of those guys, and especially Jeremy. He's awesome.
We'll do. No, I'll definitely do that. Yeah. Gary's been going against the Giants from the beginning. Folks, I knew what was going to happen when I was going up against Candace. My little channel against 6 million and one of the most influential figures in this country. It's no joke, And so I was still taken aback about the personal attacks and some of the doxing. I shouldn't have been, I guess, in retrospect, but maybe I was a little naive. But I did expect a huge loss when it came to subscribers. That didn't happen, but here we are 8 months later. My channel hasn't grown. So I'm losing and I'm gaining at the same time. I need to gain at a higher rate. But you know what? I have the right viewers. That's what matters to me. It really does. Gary is the YouTube Davey, just wanted to be a shepherd and he ended up swinging his slingshots at Giants. It's just the right thing to do. And I knew it was going to suck. Keep it up. I was here almost the whole time. Thank you, Colton. We appreciate you, buddy. Became a YouTube member. Thank you. We appreciate all you guys. Matt Tardeo is also shadow banned. I hate that YouTube goes after the truth tellers. They do. And why do you think they're promoting Candace and all these other retards? It's because look, YouTube, Google, they're an extension of the CCP. Make don't be confused about this. Make no mistake about that at all. I really do believe they are betting on the eventual transfer of power from the United States to China, and they're globalist, they're communist at heart, they're activists, they hate this country. They don't know what they're getting into, because these people are so naive, and they think they would love if the CCP ran the world and communism was a thing and it would help so many people and we'd no longer be poor and people wouldn't be sick and all the dumb shit that goes along with communism, socialism, and globalism. But that's what they're pushing for. And so when there is a narrative that can be pushed that can damage the Trump administration especially, they're going to push that. And of course, they're going to suppress opposition. It's just the way it works. And if you believe anything else, I'm sorry, you're naive. I can't wait to see Candace crash out of Gary and Jeremy.
The obscure podcaster.
The obscure podcaster on another obscure podcaster's
Right.
podcast. Gary, I started watching you because you only care about the truth. It's really cool to see a good guy win now and again. Rock on, brother. Thank you, Sean. We appreciate you. Wild and Wired Media. Congratulations, Gary. You have worked so hard, you and your team. Thank you. Thank you. And I got to give a lot of credit to two people. Number one, Jen. She's been working these deals. She's over there. Like I have a hard time. I don't really have a hard time reaching out to people. I've never asked to be on anyone's show. Like, hey, can I come be on your show? Jen's out there. She's like my biggest advocate. And of course, my wife that makes this possible, that supports me, even when she's like, what are you doing, dude? Like this doesn't make any sense. And but she continues to support me even when she disagrees with me. And isn't that what you want? And she doesn't disagree with me about any of this substantively. It's like, does this make sense? But man, I have felt down to my soul, this is what I'm supposed to be doing. And I've just felt convicted to do it. And I'm telling you, there's been times where it's like, dude, just back off. And I can't do it. And I don't think it's what I'm supposed to do.
When did you get started again with the podcasts or the videos?
Oh, I mean, I started around COVID, just doing gun stuff. I didn't really dip my toe into any of the like current events really until like Butler. But before that, I was doing like a Wednesday. Everything was like pre-recorded gun stuff, right? And gun reviews and gear reviews and things like that, and training. But then I've always pushed, and I think it's always important to talk about conservative politics and the Second Amendment and all the things that I believe. So I started doing, a Wednesday night live stream. There'd be like 30, 40 people on that thing half the time. And I was thankful for that. And I'm thankful for, like, that's the other thing too, is like when you start getting down, like, man, we should have 30,000 concurrent viewers right now. You can sit there and concentrate on that. Or you can be like, you know what? We've had 5,000 plus viewers on this between a couple different platforms, and that's something that most people don't get. So be thankful for that. And I think that's the point. But
I can tell you what I think I first found you. I think I mentioned this already, but maybe you came up here and there before, but the trip to UVU, that's how I first came across you. And I really like the on hands investigation and debunking.
Yeah.
So yeah, keep up with that work too. It was really useful, because if it wasn't for that, to this day, I would still be like, how did he get up there? How did Tyler Robbins? To this day, I would still be wondering. You're the only person that's like went there and showed it.
Yeah, like the fact that really is to me almost like the litmus test in all of this. The fact that Candace Owens has never showed her viewers ever how easy it is to get on that roof tells you everything you need to know about her motives and her honesty.
Never even bothered looking into it. Yeah.
Yeah.
Can we get a whole bunch of thank you Summers in the chat, because I think she deserves a round of applause.
She definitely does. All right, guys, you can literally forego a cheeseburger once a month to support a great creator like Gary. Please become a member. It's 100% worth it. Thank you very much. And I would say the same thing about Continued Freedom. He's amazing as well. Jared's awesome over there. We've had him on the channel multiple times. I would have him on the channel anytime. He's another person that deserves to be famous. He's a good Christian, honest person that has great analysis, and the fact that he doesn't have millions of subscribers is a shame. I'm actually proud that my first activity on X is calling Candace insane. There you go.
Gary, I
X
got to get
account
back
is
to the
insane.
I got to
Hey.
get back to the family. Thank you both so much.
Thank you, Gil.
and talk soon. Thank you.
Yep, thank you. Talk
See
to
you
you later.
later, Gil.
Bye.
Our X
Bye,
account
SK.
is crazy right now. Bye.
Thank you for all you do. Been here since the beginning, Garrett. You are the GOAT. Thank you, Little Miss Maybe. We appreciate you. CJ Correnti, been supporting the channel. He's put, at this point, probably tens of thousands of dollars into this channel and contributed not to just me, but the stuff that we put out, like the 3D model and everything else. CJ's the man. We appreciate you. And you know what? He goes around and he could, whether it's Bronson and a whole bunch of other people out there, I know he's supporting them as well. I see him in their chat taking care of them as well. So what a great guy Correnti is. Gary, will you consider running recruitment ads for USMC or US Army, etc., the Navy paid ads? I would run ads on the channel for that. I would love to do that. That's like one of the first. I never thought about that. And I'm look, people contact us and have been wanting us to. They've been wanting to sponsor our channel and us to promote stuff, and I just don't like it. I like everything. Like I need to research a product. There's a few that I would, especially anything that we sell in our store, but then we get into some issues where it comes to firearms or firearms accessories or anything like that. It's another way that you can support us. I'm not even allowed to advertise, but our real website sounds a lot like this channel and .com. Buy gear from it. That's what makes this possible. So because we're not making money, and it's just the way it is. And so there's that. Yeah, I would love to do that, Lynn. So if there's the you put me in touch with somebody that can facilitate that, I would love to support our military and to run recruitment ads. That would be great. Gary, honestly, I did not know you until I wanted someone that spoke facts about this whole crime. Candace has really effed up a large portion of very naive followers. I agree. SK, I'm going to give you the last word. We got to get off here. I got a message earlier from Andrew Wilson saying that he may have to reschedule based on how long this whole thing was going. I don't know if that's true or not, but I need to get off here pretty quick and figure that out. So just know that might be happening, that we probably are going to reschedule our 8 o'clock with Andrew. It is what it is. So SK, leave the viewers with some wisdom, some positivity, some encouragement. Let's go.
That's a lot of pressure, Gary. I just want to say thank you for everything you're doing and for doing the dirty work, like sitting here and streaming these really boring, preliminary hearings so that everybody can hear the truth and understand what's actually taking place in the courtroom. Because if you go to Candace's X account right now and you look at her followers and what she's saying, it's completely disconnected from reality. And I think this is important for people to see. This is the reality, and these people are completely ignoring reality.
Yeah.
Also, you
Go
should come check out Patriot Source Podcast.
Yes. Make sure you guys go follow Patriot Source Podcast. That is your YouTube channel too, right?
I think it's Patriot Source Network, maybe. Actually, I don't know.
Okay. Yeah, go follow them. Just look up Patriot Source. I'll make sure that the link is down in the description below. So there's that. I don't know what Bronson's saying. Oh, I believe you. Probably about not making money. So
Yeah, same.
We're not making money.
I haven't made anything. But also, thank you for having me. I appreciate it.
Let me rephrase this so we're completely accurate. Look, we are averaging around 250,000 views per month right now. And at one time, the most we've ever gotten was over 10 million views. We were averaging well over 1 million views. And that's like, for me to make sense to do this instead of doing what I normally do full time to make money, we need to be at 3 million views a month. We're at 250,000. So I'm losing. That's just 3 million is about where I need to be to break even, to replace my income from what we do. I've been blessed. What we do, we sell a lot of gear, we do a lot of things, and I love doing that. Right now, this is just more important. And even if we lose money, but that's where we're at. And so just give you, I'm not saying that we're not making any money, but we're at a loss compared to what, my normal income would be and really what it takes to support everything that we do here. Anyways, I don't even like talking about this stuff. I sound like I feel like it's whining, and it is. To some extent.
It's
But people need to know.
I think, yeah, people need to know, and people need to understand that we put in a lot of work into this. I mean, constantly researching, always being involved, even when you're not on camera or posting on X, you're doing something related to this, even if it's when you're sitting watching TV. You're always doing something, you're always thinking about something. It takes a lot of work
Yeah,
to
it
find
does.
the truth and bring the truth to people. You have to really want to do this, because if you're doing it for the money, it's not worth it. It is not worth it.
Yeah. And, you guys, and again, I love the super chats and all those things. You guys know YouTube takes 30% of that. 30%. And that's before your taxes. That's before your income taxes. So that's YouTube for you. All right. Listen, we love you guys. Thank you. I'm looking forward to going to talk with Jeremy Boring. I'm looking forward to that quite a bit, actually. And it's because of you that it's made it possible by sharing their content, making them aware that we even exist. So we appreciate that. I appreciate Jen's hard work behind this. I appreciate all the love and support I get from my wife on a daily basis. She's the real saint. She is a saint. But we appreciate you guys. So please share our content. We love you guys. Thank you for doing everything that you do. Thank you for being in the fight. We are in the fight for the truth, and we are in a fight for our country. That is 100% true. So until next time. Oh, and thank you, CJ Correnti, for an additional gifting 10 Paramount Tactical memberships. But until next time, stay armed, stay ready. We'll talk to you soon.